Lordship's kind permission. It's a matter wherein we're challenging the KAT's order, KSAT's order, wherein they've only issued notice. Today is the selection process, and they're conducting the counseling today. This is with respect
Tomorrow.
to Your Lordship. Is it?
Yes.
Might I request end of the list since counseling is today, Your Lordship? Today they're
It's today.
finalizing the list, please.
But in pending matter, to take up the matter same
No,
day,
not pending, Your Lordship.
Huh?
This is a
New
fresh matter,
matter.
fresh matter.
counseling it today. When did you file it?
Your Lordship, we filed it just on the day before Diwali, 30th. 29th order was passed, 30th we moved, Your Lordships, but there was 4 days vacation.
125 years.
Obliged.
Huh? Take it one. Mic it one. Put it, yield it.
Spots-
Mic to him.
Spot style has been fixed, my lord, on 11th.
ಯಾವ matter?
Yeah, RFA matter.
RFA. Good.
6th May post.
The my lord,
Option 11th ಇದೆಯಾ? Good, good.
As I mentioned on matter. As matter pertains to my lord's direct recruitment.
Mic and
Direct recruitment to the post of principal. Now, my lords, my IA for stay is pending. My lords, I'm told this week, my lords, the select list will be announced. Lordship may have
ಅನೌನ್ಸ್
them.
ಮಾಡೋದಕ್ಕೆ ಅದೊಂದು ಕಾಪಿ ಹಾಕಿ ಮೆಮೊ ಹಾಕಿ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ.
Lords, the urgency.
my lords, the order, my lords, under challenge, my lords, was passed by the arbitration tribunal, my lords. Tomorrow is the matter, my lords, scheduled for arguments, my lords.
Arguments.
Please, my lords,
Arguments ಅಲ್ಲಿ ತೊಗೊಳ್ಳಿ. ಸುಮಾರು ತೊಗೊಳ್ಳಿ.
please, my lords.
My lord, petitioner is constable, suspended, KT is dismissed application, my lord. Filed,
Suspension ಯಾವಾಗ ಆಗಿತ್ತು?
January, my lord. petition.
ಜನವರಿ.
Yes, my lord.
ತೊಗೊಳ್ಳಿ. ಇನ್ ಜನವರಿ ಒಳಗೆ ಪೋಸ್ಟ್ ಮಾಡಿ.
Lords, request for any date this week. my lords.
Brother, I said, you produce copy of the draft list.
Please.
So, post ಮಾಡಿಸಿ ಮಾಡು.
Lords, one submission. Lords, in serial number 26, I'm for the petitioner,
6.
railways, my lords. So I'm seeking short accommodation, my lords. I have informed the other side as well.
That's it, inform ಮಾಡಿರಾ?
Inform ಮಾಡಿದೀವಿ, Swami.
All right. Week after next, at the request of. First off,
Petitioner.
the petitioner submits that other side is already informed. Okay.
Grateful.
Yes.
Filing this respondent, my lord.
One.
Filing this memo, your honor.
ಏನದು?
Seeking for time, senior is not well, 3 weeks time, I request.
Memo ಏನ್ ಬೇಡ, ನಾವು ಹಾಗೆ ಕೊಡ್ತೇವೆ ನಿಮಗೆ.
Adverse.
Sir.
And copy of the contempt petition is not
ಕೊಡಿ.
produced.
Sir, the client, the accused or the respondent does not reside in this address, my lordship.
ಈಗ ಕೊಡಿ, petition ಕೊಡಿ.
And this has already been served to them, my
One more
lord.
copy ಕೊಡಿ.
And this is a new advocate who is representing.
One more copy of the petition has to be furnished by the complainant
Yes.
on the counsel representing the respondent
Respondent.
accused within 3 days. And file acknowledgement within 4 days in the registry, failing which contempt proceedings stand dropped. Next.
Lordship,
If compliance is done, post this matter after 4 weeks. The other one date ಕೊಡಿ.
lordship, this is pretty
It is
delayed.
not well. It is not-
Lordship, just now he told me that he's not got the petition and somebody has been getting that copy.
Next.
Mohanarangam is the one who represented him, lordship,
what
and
I
he's
put-
not on Vakalat.
10th of this, 9th of this. Next.
My lord,
Yes.
my lord, in two, by mistake, my lord, only one copy of the early hearing application was,
All right. Which date you want? Early ಎಲ್ಲ
Lord,
ಎರಡೆರಡು application ಬೇಕಾಗದೆ.
ಅಲ್ಲ, ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ,
Which date you want?
any day, my lord. In fact, in before your lordships, my lord, it's come up so many times, my lord.
Vijay.
Yes, on 4/6, 18/6, from 2016, it has been ordered to be listed for early hearing. And it has come up in 20,
You argue this matter.
any day, my lord. He has to argue.
Call
lord.
this matter tomorrow.
Very well. Obliged.
ನನಗೆ NOC ಬಂದು ಹಾಕಿದ್ದೀನಿ ಸ್ವಲ್ಪ at least 2 weeks time.
My lord,
2 weeks.
2
1
weeks.
week. Next week ಮಾಡಿ.
ಹ್ಮ್.
Next week.
ನಾನು ಹೊಸದಾಗಿ ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ ಆನ್ ರೆಕಾರ್ಡ್ ಇದಕ್ಕೆ.
my lord, this is a,
2 weeks time ಖಂಡಿತ.
my lord, one side, two people, my vendor did not have title, he has sold it to him, my lord.
But generally he will not seek time.
Please.
All right. ಒಂದು ಯಾವ್ದಾದ್ರು ಒಂದು date ಕೊಡಿ. Application
Much obliged.
for early hearing allowed.
Please.
Post on so and so. This date is fixed consensually. Okay.
19th, my lord.
19th.
Very good. 18th, huh?
19th. 18th you want.
ಅಲ್ಲ 18th ರಜಾ ಇದೆ, 19th.
Respondent.
Yes, brother. 9/2/22 acceptance of service of notice. Accept ಮಾಡ್ಬೇಕಾ?
Please, Miller.
Notice, service of notice on ನೋಡ್ಕೊಳಮ್ಮ. Respondent so and so and so.
Respondent number 2, M. Ramappa
Notke.
Reddy. Respondent number 5, Muni Venkatappa. Respondent number 6, Dodraju, alias C. Rajanna. Respondent number 8, Muniswamappa. Respondent number 10, T. Kenchanna. Respondent number 13, Bangarappa. Respondent number 14, Narsimhaya.
Substituted, service by substituted mode was taken up by the order dated 9/2/2015 made by a coordinate bench of this court. First stop. The names of respondent numbers so and so has been loudly called out by the court officer in the open court. And there is no response. Full stop. In view of the above, next para, in view of the above, service on these respondents, he is, by way of substituted mode is held sufficient. Doubt it.
For final hearing next week, Miller.
Next week. Next week, so, ಮಾಡಬಹುದಾ? So next week.
Yes.
20th.
Pleasure.
Okay.
Number 4, T. Narayanaswamy.
ನಾರಾಯಣ ಸ್ವಾಮಿ ಅದು ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅವ್ರು ಪೇಪರ್ ಸೆಟ್ ಪೇಪರ್ 1 week granted for doing the need. ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ.
Number 5, Munal Prasad.
Lordship, for wide order dated, my Lordship, 28/8/2024, my Lordship. This honorable court dispense the steps, taking the steps against the deceased respondent number 5, my Lordship.
ಅವರೆಲ್ಲ
Kindly see the order dated, my Lordship.
ಅವರೆಲ್ಲರೂ ಆನ್ ರೆಕಾರ್ಡ್ ಇದಾರು
ಇಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೂಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಡೆಡ್ ಪರ್ಸನ್ ಲಾರ್ಡ್ಶಿಪ್
Okay.
Therefore, we have taken a specific contention before this honorable court lordship. Suit has been filed against dead person lordship. Therefore, lordship, we made a submission lordship on that effect lordship on 28/8/2024 lordship. This honorable court lordship, for time being lordship, dispense the notice to the LRs of the R5 lordship.
ಟೈಮ್ ಬೀಂಗ್ ನಾವು ಮಾಡಲ್ ಇದು ಬೇರೆ ಬೆಂಚ್ ಮಾಡ್ತಾನೋ.
Lordship, and also order dated 28/10/2022 lordship.
ಏನು ಸೂಟ್ ವಾಸ್ ಫಾರ್
Specific performance. Lordship.
ಡಿಫರೆಂಟ್ 6
But I appear for the respondent, my lord, in this appeal. But I am sorry, my lord, I am appearing for the respondent. My lord, there is a proposal has been given to the appellant, my lord, for settlement. My lord, it may be called, my lord, next week, my lord, we will come out whether it
ಸೆಟಲ್ಮೆಂಟ್
can
ಈಗ
be
ಪ್ರಪೋಸಲ್
settled or
ಕೊಟ್ಟಿವಿ
not.
ಅಂತಾರಲ್ರಿ.
ನಮ್ಗೇನು ಕಮ್ಯುನಿಕೇಶನ್ ಇಲ್ಲ.
ಕೊಡಿ ಅದೇನ್ ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳಿ.
ಹೇಳಿದೀವಿ ನಾವು ಆಲ್ರೆಡಿ 50 ಲಕ್ಷ ಅಂತ ಹೇಳಿದೀವಿ, my lord. ಅವರಿಗೆ ಹೇಳಿದೀವಿ, my lord. Another counsel was earlier, my lord, appearing. But we will put it to him, my lord. Now today, my lord, other advocate has come. I will today, my lord, I will communicate my lord the proposal and.
ಏನ್ ಪ್ರಪೋಸಲ್ ಹೇಳ್ರಿ ಮಾಲಿ ಪಾಟೀಲ್, ಪ್ರಪೋಸಲ್ ಹೇಳ್ರಿ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಲಿ ಕೋರ್ಟ್ನಾಗ ಇರೋರಿಗೆ. ಏನ್ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ, ನಾವ್ ಹೇಳ್ತೇವೆ ಅವ್ರಿಗೆ.
50 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು.
You are for defendants.
I am for the I am for the plaintiff, my lord. My suit has been decreed.
Decreed.
Yes.
That decree is put in challenge before us now.
Yes, my lord.
You said if they give 50 lakhs to you, you will give up that decree.
Yes, my lord.
ಏನಂತೀರಿ?
I'll ascertain with the parties.
ಅಲ್ಲಿ ಬರ್ಕಳಿ.
I'm filing memo, my lordship.
ಏನಂತ?
2 years are pending. Both years are not survived for.
ಅದೆಲ್ಲ my lord ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು.
ಯಾರ ಅಪ್ಲಿಕೇಶನ್ ನಾವು?
ನಮ್ಮದೇ.
ಬರ್ಕಳಿ. two memos are filed by the counsel for the appellant in the open court this day to the effect that the application numbers so and so do not survive for consideration and accordingly they be disposed of. First off, there is no objection from the other side for acting upon the said memo. Do you have objection? First, next one, in view of the above, the subject applications are disposed of as having become infructuous.
Infectious in view of order dated 28/8/2024.
In the light of order dated
28/8/2024.
2024.
Please,
Okay.
please. It may be posted for admission, my lord. Any
Like
positive,
50 lakhs.
a positive settlement if it is open up lordship. All otherwise, it may be posted for admission.
ಈಗ ನೋಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಒಂದು
Please,
ಮಾಡಿ
please, please,
ಈಗ ಒಂದು ಆಫರ್ ಕೊಟ್ಟಾರ
please,
ಒಂದು 50 ಇಂದ ಬಿಗಿನ್ ಆಗತ್ತೆ
please,
ಅಲ್ವಾ?
please,
ಯು ಸಿಟ್ ಅಕ್ರಾಸ್ ದಿ ಟೇಬಲ್
please.
ನೋಡೋದು ಏನೇನೋ ಆಗ್ಬೋದು. ಬಟ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ plaintiffs submits that his clients are ready to give up the decree if a sum of rupees 50 lakh is handed to them. First, counsel for the appellant submits that he would carry this offer to his client
Please.
and come back. First, call this matter week after next. ನೀವು ಯಾರಿಗೆ?
Senior my lords.
ಅವ್ರಿಗೆ.
Much obliged.
Seniors. Appellant, I pray for 4 weeks time to filing paper book.
Paper book 2017 ಇಂದನೂ ಹಾಕಿಲ್ವಾ?
Matter of the
Counsel for the appellant seeks 2 weeks for filing of paper books. First off, 2 weeks reluctantly granted for doing it, failing which the appeal stands rejected on that ground per se.
I have appeared through NOC, my lords. I have appeared through NOC.
You want to retire from the case?
No, no. The earlier counsel is retired. I filed my wakalat.
You appear for
I
petitioner?
appear for the petitioners. There are office objections, my lord, that are to be complied. May I request for a week's time? Manuke.
Okay. Shri so and so appearing for the petitioner seek leave to retire from the case. First, in his place, Shri Manu K appears. First off, request for retirement accorded. Okay. Registry to delete name of Shri. Okay. Call after 2 weeks.
1 week, my lords. I'll comply and, my lords, matter relates to matter.
Compliance to be done at the earliest, post if compliance is done.
Okay. I'll leave it.
Yes, Bhagat,
For dispensation, my lord.
Translate. English translation, dispensed to. Ready?
Yes, sir.
Yes, head. 2023 matter.
Yes, sir.
ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಎಲ್ಲ dispensed it for the time being. Okay?
My lords, petitioners against the petitioners, a complaint was lodged. Tahsildar has conducted a spot inspection and filed a report stating that we are in the unauthorized occupation of the property. And I have produced all the documents before the land grabbing court stating that from 60 years we are in possession.
How? On what basis?
Yes, my lord. I have produced all the documents, my lord.
Show that.
Yes, ma'am. Now, my lord, complaint annexure B. Originally, it was lodged against on D. Krishnappa and Chaudappa. Yes,
Show
ma'am.
your document.
Yes,
How
ma'am.
you hold that land
Yes,
in
ma'am.
your hands, in your fist.
Yes, ma'am.
What
No,
are
no.
the documents?
Para number 4.4, petition number 1, my lord.
Para?
4.4.
Document. Show us the document.
Yes, ma'am. Annexure D, my lord.
Page number 39.
Page number 34, my lord.
ಸೇಲ್ ಡೀಡ್ ಇದು
ಅಲ್ಲ ದಾನ ಪತ್ರ ಮಾವನಿಂದ ಸೊಸೆಗೆ.
ಮಾವು ಹೆಂಗ್ ಬಂದಿತ್ತು?
Yes, my lord.
2021.
Yes, my lord.
How Mama got it?
Yes, my lord. It's an ancestral property, my lord.
Where is that?
Yes, my lord. It's not produced by me, my lord. But it's ancestral property. It
Not
was
saying
standing
that.
in his name from decades together. He transferred in the name of the Sase.
Sure. Repeating is not the proof.
Yes, yes, madam. Yes, madam.
Yes, I
Yes.
can also repeat, show
Yes.
that. Where do you stand?
Yes, madam. Regarding that, the previous documents I will produce, my lord. Next, my lords, regarding petition number 2, my lords. It's a registered document dated 1990, annexure G, my lord.
G,
Yes, my lord.
page number ಹೇಳ್ಬೇಕು.
Yes, my lord. Page number 47. Nineteen ninety-nine, under the sale deed, I purchased this property.
ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು?
One ಒಕ್ಕಲಿಗರ ಜಾತಿಯ ಮುನಿಯಪ್ಪನವರ ಮಗ.
Your assertion that it is an ancestral property dies by virtue of this.
No, this is another, my lord. Petition number 2, my lord.
No, we are on the first property.
First property, I have not produced how it has tested. Only annexure D I have produced, my lord. Regarding petition number 2, I have produced this document to show that in 1990.
So first property, now your argument is over.
No, but I am having documents, my lord.
Counsel for the petitioner submits that in respect of property comprised in the registered gift deed dated 13/12/2021, comma, he would produce documents to vouch his claim that it is an ancestral property. First, non-production may result into a heavy adverse inference being drawn under section 414 of the Evidence Act. First, call this matter next week,
Next week.
week after next, Karina,
What is a started or the complaint, my lord?
ಯಾವುದು?
Come either.
ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಮುಂದೆ see that.
I appear for the petitioner, my lords.
Yes,
Kindly,
madam.
kindly 2 weeks time may be granted for complying the subjection, my lord.
Compliance to be done within 2 weeks, failing which petition stands rejected on its own.
Much obliged.
Next. Ravi was here, na? Yes, sir.
Objections regarding translation.
Yeah, translation, ಇದೇನ್ translation ಅವಶ್ಯಕತೆ. ನೋಡ, dispense with ಮಾಡಬೇಕು, requirement would revive when judges, non-Kannadiga judges come here, ಆ ರೀತಿ ಮಾಡ್ಕೋಬೇಕು, something like that. Yes, Mr. Kantraj, ಏನಿದೆ?
Milord, this petitioner, milord, second division clerk working in the sub-registrar office, milord. The allegation is, milord, after the registration of these 3 sale deeds of a flat,
Mic and ಸರಿಯಾಗಿ ಇಟ್ಕೊಳ್ಳಿ.
sorry.
Keep your
I'm
mic
sorry.
little near.
Milord, the allegation is, milord,
Yes, sir.
against the petitioner, milord, petitioner is second divisional clerk, say,
Sub-registrar.
sub-registrar office. But only grievance is, milord, after the registration of these 3 flats, that sale deeds for, milord, are given to the, say, flat owner and not to the see, and not to the owner purchase the flats.
To the owner, ಹೇಳಿ.
That is the developer. Developer
No, up to that, registration ಆಗೋಯ್ತು.
ಆಗೋಯ್ತು.
Original
So
document
they
ಯಾರಿಗೆ
receive,
hand ಮಾಡಿದ್ರಿ?
yes. milord,
To whom you gave?
that is the, milord, the authorized person by the, milord, the purchaser.
What
One
is the
Manjegoda is the purchaser.
Authorization by?
Authorization by Manjegoda himself, who
Please.
purchased 3 flats. You last may kindly see annexure A39 at page 202. As per the authorization, milord, you last me, so page 202 at annexure A39. Milord, may I read, milord?
ಏನಿದು?
ಈ ಬ-
15/12/2017.
So
What
this
is
was,
this?
see, this is the resolution of the society. ಈ ಬಡಾವಣೆಯಲ್ಲಿ ವಾಸವಾಗಿರುವ ನಿವೇಶನದಾರರುಗಳಾದ ನಾವುಗಳು ನಿಮಗೆ ಅಂದರೆ ಬಿಲ್ಡರ್ಗೆ ತಿಳಿಸುವುದೇನೆಂದ್ರೆ ನಾವು Chandana String Wood Survey number so and so Ondara ಸರ್ಜಾಪುರ ಹೋಬಳಿ ಈ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಹೋಗಲು ಕೆಲವರು ಇದ್ದಾರೆ. ಈ ಕೆಳಗೆ ಸಹಿ ಹಾಕಿರುತ್ತಾರೆ. ಉಳಿದ ನಿವೇಶನದಾರರು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸು ನಲ್ಲಿ ಚಕ್ರ ಬಿಲ್ಡರ್ಸ್ ಹುಲಿಮಂಗಲ ಪಂಚಾಯತಿ ಲಾಸ್ಟ್ ಲೈನ್
ಸೊ ನೋಂದಣಿ ಪತ್ರಗಳು ನಮ್ಮಗಳ ಪರವಾಗಿ ಬಿಲ್ಡರ್ ಅವರು ಪಡೆಯಲು ನಮ್ಮ
ಅಭ್ಯಂತರವಿಲ್ಲ. ಲೇಟರ್ ಫ್ರಮ್ ಬಿಲ್ಡರ್
ಇದನ್ನ ಯಾರು ಯಾರಿಗೆ
ಮಂಜೇಗೌಡ, your last me next page, your last me kindly see. Manjegowda is the purchaser, serial number 4.
K.R. Manjegowda.
See, Manjegowda who purchased three flats. In his name, 3 flats were registered. They collected. And he himself gave a letter subsequently saying that I have received the sale deeds for which he has no objection at all. Your last may kindly see.
Manjegowda himself said.
Yes, yes. Annexure A3 at page 52. Vishya, Chamarajpet Millard, this is
Last current relevant line ಅಷ್ಟೇ ಓದ್ಬೇಕು.
last portion of last may kindly see. ಸಿಬ್ಬಂದಿ ಯಾವ ತಪ್ಪು ಇಲ್ಲದಿರುವುದರಿಂದ ಅವರ ಮೇಲೆ ನಾವು ಕೊಟ್ಟಿರುವ ದೂರನ್ನು ಹಿಂಪಡೆದುಕೊಳ್ಳುತ್ತೇವೆ ಎಂಬುದಾಗಿ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. ಹಾಗೂ ಸದರಿ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ತಾವು ಕೈಗೊಂಡಿರುವ ಮೊಕದ್ದಮೆಯನ್ನು ಈ ಹಂತದಲ್ಲಿ ಕೈ ಬಿಡಬೇಕಂತ ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥಿಸುತ್ತೇನೆ. He has received the sale deeds also from the person to whom those sale deeds were handed over. Despite the same
Where is your reply to the Shokas notice?
Your last
Where have you taken up that stand?
Yes, you lost. 47. Page, Millard.
Paragraph
47. I will point it.
Where have you mentioned in that resolution they had permitted the handing of the documents to the, there is.
Para 6 may kindly be seen, Millard.
Para 6 ಓದಿದೆ ನಾನು. ಅದರಲ್ಲಿ
Sudhakar received the original sale deeds from me and acknowledged the receipt of the same.
ಇಲ್ಲ.
Same.
You are saying he came along with one T Sudhakara and told us to give it. That's not your, that's not the document. Document says that the persons who have been enlisted at the table,
Yes.
they should be given ಅಂತ. ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ reference?
ಇದೆ. Subsequently, Millard, authorized person was.
ಎದರಲ್ಲಿದೆ?
See, under the.
Show that.
Page ಯಾವುದು? Forty-seventh page. In the connected matter, page 47 may kindly be seen. That is what I am.
In your reply,
Yes.
the apex court said in Kashinatha Dikshitalu matter.
When the complainant has.
If the doubt arises.
Relevant para, page 49.
49.
Yes, Millard.
Which line, sir?
Last 5 paragraphs, Millard. I have not committed any
That's
day.
all. I'm not that one. You have structured your defense.
ಮುಂದೆ provision ಹೇಳಿದ್ದೇನೆ.
That's all right. I have read that.
As per section 112,
That's not the question.
I am entitled to hand over the documents to the nominee also. Therefore, when the complainant has nominated Sri P. Sudhakar to collect the original sale deeds 12/1/2018 itself, he is barred from lodging a false complaint against the officer alone. A lapse of more than 4.5 months. Under that provision, you last may kindly see. Now, annexure A3 may kindly be seen. Annexure A3.
No, I'm asking simple questions, sir.
Yes.
Where is the reference to the letter which you have read at page 102, 202, exhibit D15,
Page 102.
202, 202,
Oh, yes,
which you drew our attention to.
yes.
Where is reference to this letter?
So he was welfare in the connected matter, the 11th, serial number 12. Blood, one more document, in the next matter, blood, you will ask me kindly see. Serial number, say 11th matter, page 31, another document. That is regarding Sabrisha.
Another matter,
The
serial number 12 is also
connected to
this.
12 is also connected.
also same matter.
Yes, yes.
All right.
Page 31, blood wherein ಮುಂದುವರೆದು may I read me? ಮುಂದುವರೆದು ಕರ್ನಾಟಕ ನೋಂದಣಿ ನಿಯಮ 1965 ಸೆಕ್ಷನ್ 112 4ರಂತೆ ಪಕ್ಷಗಾರ ನಾಮನಿರ್ದೇಶಕ ವ್ಯಕ್ತಿಗೆ ಮೂಲ ದಸ್ತಾವೇಜುಗಳು ನೀಡಲು ಕಾನೂನಲ್ಲಿ ಅವಕಾಶವಿರುವುದರಿಂದ ಶ್ರೀ KR ಮಂಜೇಗೌಡ ಇವರ ಸಹಿ ಇರುವ ಶ್ರೀನಿವಾಸ ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್ ರಿಜಿಸ್ಟರ್.
There is prima facie material.
Please, my lord.
And subsequently he has given a letter saying that I have collected the documents from the person to whom you had,
Yes.
he had delivered. Where is the grievance?
Lord, it appears that after 1 year, my lord.
He has said, person who has complained, he says, ಇಲ್ಲ ನಾನು ಅವನಿಂದ ವಾಪಸ್ ಬಂದಿದೆ ಅಂತ. ಏನ್ ಗ್ರೇವ್ ಆಗಿದೆ? Of course, the law says document should be given to the parties who is
Yes, ma'am.
generally buyer of the property
Please, my lord.
or transferee of the property or to his nominee.
Please, my lord.
No, they are given ಒಂದು ಲೆಟರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಇದಾಗಿದೆ. ಮತ್ತೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು ಯಾರಾದ್ರೂ ಮಿಸ್ಯೂಸ್ ಮಾಡಿದಂತದ್ದು ಇಲ್ಲ.
ಇಲ್ಲ
Because presumption in law, which Mullah writes,
No,
presumption in law is where a particular person holds the original, he has encumbrance over the property, worth of the property mentioned there. That's the law. 1918 Privy Council. That's not your case. Your
Tribunal,
simple case is
Yes,
he had
that's not
handed
their
it
case.
to some other person.
I understood.
ಅದನ್ನ ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ?
Tribunal, my lord, it says that there is no perverse inquiry proceedings ಅಲ್ಲಿ ಏನು perverse ಇಲ್ಲ ಅಂತ ಹೇಳಿ on that ground, my lord,
Enquiry,
there
where
is
is
no,
that? How it is treated?
if my lords may kindly peruse page 296, my lord,
296.
last 5 lines, my lord. ಕೆಳಗಡೆ, bottom, my lord, looking to the entire material, it cannot be said that the tribunal, that it is a case of no evidence. So also it cannot be said that the finding recorded by the inquiry officer are perverse in nature. But in my considered view, the finding recorded by the inquiry officer is
Perverse
correct.
ಆಗತ್ತೆ. ಅವ ಯಾರು
ಇಲ್ಲಿ
document
ಎಲ್ಲಿದೆ?
ಯಾರಿಗೆ ಕೊಡೋದಿತ್ತು ಅವನೇ ಹೇಳ್ತಾ ಇದ್ದಾನೆ, ಇಲ್ಲ ನಂಗೆ ಅವ್ರು ಕೊಟ್ಟ ನಂತರ ಅವ್ರು ಇಸ್ಕೊಂಡೇನಿ ಅಂತ. Though he raised the issue that he should not have given the document. Subsequently he said, anyway, we have received that document.
It appears, my lord, sale deed were collected by the builder.
Correct. But material ಅಂತ ಹೇಳ್ತಲ್ಲ tribunal, how?
That,
Why it disbelieved document at page 202? It's an exhibit in the inquiry. Where is the reasoning?
reasoning, my lord, the tribunal says that after 1 year, they have handed over the documents.
Where is the discussion on the document?
Discussion, my
No.
lord, it is there, my lord.
Emergent notice, learned EGA is requested to accept notice for the respondent number 1. Shri panel counsel is requested to accept notice for respondent numbers 2 and 3. Full stop. Learned senior advocate, Mr. Kantraj appearing for the petitioner, draws our attention to the document at exhibit, an exhibit adu 202.
Exhibit D15.
D15.
D15 at page 202 of the WP, which states about the authority given to the petitioner hearing to hand the document, registered document to some person other than the buyer of the property. First stop. There is other intrinsic material to house that also. First stop. Next point, in view of the above, the interim order as sought for is accorded. Same. ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಏನಾಗ್ತದೆ? ಎಕ್ಸಿಬಿಟ್ ಸೇಮ್ ಆಗ್ತದ ಬೇರೆನಾ?
Exhibit D15.
ಸೇಮೇ. ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಬೇರೆ ಆಗತ್ತನ? 202 ಬೇರೆ ಎಷ್ಟಾಗುತ್ತೆ? 202 ಹೇಳಿ.
I'll give the page.
ನೋಡ್ಕೊಂಡ್ ಕೊಡಿ. ಆ ರೀತಿ ಎಕ್ಸಿಬಿಟ್ ಡಿ ಅಂತ ಇಷ್ಟು D15 ಅಂತ ಪೇಜ್ ಹಾಕಬೇಡ. ಓಕೆ. Office objection overruled of accepting submission of counsel for the petitioner. Yes.
Page number is 203, my lord.
203, 202, 200, page number better, exhibit D15. Okay. Yes.
If a short accommodation, 2 weeks.
Okay, Srinivas. Complaints.
Complaints.
ಏನು objections? What fear?
ಇಲ್ಲ ಮೇಲಾಡ್ ಅದು ಕ್ರಿಮಿನಲ್ RP ಫೈಲ್ ಮಾಡಿದ್ದು ಆರ್ಡರ್ ಆಗಿ KLGP ಆಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಕೋರ್ಟ್ ಫೀ ಕೊಡಲ್ವಾ?
ಕೊಡ್ತೀವಿ ಮೇಲೆ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ತೀವಲ್ಲ 2 weeks time.
Complaints within 2 weeks, failing which petition stands rejected. Yes. ಆಯ್ತು ಅಲ್ಲ 12 ಅಜೆಂಡ್ ಅಲ್ಲ 12 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ಲಿ ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್. ಓಕೆ. ಎರಡರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ಬೋದು. ಓಕೆ.
Petition.
13. Yes, Vijay Kumar, ಏನಿದು?
Office objection, my lord, is I have served a copy on the third respondent board. And
ಅದು
they have
for
not filed any objections before the tribunal, my lord.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಥರ್ಡ್ ರೆಸ್ಪಾಂಡ್ ಯಾರು ನೀವ ನಾಯಕರೇ? ಏನಿದು ಮ್ಯಾಟರ್?
Lord, the transfer of the petitioner. Lord, she was promoted as joint director of town planning on 8/2/2023.
ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್ ಏನಿದೆ?
2 years.
2 years. Under 25/6/24 order.
Yes, my lord.
This order is dated
The 12/7/2024.
12/7/24.
Yes, my lord.
ಟ್ರೈಬ್ನಲ್ ಏನ್ ಹೇಳ್ತದೆ?
Tribunal, my lord, there are serious complaints, but my lord, the respondent kindly come to page 38, my lord, the impugned order. She is on transfer to the third respondent board. Board says they have not received any complaint. The first respondent says that they have received complaint and she is being transferred.
ಮತ್ತೆ ಇರ್ಬೋದು.
No, but oral transfer, oral complaints,
ಇಂಥ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ, ಓರಲ್ ಕಂಪ್ಲೇಂಟ್.
oral complaint. And the third respondent says they have not received any complaint.
ಓರಲ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲರ ಮೇಲೂ ಇದೆ, ಈ ಜಡ್ಜ್ಗಳ ಮೇಲೂ ಓರಲ್ ಕಂಪ್ಲೇಂಟ್. ಅದೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಎಲ್ಲಿದೆ ಮಟೀರಿಯಲ್? ಎಸ್ ಮೇಡಮ್.
There are
Ravindran said,
dereliction of
ಓರಲ್ dereliction of duty.
No, ma'am.
ಏನು? ನೋಡ ಅವ್ರ ವರ್ಷನ್ ಅದು ತೋರಿಸಿ. dereliction of duty DE ಮಾಡಬೇಕು. Of course, transfer is also permissible, but prima facie material ಬೇಕಲ್ಲ.
I'll take
What the tribunal said about that?
No, your lordship may kindly come to page
page para 12, my lord,
Page.
page 24.
page 11, page 23, para 11. ma'am.
3.
Correct, sir.
A serious allegation. Where is the allegation? Where is the allegation? Show that. The tribunal only says as a mantra. Mantra is no, it does not make mango fall down. Show one bus ticket size paper. Where is the allegation? Status quo ಇದೆ ನಿಮ್ಗೆ ಈಗ.
Status quo, but what has happened is, my lord, I was relieved and I have now been reported before the first respondent and nobody is posted in my place in third respondent board.
Show where is the complaint? No office, no civil servant will be safe if everything were to be go orally. Nobody will be safe. Orally anything can be said. In fact, in old CPC, there was no provision which said every order under the CPC should be in writing. Some orders were made by Governor General in Bombay orally, saying that court should be closed. And courts were closed orally. Then CPC came to be amended, saying that it should be in legal history. Justice Ramajoy has mentioned about that. Orally courts were closed by oral order. So then they said in writing. A similar principle applies here also. Orally andagane yaru orally, yarige orally, yarinda ಏನು? ಅವರಿಗೆ ಅದನ್ನು ಕೊಡಿ. Restore him to the post, her to the post. A coordinate bench of this court wide order dated 9/10/2024 had said as under. First, counsel for the petitioner submits oral allegations are unsafe to be acted upon in public employment. And therefore, employment, semicolon. He adds that till date, the position which the petitioner was holding is vacant, continues to be vacant. And therefore, in terms of spirit of the order of the coordinate bench, comma, he should be restored to the original position. First up, learned AG appearing for the officials and learned panel counsel appearing for the KIDB are not in a position to dilute the assertion of the counsel.
So far, we are concerned, my lord, I have specifically stated, my lord, so far as board is concerned, there is no such oral complaint by the board.
We'll write that now.
Second,
Sentence second semicolon, first semicolon aitu, second semicolon aitu, third semicolon. Learned panel counsel appearing for the respondent KIDB in all fairness submits. His client has not received any complaint against the petitioner.
Yes, it's my
Petition. First up, assertion is available in the court record, online proceedings. First up. Mundin same ಮಾಡಬೇಕು. Next continue same. Next part. In view of the above, the first respondent is directed to restore the subject post to the petitioner forthwith and report compliance to this court on the next date of hearing. Yes, call this matter next week for compliance, for reporting compliance. Immediately ಮಾಡಬೇಕು. Nobody will be safe. No employee will be safe. No person, you also will not be safe.
Please.
You also, please. And obviously we also. Yes. Status come, ಈ order ಬರ್ತದೆ. In view of that, science. Okay.
Appearing for the petition, my lords. Office objection is only with regards to translation, my lords.
Translation.
Yes, my lords.
Yes, dispensed.
Matter relates to promotion, my lords. I had approached the honorable tribunal seeking for issuance of writ of mandamus to consider my representation, which I had made to the authorities to consider my claim for promotion, my lords. I am in the cadre of assistant engineer. Since 2004, I have not been promoted, my lords. There were two inquiries initiated against me, one in the year
But the tribunal
2006.
says.
Tribunal lords,
Pending.
inquiries, one is pending, my lords. One was, I was exonerated. In that second inquiry, I have not approached any court, my lords. My co-delinquent would approach this honorable court, learned single judge, and get an interim order, my lords. Now the tribunal would say, since there is an interim order, there is delay attributable to your co-delinquent, and therefore you are not entitled for promotion. My case is I'm left with only 4 years of service. I would retire by the time
ಯಾವಾಗಿಂದದು allegation ಯಾವಾಗಿಂದ?
2019, my lords.
ಯಾವಾಗ ಮುಗಿಸ್ತೀರಿ? 2019 allegation enquiry ಯಾವಾಗ ಮುಗಿಸ್ತೀರಿ? ಹಾ?
There is a stay order passed in writ petition number 12690 of 2019.
That is annexure A4,
One
man.
of the colleague is also
Call this matter along with WP number
12690 of 2019.
next week. Week after next one.
Only one submission, my lords.
Ah.
That is pending before the learned single judge of this honorable.
Single judge ಮುಂದಿದೆಯಾ?
Yes, my lord. I have not approached. He's a board employee, so he's approached the learned single judge of this honorable court, my lord. And there is a stay only insofar as co-delinquent. There is no embargo on
Joint
trust.
enquiry ಏನದು?
Yes, my lord.
Joint
Joint inquiry. 5 officers are there.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ?
Therefore, my request was promote me subject to the outcome of the inquiry. If I am ultimately held that I was involved, or if the writ petition is disposed of, I would not claim any benefits at all.
Field cover procedure is adopted, your lord.
Correct, ಅದೊಂದು 25 ವರ್ಷ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ.
Like stage somewhere, therefore they are not proceeding with the.
I had produced the government order
good,
also. lords.
Good book by Gautam Bhatia. Sealed covers. ಅಂತ.
Unsealed covers, yes. my lord.
Unsealed
I have-
covers,
Yes,
you're
my
right.
lord. Yes, my lord.
Super one. Good writer. He writes with a pen dipped in
Yes.
acid. Very beautifully he has written and referred to many judgments of the apex court,
Yes,
about 4 or 5 high courts.
Yes.
You give one book to our library.
Yes, my lord.
Huh?
Certainly, I have it.
In ನಾಳೆ ನಾಡ್ದಿಗೆ ಹಾಕೊಳ್ಳ?
Yes, my lord. Day after.
Next week ಹಾಕೋಣ. ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. All right, you bring that book.
Yes, my lord. I will.
Present it to our
Certainly.
library. It's a good book. You also have one copy.
Yes, my lord. I have a copy of it. I'm grateful.
Notice. Age.
Also, I produced the government order which prescribes the timelines for the inquiry. Within 1 year,
That judgment of the apex court where it said you can't deny promotion on the ground that matter.
Chaman
is
Lal
fixed.
Goyal, my lords.
Huh?
Chaman Lal Goyal,
Chaman Lal.
1995.
You are right. ನೋಡ್ಕೊಂಬರ್ಬೇಕು.
Long pendency of inquiry would not
So, good.
preclude from considering my case.
ನಾವು ಇನ್ನೊಂದಿದೆ ಈ ತೀರ್ಥಪ್ಪ
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗಿದ್ರಿಂದ we are not proceeding.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ಬಟ್ ಅದು ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಇರೋದಕ್ಕೆ ನೋಡ್ಕೊಂಬನ್ನಿ ಅದ್ರ ಮೇಲೆ ಏನಿದೆ. ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಇದ್ದಾಗ ಒಬ್ರು ಸ್ಟೇ ಮಾಡ್ಕೋತಾರ ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅದ್ರ ಮೇಲೆ ಹೇಳ್ಬೇಕು.
Yes, sir. I'll certainly do some research. Could there any date be? Yes.
ಏನ್ ಡೇಟ್ ಬರಲಿ
Next date, next week.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಬರ್ತದೆ ಆಫ್ಟರ್ 2 weeks. ಎಸ್ ಏನಿದೆ ಆನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಿದು ಅಲೋ ಮಾಡೋಣ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಪ್ರೇಯರ್ ಇದೆ.
ಅಲ್ಲ ಎಂಪ್ಲಾಯ್ ದಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ಸಿ ಎಂಪ್ಲಾಯ್ ಡೈಡ್ ಇನ್ 1994 ಮೈ ಲಾರ್ಡ್. This is compensatory appointment. 3 wives is claiming the death benefits my lord.
ಇದು ವಿಡೋ
Please my lord. 3 wives. 3 widows.
Was he ದಶರಥ ಮಹಾರಾಜ or what? ಅದ ಐಎ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಮಾಡೋಣಂತೆ.
Please.
Application in IA number 1 of 2021 seeks leave to amend petition pleadings. It is supported by an affidavit. First up, the amendment would would not cause any prejudice to the other side. First, if amendment is not allowed, the petitioner may be aggrieved. First, after all, amendment is a rule and denial of leave to amend is an exception. First, no case of exception is made out. First, no objections are filed to the subject application. First, next paragraph. In the above circumstances, application having been favored, leave to amend as sought for is accorded. Amended petition to be filed. Notice ಆಗಿಲ್ಲ straight way. Notice ಆಗಿಲ್ಲ ಇನ್ನು.
Pescom is contested party.
All right, same order. Amendment to be carried out with an amended petition to be filed within 2 weeks. First, within next 1 week, it is open to the other side to file their statement of objections. Okay. AGA for R1. Say and so. Okay. Next.
Petitioner, my lord.
Yes, Mr. Ranath Jai.
My lord, the petitioner was appointed as a watchman, night watchman in the year 2009, annexure A1, my lord. December 2009, he has been appointed. 2009, it was recommended by the Assistant Regional Transport Commissioner, and then A2 is the order. On a meager salary of ₹1,000, he has been appointed on May 2010. He worked as such, his salary remained 2,000. Night duty, my lord, from night to the morning. Then, my lord, the annexure A5, page number 34, the commissioner, ARTO wrote to the commissioner, kindly see 1 minute, page number.
What is happened? What is your prayer?
He was not given the salary of the post, and he was not, up to 2018, he was continued in the same terms by paying 2,000 rupees per month. Then he approached the tribunal at page number 40, annexure A10, my lord, page number 40.
ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಅಂತ ಏನೋ ಆಗಿದೆಯಲ್ಲ.
ಕನ್ಸಿಡರ್ ಅಂತ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಅದ್ರೊಳಗೆ 2 ಆಸ್ಪೆಕ್ಟ್ಸ್ ಮೇಲೆ ಒಂದು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ, ಇನ್ನೊಂದು ಅವ್ರಿಗೆ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಯಾಲರಿ ಕೊಡಬೇಕು, ಬಿಕಾಸ್ 2,000ಗೆ ದೇ ಆರ್ ಬೀಂಗ್ ಪೇಡ್ ಮೇಲೆ. ದೆನ್ ಐ ಮೇಡ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಆಸ್ ಪರ್ ಅನ್ನೆಕ್ಷರ್.
ಪಾಸ್ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ? ಒಂದು ಸೆಂಟೆನ್ಸ್ ಒಂದು ಪಾಸ್ ಇಲ್ಲಲ್ಲ. ಹೌ ಟು ಅಸೆಸ್? How to assess? Where is the pause?
47.
But it says consider the represent. What is in your representation? What all you are saying?
Page number 48 is my representation. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಆಡಳಿತ ಮಂಡಳಿ ಬೆಂಗಳೂರು ಪ್ರದೇಶ ಪ್ರಕಾರ ನನಗೆ ಬಾಕಿ ವೇತನ ಸಂದಾಯ ಹಾಗೂ ಕೆಲಸ ಕಾಯಂಗೊಳಿಸುವ ಕುರಿತು ಮನವಿ. ಈ ಮೇಲ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದೆ ತಮ್ಮಲ್ಲಿ ಅರಿಕೆ ಮಾಡಿಕೊಳ್ಳುವುದರೆ, ನಾನು ತಮ್ಮ ಕಚೇರಿಯ ನೈಟ್ ವಾಚ್ಮನ್ ಆಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೇನೆ. 2018ನೇ ಡಿಸೆಂಬರ್ನಿಂದ ಈವರೆಗೂ ಸಂಬಳ ಪಾವತಿ ಮಾಡಿಲ್ಲ.
ಸಂಬಳ ಕೊಡ್ರಿ ಅಂತ ಅನ್ಕೊಂಡು ಕೇಳಿ ಒಂದು ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಿ.
ಹೌದು ಹೌದು
ಅದು ಮತ್ತೆ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ order.
ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ವಿ ಪೇಜ್ ನಂಬರ್ 49.
49.
Contempt came to dismiss, my lord, page number 53. Peruse the order of the tribunal, wherein there is a direction to consider the accordingly, respondent has considered the same decision is taken R1 in our consider view. R1 is nothing but endorsement, next page A13, page 54.
ಅಲ್ಲ ಜೈಸ್ರೆ ಅವ್ರ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಯಾರ ಹಿಂ ಬರಹ ಕೊಟ್ಟಾರೆ, ಅದನ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾಗತ್ತ ಅಂತ.
ಅದೇ ಈ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ KAT ಅವರು ಇವಾಗ.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದನು.
ಹೌದೌದು, ಆರ್ಡರ್ನ ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು. A13 was the endorsement, which was the subject matter of the present order, which is challenged before your lordship, page number 16, annexure A. Page number 17 ನಲ್ಲಿ ಆ endorsement dated 21/8/2020 was the subject matter of this application. 2008 I have worked up to, even now I am orally working, but they are not paying the salary. They are taking the work but not paying the salary, one aspect. And now I have completed 10 years of service also.
ನಮ್ಮಲ್ಲ ಕಟ್ ಆಫ್ ಡೇಟ್ ಯಾವ್ದಕ್ಕೆ, ಯಾವಾಗ 10 years ಆಗ್ಬೇಕು?
ಕಟ್ ಆಫ್ ಡೇಟ್ ಅಂತ ಇಲ್ಲ, ಉಮಾದೇವಿ
ಆಗ್ಬೇಕಾಗಿತ್ತು 2018 ನಲ್ಲೇ ಟರ್ಮಿನೇಷನ್ ಆಗಿದೆ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
2018 order has not been
directly applicable to proceedings in this case because he has not completed 10 years of service.
Whatever salary ಕೊಡೋದು ಅದಕ್ಕೆ
order that we have paid it, your lordship may kindly see page 55. Page 55.
Objection ಹಾಕಿ ನೋಡಿ, ಒಂದು objection ಹಾಕಿ. Issue notice, learned AG is requested to accept notice for this ಆಗಿದೆ already.
File the objection.
Objection ಹಾಕಿ. Statement of objections, if any, to be filed within 2 weeks.
Oblige.
Directed the government and KPSC treats, what is the right to you to have a modified list after 3 years of appointment of the petitioner?
Modified?
The list.
Which
But
list?
here petitioner was appointed. And after 3 years, KPSC modified the list and removes me and brings 2 persons. That was challenged by me before the tribunal, my lord. And they are asked to file the response and or to create a supernumerary post and accommodate both of us. And they have to tell the government.
During the corona, they have published the list. My lord, they noticed, KPSC itself is noticed the, my lord, the lesser merited candidate has been selected in the particular category. Therefore, they have revised their own, my lord, in the year 2023.
That power is there with them?
No power. They have
have taken the view.
It's only, my lord, there is no
The
specific.
orders of the court they can do.
But there is no specific power, my lord, but in this case, my lord, since the error is there. They have,
Error is there. Error may be
they
there in
know,
the
they only
judgment
notice
also.
it, my lord, it is not on my part. I was more merited than the selected candidate. I secured 158 marks.
That's all right.
The
Where is the power? Tomorrow, if they, not one case, suppose if we, countenance your stand, then it amounts to conceding that power of review to that body, which is not the object of the law. In one case, injustice agbodu.
Therefore,
But,
my
that
lord,
is not the point.
therefore, in the other bench, my lord, the 13/7, my lord, the government was directed to take instructions regarding vacancy position. Next date, my lord, they said there is a vacancy positions, my lord. I submitted a representations also, my lord, to consider, my lord, they accommodate both the persons, my lord. I'm not, my lord, against the selection of the petitioner.
The point is not that. There is a larger issue. Tomorrow, if they start doing the same mischief, what should happen to the candidates whose names are found, but whose names figure in the list?
I was not aware, my lord, it's a peculiar case where, my lord.
Why can't you treat our argument?
Please.
At least.
Your lordship argument is correct, my lord. There is no, I'm not quarrel about it, but since I'm more merited candidate.
That makes no sense because you have said you're only repeating. Tomorrow, if they start doing it as a business, where should our candidates go? That is the point.
KPSC, my lord, last occasion, my lord, they have specifically stated they have committed a mistake.
And there is no power vested in them. That is submitted.
ಅಂತ ಪವರ್ ಕೊಟ್ಟರೆ ನಾಳೆ ವ್ಯವಹಾರ ಆಗ್ಲಿಕ್ಕೆ ಶುರು ಆಗ್ತದೆ. ಮುಂದೆ ನಮ್ಮ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಗತಿ ಏನು? Adu a fear nಮಗೆ. Not you may be more meritorious, that's not the point. That's only one aspect of the matter. But question is, can we concede that power to the selecting body?
It can't be done.
Just stress.
It can't be done.
It cannot be.
It can't be done.
Even for the additional list, bar is 1 year.
1 year ಅಷ್ಟೇ ಇದೆ.
1 year ಅಷ್ಟೇ 3.8 ಪ್ರಕಾರ.
List list ಮಾಡಿದ್ವಿ.
How tribunal treated the matter?
They are on technical ground dismissed. I am telling you, all the parties are not made as a party. Prayer is not proper, not merit, it's not dismissed. Only on technical.
Technical ಅಲ್ಲ. Non-joinder of party, the Supreme Court says is not technical. It's a substantive ground.
Yes. But ಈ subject ಮೇಲೆ discussion is. No discussion on this point, my lord. Power of the KPSC.
Now before us, we are saying.
Yes.
You are in 227 actually.
Yes.
Virtually, because you are challenging the order of the tribunal.
Yes. Yes.
Question is, suppose if necessary parties are left out, and if their apple carts are going to be disturbed by our granting relief to you, which
Now
you
we are
have sought for.
restricted only to two persons who are affecting me. Only I have made a party, my lord. They are telling there what happened. Entire list were challenged. 10 persons were there, my lord. Revised list. I am affected by respondent number 5 and 6 alone, my lord. I am restricted to that only, my lord. I am not challenging the entire list. But your lordship, I will leave it to lordship. The power of when it comes, power of the KPSC to revise after 3 years without objection, anything. They are functus of issue.
ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಯಾರ ಆ ವೇಕೆನ್ಸಿಗೆ?
ಈಗ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 and 5, 5 and 6, my lord.
5 and 6.
Yes, my lord.
ಅದರಲ್ಲಿ ಒಬ್ರು ಹೋಗ್ತಾರೆ, ನಿಮ್ಗೆ ಒಬ್ಬರೇ ಅಲ್ಲ ಕ್ಯಾಂಡಿಡೇಟ್.
ಹೌದು, ಒಬ್ಬರೇ ಹೋಗ್ತಾರೆ. 6 ಹೋಗ್ತಾರೆ.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ 6ಗೆ?
I appear for R5.
R5, 6ಗೆ ಯಾರು? Served and represented.
Appear for respondent number 3, my
3.
KPSC.
It's actually, my lord, I say, my lord, it is a fraud committed by the KPSC.
It is.
And they published the final list during the peak corona period on, my lord, 23/5/2020, where was the lockdown was there. 11/5/2020.
Who appears for KPSC?
Sinchana.
Sinchana. So Karkamani, we may
Start date
pass
maybe.
some strictures on the KPSC.
Chart date maybe.
Huh?
Chart date.
Let them file affidavit, my lord. Why they are not considered the merit of the candidate while publishing the first list?
The
And last two questions, my lord, government stated, my lord, they have ready to accommodate. We have given the representation also.
ready to accommodate ಆಯ್ತು. ಇದ್ಯಾಕಾಯ್ತು ಹಿಂಗೆ ಅಂತ? ನಾಳೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಗತಿ ಏನು? ವ್ಯವಹಾರ ಮಾಡಿಕೊಂಡು ಯಾರನ್ನ ಬೇಕು ಅವ್ರನ್ನ ಸೇರ್ಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಅಲ್ಲಿಗೆ ಮುಂದೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು? ಸೂಸೈಡ್ ಮಾಡ್ಕೋತಾರ?
3 ವರ್ಷ ಆಯ್ತು ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡು 3 ವರ್ಷ.
ಈಗ ನನ್ನ ಕ್ಲೈಂಟ್ ಅಳತ್ತ ಕೂತ್ಕೊಂಡು.
ಕರೆಕ್ಟ್, ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ?
ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ ಆಗಿತ್ತು.
You are beneficiary of, at least certainly you are beneficiary of the fraud.
Merit it.
Not, but you are there may be many more meritorious candidates. Question is not that. A beneficiary of the fraud cannot justify the fraud anta hold madam. P. Changalavarayan Naidu, Nantara Meghamala versus so and so, so and so.
My lord, petitioner is the beneficiary of the wrong done, my lord.
Okay.
Where he is lesser merited candidate than the revised list.
No,
where-
but he was there. He was there. He does not prepare the list.
But I was,
His name was there, rightly.
Please,
or
please.
his name was. How he can be substituted by another name? It will be disastrous. But since larger issue is involved. Learned AG is requested to accept, requested to come and make submission on the next date of hearing. First stop. So also the panel counsel appearing for the third respondent. First stop. Call this matter the 2 weeks between. Admele ಏನಿದೆ rulings ಎಲ್ಲ ಇದೇನು?
ಇದ್ರಲ್ಲಿ
one Supreme Court decisions where, my lord, even though there is a mistake, my lord, the merited candidate should be, my lord, also be to be considered. But in this Vikas case, my lord, Supreme Court directed to consider for accommodation of both the candidates.
That amounts to allowing the KPSC to do the same mistake. ಒಂದು ಆರ್ಡರ್ ಬರಿಬೇಕು ನಾವು. ಫ್ರಂಟ್ ಪೇಜ್ ನಾಗ ಎಲ್ಲ ನ್ಯೂಸ್ ಪೇಪರ್ ನಲ್ಲಿ ಬಂದು ಅವ್ರು ಮರ್ಯಾದೆ ಹೊತ್ತು ಅಂದ್ರೆ ಹಿಂಗ್ ಮಾಡಲ್ಲ. Very court order in the Bagala, Lakshmi Narayana, nowadays, only court orders are not sufficient. We have to inflict very big injury. Only then the state entities will be in their bounds. Otherwise, they will never do. They don't take
I'll
the
search
courts at
more,
all.
I'll search more judgments also, my lord, on this point.
Not common.
Stay granted
Other
may
one
be
get-
kindly extended.
Interim order to continue. All in the second week of January 2025. Okay. Yeah, in the meanwhile, it is open to the respondent numbers 1 and 3, na?
One
State 1 and 2, madam.
1 and 2.
1 and 2.
1 and 2. In consultation with KPSC to give accommodation to the petitioner as well. So that issue may be given a decent burial.
Respond number 5 and 6.
Huh?
5 and 6 are because.
Without disturbing 5 and 6.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಆಗಿ ಹೋಗ್ಬಿಟ್ಟದೆ.
ಇದು ನಾನು ಇನ್ನೂ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದೆ.
You are there already. Well, continue, but entry order continue ಆದ್ರೆ ಸಾಕು. Entry order to continue.
Directions ಇರ್ಲಿ some non consideration ಮಾಡ್ಲಿ.
ಅವ್ರು ಬೇಕಾದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ನೋಡೋಣ.
ಅಲ್ಲ,
ಸ್ವಲ್ಪ
Your lordship, my lord, they have ready to give, my lord, your lordship observe it, they will consider it, my lord. Vacancies are there.
We are told at the bar, next, interim order to continue first. We are told at the bar that there are other vacancies in which respondent number 5 can be accommodated. First off, counsel appearing for the said respondent submits that his client has already made a representation in that regard.
Please, my lord. On 26/9/2024, my lord.
On
26/9/2024.
9/2024. First off, the official respondents to process the same in accordance with law. Okay.
Please, much of.
I appear for,
Yes, Lakshmi Narayana.
there is an order passed by this honorable court on 9/8/2024.
9/8/24.
Yes, my lord. That our case has to be considered for promotion to the post of Assistant Executive Engineer and further promotion. Then, my lord, the 2 adjournments have been sought for by the government.
It has already been considered, your lordship, so far as assistant executive engineer is concerned. And it is pending consideration at any moment, it will be signed, your lordship. DPC is held.
When are you complying this order?
And in so far as he is concerned, your lordship, she has to qualify for that. Qualification is there, minimum 3 years she has to complete as the assistant executive engineer, your lordship. That she is not entitled to. In so far as AE is concerned, your lordship, it's already under process, your lordship.
Process ಅಂದ್ರೆ the process
DPC held ಆಗಿದೆ.
ಯಾವಾಗ ಮುಗಿಸ್ತೀರಿ?
2 weeks time.
2 weeks.
2 weeks time.
At least ಏಕಾದ್ರೂ ಅಷ್ಟೇ ಸಂಬಂಧಪಡೋದು.
AE.
There are, the short point, my lord, would be upon a request by the petitioner, she has been transferred to the Water Resource Department. Then, my lord, she has given a representation to the government that there is a delay in exercising the option. Please condone it. The government under Rule 16 of the General Recruitment condoned it. That came to be quashed. When, my lord, eligibility for promotion is considered, are suitable.
10 days ನಲ್ಲಿ ಮಾಡ್ರಿ. 10 days ನಲ್ಲಿ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ಎಷ್ಟು why should wait endless. Counsel for the respondent on instructions of the officials concerned submits that the order dated 9/8/2024 issued by the coordinate bench would be complied in pith and substance, and a report of compliance would be filed within 10 days. Well, within an outer limit of 10 days. First, call this matter on. ಅವತ್ತು ಹೇಳ್ಬೇಕು.
Please.
ಆರ್ಡರ್ಸ್ ಯಾಕೆ ಮಾಡಿರ್ತಾರೆ? ಆರ್ಡರ್ಸ್ ಮಾಡೋದು ಕಂಪ್ಲೈ ಮಾಡ್ರಿ ಅಂತ. ಗವರ್ಮೆಂಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿ ಅಂದ್ರೆ
ಕಂಪ್ಲೈಂಟ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ, ಆಲ್ಮೋಸ್ಟ್ ಆಗಿದೆ.
ಬಿಡಿ, ಆಲ್ಮೋಸ್ಟ್ ಆದ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲ, ಅದು ಅವ್ರಿಗೆ ರೀಚ್ ಆಗಿ
ಎಲ್ಲ ಆಗಿದೆ.
ನೋಡಿ, ನೀವು ಕನ್ನಡಿ ಒಳಗಡೆ ನೀವು ಮಾವಿನ ಹಣ್ಣು ತೋರಿಸಿದ್ರೆ ನಮ್ಗೆ ತಿನ್ನಕ್ಕಾಗಲ್ಲ. ನೀವು ಕೊಡ್ಬೇಕು, ಕೊಡಿ, ಅವ್ರಿಗೆ ಕಳಿಸಿ. First off, the said complaint should be in substance and not formality, not in formality. Okay. Yes. Yes, Mr. Baliga. Any?
Against the directions.
I appeal for the first respondent bankers.
I appear for respondent number 2, Your Lordship.
Second respondent. Yaravaru?
Auction purchaser.
Auction buyer.
The appeal is pending before the DRAT. DRAT directed me to pay 11 lakhs. Against that, I am before your lordship. This court has directed me to deposit 8 lakhs. That within time I deposited. I deposited that amount.
ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಡ್ಲಿಕ್ಕೆ ಅನ್ನೋದು.
Entry model.
ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಡ್ಲಿಕ್ಕೆ ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರನ್ನ ಕಾಂಪ್ಲೈ ಮಾಡೀನಿ ಹಾಗಾಗಿ ಇಟ್ ವಿಲ್ ಆಡ್ ಮೆರಿಟ್.
ಇಲ್ಲ ಅದಲ್ಲ. What is the facts ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. I brought to the under 18, it could be reduced till 25%. ಆ ಬೆನಿಫಿಟ್ ಅನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ.
Repeat.
Under section
18, amended section 18.
18 ನಲ್ಲಿ provided also that the appellate tribunal, for the reason to be recorded in writing, reduce the amount to not less than 25% of the debt referred to be in the second provision. Our benefit, I am requesting your lordship to extend that benefit, because
What we said in Vijay Mallya matter, thodi, ILR 2018-19, myself and Justice Maheshwari Saab wrote that judgment. No, identical question is considered. We have construed section 17 and 18 of the amended act. But Vijay Mallya, ನೋಡ್ಕೊಂಬರ್ತೀರಾ next week? Next week ನೋಡ್ಕೊಂಬರ್ಬೇಕು. ಹಂಗ್ ಮಾಡ್ರಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಕೋರ್ಟಿಗೆ ಬಂದ್ರೆ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪವರ್ಫುಲ್ ಇರ್ಬೇಕು. ಹಂಗೆ ಎಂತದ 2 ಸೆಂಟಿ ಹೇಳೋದು ಮಾಡೋದು. ತೊಂಬರಿ ರೂಮ್ಲಿಗೆ ಇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ಕನ್ಸಿಡರ್ಡ್. We have already considered, affirmed by the Supreme Court. Bring that judgment. Dr. Vijay Mallya versus Consortium of Banks, ILR 18 or 19, 2019. Yes, call this matter week after next to enable counsel for the parties to come after preparing for the matter. Okay.
Having TBA barred by limitation, Your Lordship. Time-bound advancement he is seeking, which is barred by limitation. After 32 years, he is seeking that, Your Lordship. There is a barred pleading also, Your Lordship. There is no details regarding the pleadings before the KAT.
Short accommodation may kindly be granted, madam. Short accommodation may kindly be granted.
You want time?
The end of this week or Monday.
Call week after next at the request of counsel for the petition.
Next week only, Monday.
ಬರ್ರಿ ನೋಡ್ಕೊಂಬರ್ರಿ. Yes.
For the petitioner in the matter, Millards.
Yes, Mr.
Millards, the respondents have amended the rules, Millards, that I had challenged before this honorable court.
There was a restriction once they are become the members of the commission, state or central or, national or state. That rule has been amended after filing of the writ petition, Millards. Last date of hearing, I placed on record the notification, amended notification, substituting the rule 11(2), which was prohibiting them completely practicing before any of the commissions. Now only restrict into the commission from where they return. To that extent. Yes, madam. I have placed on record along with the memo.
The matter is resolved.
Learned counsel for the petitioner submits, and the learned senior panel counsel appearing for the contesting respondents agrees that in view of change of legal regime, wide notification dated
2nd August 24 placed on record by UAF memo.
Date ಕೇಳಿದ್ವಿ ಅಷ್ಟು ಹೇಳಿ.
2nd August 24 minutes.
2/8/2024, comma. The absolute embargo which obtained under the earlier legal regime has been diluted to the effect that the members can practice before any body other than the one in which they held the office.
Retired from the service of that commission. That's how it has wording.
ಅಲ್ಲಿ ಬಾಡಿ ಬದಲಿ ಕಮಿಷನ್ ಅನ್ಬೋದಾ?
Commission. That if it is one intelligence matters, the same wordings are used to do better manners.
Notification, the next paragraph, the subject notification being short and comma but relevant is reproduced below. First stop. Next paragraph. In view of the above, writ petition is disposed of.
Much obliged.
As having become infructuous.
Much obliged.
The notification model. The whole notification act might. Next. In Malaysian constitutional law, Malaysia's constitution, it came into force in 1964, largely modeled on Indian constitutions. Same way, except that there is no chapter like directive principles of state policy in that constitution. They, even after retiring from the Supreme Court of Malaysia, they are entitled to practice there.
But under Article 124(7
Of
as
course,
220.
They have done that way.
That's it. Lovely.
Yes, Mr. Srinivas.
Yeah, Your Honor. The Honorable Court is familiar that I represent myself as party in person.
You're most welcome.
Yep.
Can we have this
In this-
for admission now?
This is for preliminary hearing, Your Honor.
Yes.
There are three respondents in this writ petition, WP 24623 of 2024. Respondent one is the same respondent
What
which
is that
was,
you have challenged here?
Your Honor, respondents two and respondents three are attempting to block the introduction of macroeconomic reform project Earthling by me, my authored work, to the 193 world country delegations at the WIPO assembly upon the orders of this honorable court. And respondent three is attempting to create duplicates or aliases of me in an attempt to do identity theft. Both of this are related to the cause of action.
It is only attempt.
Which, no,
Attempting to. Your words we are reproducing now.
well,
Anticipatory.
so
relief.
I mean, to explain it another way, respondent two is a data center company. It's a hosting services company that provide services and they are attempting to apply what I define as a data center lever.
No,
Your Honor.
attempting to, you are repeating.
I have no, by attempting, I mean, I have evidence that is enclosed in the writ petition, which I would,
That they are attempting.
yes,
Evidence is as
they
to
they have
attempt.
actually deleted a few hundred emails from my email ID, projectearthling@srinivasdevati.com. And,
We'll
and
issue notice, then we'll hear them also, so that once for all we can do that.
I want to be heard so that the honorable court allows me to issue summons to them so that I
Not if
summon
they are
them to the
issuing
court.
now. Even when we are convinced of your prima facie case, still you want to argue up to 130.
No,
But you
as a
face your
party
friend-
person, I was under the impression that I need the honorable court to pronounce a daily order
No.
that I can summon respondents 2 and 3. But if I can actually go ahead and summon them, I'll.
Very good. Learned DSG, Mr. Shanti Bhushan is requested to accept notice for
Your Honor, respondent 1, I have served a copy.
first respondent.
I've served.
First, issue emergent notice to second. ಇಲ್ಲಿ number 2 ಅಂತ ಬರಿಬೇಕು.
Respondents 2 and 3.
2 and 3 ಅಂತ ಬರಿಬೇಕಲ್ಲ.
Okay.
Number ಹಾಕ್ಬೇಕು.
Respondent 1, I have already served the.
You have said that.
Yes.
It's a legal requirement under rule 4A, amended rule 4A.
Okay.
But we have to issue notice. ಅವಾಗ ಬರ್ತಾರ ಅವ್ರು.
Okay.
2 and 3 ಬರ್ದಾಕಿ. ನೀವೇ ಬರ್ದಾಕಿ.
So for respondents
2 and 3 ಬರ್ದಾಕಿ.
For respondents 2 and 3, I can go ahead and issue
Yes.
notice and summons
Correct.
together, right? Okay.
Yes.
It'll be posted for hearing on,
No, ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
you know, the next date that I have to mention while issuing a notice or for the
But
summons.
we in our court, there is a practice that the court which admits the matter or issues notice shall not fix the date, because that gives an impression that we are interested in the matter. Therefore, let it go, let it serve, post after service. Sorry. Post
You know,
after service.
I was here to go through the annexures.
Yes.
I'm requesting about 30 minutes of hearing time to go through the annexures. If allowed, so that I can present the entire documented evidence.
So you have served a copy on the first respondent now.
Correct.
Let copies be given to respondents 2 and 3.
Okay.
Then we can, once for all, we can go through
After
together.
that, do I have to move a memo for posting or?
Perhaps,
That is the procedural I'm
that's
requesting.
best. On the, you can move a memo also after service is done.
Or would it be listed that, how would I come to know? Because I'm party in person.
You are right.
I have to be given a date.
Call this matter in the second week of January 2025. Okay.
If it could be earlier, because there is attempts of identity theft and creating duplicates.
Correct.
With
We have difficulty.
with the respondent 3.
No.
So if it has got to be slightly, maybe a December date, if you could accommodate.
December, of course, it's a good December. Roses in December is good thing.
Okay.
But we have a lot of work now.
Okay.
They already dates have been
All right.
fixed. That's
So
the reason.
January 2nd week.
Yes.
It will be called on.
Yes. Thank you. All right.
It's an order challenging the order of cat, my lords. It's an autonomous body. It has a cat.
Cat and dog.
Honorable CAT.
Came in the way.
So sorry.
What happened? Cat came in the way of my.
Yes, my lord. See, the
Yes, brother.
respondent number 2 was selected as a principal director from director's grade, my lords. The DOPT,
Notice and stay. As sought for. You have sought for entry model?
yes, ma'am. Yes, ma'am. Page number.
Till next date of hearing. Yes.
Please.
Yes,
But it's-
Ravi. Anything.
I am a opposite party before the district commission,
Commission,
consumer commission.
Ah,
A complaint came to be lodged against me. You lost me, kindly turn to page 18, the prayer made in the, before the district commission. In page number 18.
18. Ah.
First prayer. Directing the first opposite party, that is me, to amend the deed of declaration. So and so.
2013.
Yes, to bring a percentage of interest in the land, common areas facilitated attached to the respective apartments and so and so. And directing the opposite party to restore the terrace portion of the multi-story building so and so, so and so. But after filing of this complaint, we filed a version before the district commission. On the ground, it is not maintainable because it's a prayer sought, it's altogether a jurisdiction of a civil court and I am not a consumer. But the suo motu order came to be passed, we filed an appeal before the district commission, questioning that no orders have been
Appeal
passed.
before the district commission.
State commission,
State
state
commission.
consumer commission.
Ah.
Appeal came to be allowed and a matter is remanded to hear on the maintainability of the complaint, whether the complaint is maintainable or not. Thereafter, the order regarding maintainability is ordered and the complaint ordered to be maintainable. As against that, we filed one more appeal before the state commission, questioning the maintainability of the order along with an application for stay. That application of stay is not considered and the court ordered for issuance of notice agreed by the same and before this court. Now before the district commission, they are proceeding with the matter. Now the case has been posted to 6/1/2025.
ಅದನ್ನ
maintainability ಬಿಟ್ಬಿಟ್ರೆ ಏನ್ ಬಂತು ಇದರಲ್ಲಿ?
ಈಗ ಫಾರ್ ದ ಟೈಮ್ ಬೀಯಿಂಗ್ ಒಂದು 15 ದಿವಸದಲ್ಲಿ ಮೇಂಟೈನಬಿಲಿಟಿ ಡಿಸೈಡ್ ಮಾಡಿಬಿಡ್ಲಿ ಅವರು.
May submit, my lord. A direction may be issued, it may be
That's what.
disposed of, that's all.
Till then, let them not precipitate. Today is the matter is posted before the district commission regarding filing of the reply to the interrogatories.
The substance of this petition relates to non-consideration of the request for reprieve by the state commission in the appeal filed against order of the district commission.
Please.
As to the maintainability of the complaint itself. First, learned counsel appearing for the petitioner argues, and The learned counsel representing the
The respondent
respondents,
number 1 to 3, my lord.
1 to 3, standing tall at the bar, agrees that a direction may be issued to the state commission to hear and dispose of the appeal within a reasonable period.
After service of notice to the respondent number 4. Because I have
Of
already.
course, after service to fourth respondent hearing. And that till then, let there be non-precipitation of the matter. First off, we are happy with the kind of stand taken at the bar here. First, next one. In view of the above, this petition is disposed of, requesting the state commission to take up the appeal for consideration before long. And that till appeal is taken up and decided, the matter shall not be precipitated in respect of the complaint in question.
Before the district.
Before, in respect of pending, the complaint pending before the district commission.
Shall I state the number, my lord? Complaint number 277/2022.
Barkodi, all we make it clear that we have not examined anything on merit. And the matter is at large at the hands of the state commission. All contentions of the parties are kept open.
Please. I have already appeared before the trial
No,
court and submitted objection, but only the respondent number 4 is to appear.
Correct.
Till the. after-
Registry to send a copy of this order to the fourth respondent by speed post immediately. Next.
Please.
To appear for the
Shastri.
appellant. I pray for 4 weeks time, my lord.
4 weeks time. Okay.
What has happened, my lord, is that
It'll be, but other man time waste ಮಾಡಬೇಡಿ time.
ಅಲ್ಲ ಇನ್ನೊಂದು connected suit ಇದೆ. He is seeking for partition. Decide ಆಗ್ಬಿಟ್ರೆ then this matter
It
can.
is listed today for arguments.
Final arguments.
Today.
I am the
it's listed.
defendant for final arguments.
Suit for partition.
4 weeks ಹಾಕ್ಲಾ?
2 weeks.
2 weeks.
ಆಯ್ತು.
ಮುಗಿಯತ್ತಾ? 2 weeks.
ಅಲ್ಲ 4 weeks ಅಲ್ಲ judgment and decree ಆಗ್ಬೇಕಾದ್ರೆ. That is why I asked.
3 weeks ಮಾಡು. Call after 3 weeks.
Please.
At the request of counsel for the petitioner.
Appellant.
Appellant. Yes.
Grateful.
Name of Sri V.P. Shivkumar to be deleted. And in his stand, Sadananda Shastri appears. Okay. Let- In his stead. Okay.
For the respondent.
ಪ್ರಕಾಶ್ ಶೆಟ್ಟರ್ ಬಂದಿಲ್ಲ. Passover. ಇವತ್ತೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ
Instead
ಅದಕ್ಕೆ?
of- I may make one request, madam.
Ah.
Instead of Passover, let it be taken up tomorrow, my lord.
Tomorrow ನಮ್ಗ್ ಹಂಗಿರಲ್ಲ.
Tomorrow or next week, my lord.
ಡೇಟ್ ಕೊಡ್ರಿ. ಟುಮಾರೋ ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಈಗಾಗಲೇ ಎಲ್ಲ ಲಾಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಆರ್ ಸ್ಕ್ವೀಸ್ಡ್ ನಾವು. ಆ ರೀತಿ ಇರಲ್ಲ. ಒಂದ್ ಡೇಟ್ ಹಾಕಿ ಅದರ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಹಾಕೋಣ.
He is working now.
ಈಸ್ ವರ್ಕಿಂಗ್ ನಾವು.
He is working from 24/12/2016. It's a absorption, my lord, regularization dispute is pending before CJIT.
Call this matter in the second week of January 2025. First off, the submission of learned panel counsel appearing for the which respondent, private respondent, that the petitioner has been working even to this day is placed on record. Okay, you take advantage of that. Yes, Raghavendra.
Case of dismissal from service.
Ah.
My lord, allegation is, my lord, purely a criminal misconduct, where, my lord, a conspiracy to kill my wife along with the mother-in-law and one
Conspiracy?
Hirananda. Conspiracy to kill my wife
Ah.
along with my mother-in-law.
Along with ಅಂದ್ರೆ ಅವಳನ್ನು ಕೊಲೆ ಮಾಡೋದು ಅಂತನೋ ಅಥವಾ ನಿಮ್
ಅವ್ರ
ಜೊತೆ
ಜೊತೆ ಸೇರಿ, ಅವ್ರ ಜೊತೆ
ಹೊಂದಾಕೊಂಡು ಅಂತ?
ಅವ್ರ ಜೊತೆಗೆ ಸೇರಿ,
ಸೇರಿ ಅಂತ.
mother-in-law ಜೊತೆಗೆ ಸೇರಿ wife ಅನ್ನು kill ಮಾಡೋದು only this is the charge, my lord, which is a criminal misconduct. 120B, my lord, where criminal court, my lord, acquitted me, but, my lord, after evidence of 31 witnesses, 32 witnesses.
33 witnesses.
ಪಿ ವಿ ರುದ್ರಪ್ಪ ಆಗತ್ತಾನೆ ಇದು?
ರುದ್ರಪ್ಪ
ಆಗತ್ತಾ?
ಆಗತ್ತೆ. ಒಂದು ಇದೆ ಅಲ್ಲಿ, my lord, relatives, my lord, they have treated as hostile. That one point is there. But those persons were examined in the departmental inquiry, mother, father, and sister of the deceased. Well, they have not supported the charge even in the departmental inquiry.
Mother also, your mother-in-law also did not.
Mother-in-law also not supported. Mother-in-law, ನನ್ನ ಹೆಂಡತಿನೇ ಸರಿ ಇಲ್ಲ ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
Mother of deceased. He is not along with him. ಹೆಂಗದು ಎಕ್ವಿಟಲ್ ಆರ್ಡರ್ ಯಾವ ರೀತಿ ಸ್ಟ್ರಕ್ಚರ್ ಆಗಿದೆ? ಅಬ್ಸರ್ವೇಷನ್ಸ್
Acquittal order is
five items.
Acquittal order clearly says, my lord, it is, they have failed to, my lord, they prove the charge. I'll give the.
ಅಲ್ಲ ಗಾಯತ್ರಿ,
Please.
PV ರುದ್ರಪ್ಪ ಕವರ್ ಆಗತ್ತಾ?
PV Rudrappa, my lord, in one sense it covers, in another sense your lordship observations, my lord, where certain witnesses, my lord, turned hostile. Therefore fully cover ಆಗಲ್ಲ.
ಅಜಿತ್ ಕುಮಾರ್
ಆದ್ರೆ ಚಾರ್ಜ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಅಂತ ನಮ್ಮ, ಬಿಕಾಸ್ ಚಾರ್ಜ್ ಇಸ್ ಪ್ಯೂರ್ಲಿ ಕ್ರಿಮಿನಲ್ my lord offense.
ಸರ್ವಿಸಿಗೆ ಸಂಬಂಧಪಡಲ್ಲ.
ಸರ್ವಿಸಿಗೆ ಸಂಬಂಧ, ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Suppose if you are a manager in a cashier in a bank and you lift my pocket, whether it has elements of service or not.
Please, if I'm a bank manager, I conspiracy to misappropriate the bank amount.
Not bank money, my private money.
But during the course of employment, it happens, my lord, it is a misconduct, my lord.
I think this is matter is covered by the judgment of judgment. There is a judgment of Punjab Haryana High Court.
2011, my lord.
2011 is Supreme Court.
Gurpal Singh.
Gurpal Singh.
set ಇದೆಯಲ್ಲ, ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡಿ.
my lord.
It's Rajasthan's case, my lord. ತಗೊಳ್ಳಿ ಮೇಡಮ್.
Is it misconduct or agali? How this if alleged act amounts to, if it were to be proved, we can understand.
My lord, nearly 33 witnesses were
One point
examined.
I'll, my lord, under 14 of the KPSC rules, if a criminal case is conducted against me, if a convicted, my lord,
No
I will be
inquiry
out
at
of
all.
service
Correct.
without even conducting the notice also.
That's the law. That's the law. But where you are acquitted, even assuming that it's a benefit.
My lord, evidence, my lord,
No, we'll
evidence
assume
of,
that.
my lord,
It
he
is
was
not a case of
absconding,
PV
my lord.
Rudrappa.
My lord, in Ajit's case, my lord, it is held that, my lord, there is no bar for, even if he's acquitted, there is no bar for
Holding
conduct,
inquiry.
yes, inquiry. my lord.
Inquiry about what? Provided that act has something to do with
Yes,
the definition of misconduct as governed in the
Lord.
conduct rules.
Offense is 302, my lord.
Correct.
Evidence of PW 32 and 33, my lord. They say that, my lord, on the date of offense, on the date when she was killed, the petitioner was not there. He was absconding.
No, we will assume everything as you said
Yes,
now.
yes, my lord.
Where is the elements, where are the elements of misconduct? Service is ಸಂಬಂಧಪಡಬೇಕಲ್ಲ misconduct. ಅದೆಲ್ಲಿದೆ? How misconduct is defined? Which is that misconduct? ಕೊಡಿ.
Conduct rules ತೆಗೆ. Conduct rules ಇದೆ. Service man.
For example,
Conduct rules, my lord, rule 3.
suppose he is running a bakery without permission under the Bakers Act. And he is prosecuted but acquitted.
ತೆಗೆ. Conduct rules ತೆಗೆ.
How you are concerned with that anta? Prove ಆಗಿದ್ರೆ we can understand.
Yes,
Then
ma'am.
if it is proved,
He
the
is
question of
acquitted.
holding this one will not arise at all.
I understand.
Straight
my
away
lord.
you will dismiss him.
He's
But if it
acquitted.
is not proved, can you hold a disciplinary inquiry in respect of that? Is the question. There are some judgments there are some judgments.
My lord, in page 52, my lord, the judgments have been
Misconduct.
cited. 52, my lord. Noida Enterprises Association. Yes.
Noida Entrepreneurs.
Yes, my lord. Entrepreneurs Association and even Shashi Bhushan Prasad.
What they say?
Lord, in lordships may kindly permit me to read para 11, my lord, in page 53.
No, this is
Allah,
being challenged.
regarding conduct only there.
This is being challenged.
Yes,
What
ma'am.
the judgments say, what the law declared in those judgments. You don't, therefore
there-
looking to the principles enunciated in the above mentioned. So
Yes, my lord.
what are the
Differently
principles?
I'm of considered view that the.
What are the principles? Where is it stated?
Yes, ma'am. I'll go through these judgments, ma'am. I'll assist the
That's the
court. my
correct
lord.
answer.
Yes, ma'am.
Norkamani.
Please, my lord.
The
They have
the
challenged the
paragraph-
inquiry proceeding.
Jit Kumar. Wow. Criminal case disciplinary inquiry can concurrently go is known to first year law student. Question is not that simple. Where the alleged act
Yes, ma'am.
does not have elements of misconduct. It may be a crime elsewhere.
Yes, ma'am.
How you can hold a disciplinary inquiry is the question.
I'll assist the court, ma'am.
All right, second week of January.
Little bit shorter date, but he is out of time.
No. Yes, next. Yes.
Lord, the matter pertaining to Lord initiation of departmental inquiry against the petitioner. Lord, the petitioner was transferred to RMSA, Rashtriya Madhyamika Shikshana, Lord, on 18/6/2014.
18/6/2014. ಏನಿದ್ರಾಗ ಏನಂತ ಮಿಸ್ಟೇಕ್ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ ಆರ್ಡರ್ ನಲ್ಲಿ.
214 2B, my lord.
Misappropriation of
That's
funds, government funds.
Lord, the inquiry is hit by 214 2B, my lord. Beyond 4 years.
214.
214.
ರಿಟೈರ್ ಆಗ್ಯಾರ ಈಗ.
Yes, my lord, I have retired on, my lord, 31/1/2019.
31/1/2019. Charge was issued on 8/11/2021.
8/11/20.
That will be within 4 years only.
30/12/2021.
No, come
Yes.
to page 50.
Yes, ma'am. 50, ma'am. Please.
50.
Yes, ma'am.
From down below.
Yes, ma'am.
1, 2, 3, 6, 8, 7th sentence.
Yes, ma'am.
The issuance of charge memo is on 8/11/2021.
Lord, that is the entrustment order, my lord.
Entrustment order. This is wrong.
Yes.
That 14A. 14A order.
8/11 is interesting.
Articles of charge is dated 30/12/2021, page 213. Lord, the 214 2B says, Lord, it from the date of
214,
alleged incident.
214 2B2.
2B2. Yes, ma'am. Lord, it is pertaining to, my lord, 214 2B2 says alleged incident. Alleged incident is said to have taken place in the year 2013.
So more than 4 years.
4 years. 2021 initiation. Lord,
Suspension agidna.
suspension
If he is under suspension, there
even
is one provision, amended provision which says
214
that period has to be excluded.
Yes, 214/6.
214/6. Was he under suspension?
Lord, I am not aware of the fact.
ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
Lord, before that, Lord, only on the short ground, Lord, it should be done de novo for this reason. Lord, the notice, that is observation notice is issued by a, my lord, of incompetent authority. That is, my lord, public prosecutor working in the office of, my lord, second respondent issues the notice, that is observation note. Lord, this honorable court has held that, my lord, the text and context of section 9 says that, my lord, it is only the Honorable Lokayukta or Uplokaayukta which who has to issue an notice. Reason is, my lord, before issuing notice, but the second respondent has to come to the definite conclusion that a case is made out.
That opinion is to be formed by the Upalokayukta
my
or
lord,
the Lokayukta as the case may be.
the-
Yavudu Gundappana, Yavudu?
Lord, my lords have discussed Gundappa and my lord, in division.
Dharwad bench, no?
Yes,
Illidena.
Dharwad bench. my lord.
Dharwad. Myself and
Basavaraj,
Krishna Bhatt. Or Vijay Kumar.
Vijay.
Justice
Vijay Kumar.
Pradeep Singh Yerur, my lord.
Erur sir. Nodidira judgment?
No, not the.
Authority, put one copy. Not reported. Not reported. Yarad helbeku. Of course, first one is competence itself. Let us see that one. The second one is whether he was under suspension and therefore 2146 would apply.
But only the period of suspension may be excluded. Even then,
It will be within, it will be
But,
beyond.
2013 allegation, 2021 initiation. But how the tribunal has considered this
Just
as
appropriation money est.
to the tune of 40 crores.
Huh?
40
To the
crores.
tune of 40 crores.
It requires consideration. It requires consideration.
But
Para
allegation is not against the petitioner.
Worth of the contract is 40 crores. Sir.
40 crores, not the allegation.
Allegation is using substandard quality.
Standard cost.
Allegation is not, my lord, I have misappropriated 40 crores. Allegation is,
Substandard quality of construction.
40 ಕೋಟಿ ಅಂದ್ರೆ ಏನು ಕಟ್ಟಿಲ್ಲ ಅಂತ ಆಗ್ತದೆ ನಿಮ್ ಪ್ರಕಾರ ಹೋಗಿದ್ರೆ. Your charge substandard construction we can understand. Saying that entire 40 crores he has swallowed.
Yes.
Means there is no construction at all, not even one small brick is laid there. That cannot be. Logically, it cannot be. If your allegation
Yes.
is that there is substandard construction,
Yes.
it repels the coupled allegation that there is no construction at all because he has swallowed entire. It cannot, one excludes
Appropriation
the
of,
other.
yes,
ನೋಡ್ಕೊಂಡ್ ಬಂದಿದ್ದು
yes.
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಕೊಡಿ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ
ಆಗಿದೆ. There is an interim order, my lord.
entry model to continue, call in the second week, third week of January. Yes. Maryada Purushottama.
Sorry, my lord. I may be.
Maryada Purushottama word.
Yes, my lord.
Who?
Rama, Sri Ramachandra. my lord.
Was called as Maryada Purushottama by Vasishta and Vamadeva. Yes. Yes, brother. Yenide.
My lord, my 2 annual increments were withheld with cumulative effect, my lord, for the allegation that I have not reported for duty in the Belgaum bench, my lord. I am an employee of Karnataka State
ಯಾವ
Administration.
ಡೇಟಿಗೆ you should have reported for duty and when you reported?
My lord, by order dated 4/9/2020, I was deputed on OOD basis for a period of 3 months to the Belagavi bench, my lord.
For
Deputed on OOD basis. This is the word used in the order, my lord.
date?
4/9/2020, my lord.
4/9/20.
2020, my lord. Yes, my lord.
For a period of 3 months.
3 months, my lord. Then I gave a representation to the authorities, my lord.
Where is the charge memo?
Page number 35, my lord. Annexure, my lords.
35. 4/9/2020 order ಆಗಿತ್ತು.
Yes, my lord.
You reported duty on which date?
No, my lord, I gave a representation saying that it is unable to, I am not willing to go there, my lord, because I have some personal inconvenience. I have given a representation, my lord.
What was the personal Suppose if we are posted to the Dharwad bench,
My
and
lord.
we tell the Chief Justice that, Honorable Chief Justice, that we will not go,
No,
what he will do to us?
My lord, in the KAT, there is no guidelines for posting any of the person to Belagavian bench.
Therefore, he will be posted anywhere the government wants.
My
The
lord,
government servant.
there is no TADA mentioned in the order, my lord. That's what I have to spend my own money in my Belagav, my lord. Therefore, I opposed that order and gave a representation to cancel that order, my lord.
If TADA is given, you would have gone there.
Yes, my lord. I have already gone earlier, my lord, in Kalaburgi.
After the constitution of the bench, my lord, instead of transferring as per the government order dated 7/1/2013,
You are
my lord,
deputing.
only we have short period of 3 months or 4 months, you are deputing it, my lord.
Correct.
My lord, everybody has gone, except
That everybody may be very blind. Everybody believed earth is not round. He says, why at my cost? I will not spend 1 rupee from my pocket. If you want me in Thar desert, you send vehicle to me. I will go there. Why he should spend? No, why you just answer 1 rupee. It's a very valued, it's the product of my perspiration. I will not spend. How can you compel the citizen?
but that is not his grievance, my lord.
Huh?
That is not his
Disobeying
grievance,
the
my lord.
orders.
I have brought some different file, my lord. I have it day after tomorrow, my lord. I'll assist, my lord. Because I brought, my lord, 26441 of 23, where different charge against.
Identical question was treated by State Supreme Court by Justice Neely of America. Bring that judgment. Almost identical. Justice Neely, one of the famous judges of a Supreme Court of a particular state, I don't remember which state, he treated that subject.
Please.
A citizen cannot be made to spend one penny from his pocket. He says, if you give money, I would have gone there. Just look into. Many would have gone there. We do not know why they go.
Against, my lord, has 4 inquiries. Now, another 3 inquiries are conducted. He has suffered with a penalty also.
ಅದು ಎಂತದಿದೆ ಏನೇ ಇರ್ಲಿ ಈ ಸಬ್ಜೆಕ್ಟ್ ಸಂಬಂಧಪಡಂಗೆ ಸ್ವಾಮಿ ನಂಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅವರು ನನ್ನ ದುಡ್ಡಿನಿಂದ ನಾ ಹೋಗಲ್ಲ.
I'll take instruction and assist, my lord. Have it day after tomorrow.
His representation is at page 50, my lord. He is not.
You have not said that.
No,
What
kindly-
he said.
Lordships may
ಎಲ್ಲಿದೆ
kindly
ನಾವು ದುಡ್ಡು ಕೊಟ್ಟರೆ ಹೋಗ್ತೀನಿ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ ಅನ್ಕೊಂಡು ಎಲ್ಲಿದೆ?
Annexure G.
Annexure G.
Please, my lord. In page 48, my lord. In page 49.
49.
On that point, there is no,
No grievance at all.
please, my lord.
Where have you stated?
My lord, I have stated in somewhere, my lord. I will show, my lord.
ತೋರಿಸಿ.
The-
ಅವ್ರು ಬಿಡಿ ತೋರಿಸಿ ಬಿಡಿ ಅವ್ರನ್ನ ಏನ್ ಮಾಡ್ತಾರೆ? Convince us. You have to convince us on preliminary points. Where have you stated?
Yes, my lord.
Where have you stated?
Totally, I have submitted 3 representations.
You might have
In one of
stated
the
one dozen representations.
Yes, my lord.
Answer our question.
Yes, my lord. I have to trace my lord in that. It may be pass over my lord. I will show my lord.
All right. Call,
My name may be
next
shown,
week.
madam. My name is not shown in the
Gayatri appears for.
respondent number.
Call this matter on 12th, 13th, other one date haki. 13th ಮಾಡ್ಬೋದಾ?
Yes, my lord.
13th, okay.
I'll show.
13.
ಈಗ ಎಲ್ಲದಕ್ಕೂ ಹಿಂಗೆ ಕೇಸ್ ಹಾಕೊಂಡು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ ಎಂಪ್ಲಾಯ್ ಹೌ ಜಡ್ಜಸ್ ಶುಡ್ ವರ್ಕ್ ಇನ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್?
My lord, that's what my contention, madam. We are taking small salary, my lord. We have to spend monthly 20 to 25,000. There is no accommodation, nothing, my lord. They are not giving a single paisa. We have to stay there. In Kalaburgi, when I was gone, they have given the TADA, my lord. So we have accompanied the judicial member and worked there, my lord. You know, while
That I'll
posting
take
the
instructions.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಈಗ ನಮ್ಮ ಅನಾಲಜಿ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಅಲ್ಲೆಲ್ಲ ಫೆಸಿಲಿಟಿ ಕೊಡ್ತಾರೆ, ಉಳ್ಕೊಳ್ಳಿಕ್ಕೆ ವ್ಯವಸ್ಥೆ ಎಲ್ಲ ಇತ್ತು. ಅವ್ರಿಗೆ ಹಾಗೆ ಹೋಗು ಅಂದ್ರೆ ಎಲ್ಲಿ ಉಳ್ಕೋಬೇಕು, ಅವರು ಏನ್ ಮಾಡ್ಬೇಕು?
In some days,
there is one aspect, just address that also.
Please, please.
you have stayed in the office also, my lord. In Kalaburgi.
Let
And
us.
I raised even preliminary objections also.
Yes,
Because in the all 3-4 matters which he filed, all petitions were my lord given by the Karnataka administrative Belagavi bench after transfer the case from Bangalore to Bangalore.
Solid, no, then it does not go to the root of matter. You are raising it, we know that, because of the 3-judge bench.
The 3-judge bench.
Not.
Here, my lord, where suspension against him was, my lord, allowed. I filed the writ petition before the Dharwad bench. He raised the preliminary objections, my lord, the division bench, coordinate bench, my lord, held. Dharwad bench is only the power to, my lord, entertain the writ petition. That is why I am bringing, my lord, this notice.
ನೋಡ್ಕೊಂಡು ಹೇಳು.
In this case, my lord, he availed the loan without prior permission. Under conduct rules rule 21.
Permission is a must.
My lord, he has to, my lord, take permission. Yeah, evasive reply is given. Others, my lord, similarly situated persons, my lord, they avail the loan, my lord. When we issued the notice, they, my lord, they apologized it, my lord, we left it the matter there itself. But here, my lord, in this case in hand, he has not done that. Therefore, my lord, after conducting inquiry, imposed the penalty.
Penalty of?
Two increments with cumulative effect.
2 increments. 1 increment ಮಾಡಿ. ಏನ್ ಲೋನ್ ಆ ಲೋನ್ ಯಾವ್ದೋ ಒಂದು ಬಾಂಬ್ ತಯಾರಿ ಮಾಡ್ಯಾನೆ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಅಲ್ಲ,
ಮನೆ ಕಟ್ಟಿಗಳಿಗೆ ಅಂತ
ಕಾರಣ ಏನು ಅದನ್ನ ಅಗ್ರಿವೇಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಎಷ್ಟು ಅಮೌಂಟ್?
5 ಲಕ್ಷ. 5 ಲಕ್ಷ ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡು ಇಂಟಿಮೇಷನ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತ ವಾದ ಮಾಡೋದು.
That's what he is. Perhaps he has studied law. Therefore, he takes up all such contentions. I read his representation. Anyway, 2 increments with cumulative effect.
ಒಂದು ನಿಮಿಷ ನಾನು ನೋಡಿ ಹೇಳ್ಬಿಡ.
That will be too much.
Yes, my lord. Cumulative
2
effect.
increment.
That will be too much. Make it 1.
Please, I will leave it.
1 increment ಮಾಡೋಣ.
My lord, in the rule 21, there is no such specific mention to get the permission, my lord.
ಇಲ್ವಾ?
There is a stay order, my lord, that order.
ಅದು ಬಿಡಿ, ಸ್ಟೇ ಆರ್ಡರ್ ನಾವು ಕೊಟ್ಟಿದ್ದೆ, ಅದು ಹೋಗುತ್ತೆ.
Yes, my lord. Yes, my lord. Yes, my lord.
Question is whether there is such a requirement that you should inform or you should take the prior permission.
No such requirements. Rule 21 of conduct rules, my lord.
Rule 21.
Yes, my lord.
21.
Investment, lending and borrowing. No government servant shall speculate in any stock, share or other investment. No government servant shall make a permit. ಯಾವ rule?
ಇದು ಕಾಂಡಕ್ಟ್ ರೂಲ್ಸ್, ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸರ್ವಿಸಸ್ ಕಾಂಡಕ್ಟ್ ರೂಲ್ಸ್ 21(4)(1), my lord.
21(4)(1),
my lord.
No government servant shall, except with the previous sanction of the government, save in the ordinary course of business with the bank or firm standing duly authorized to conduct banking business either himself or through any member of his family or any other person acting on his behalf, lend or borrow money as principal or agent to or from any person within the local limits of his authority or with whom he is likely to have official dealings or otherwise place himself under the pecuniary obligation to such person. Wait, first pair Roman 1 itself says, my lord, within the except previous sanction.
ಯಾವ್ದಕ್ಕೆ?
ಲೋನಿಗೆ,
ಬಿಸಿನೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ, ಲೆಂಡಿಂಗ್ ಬಿಸಿನೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ಕೆಳಗಡೆ ಇದೆ Roman 1A, borrow money.
Lend or borrow money as principal or agent. ಅಲ್ಲಿ ಕಮ ಇದೆ. ಅಲ್ಲಿ ನೋಡಿ, ಪೂರ ಸ್ವಲ್ಪ ಸರಿಯಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಒಂದು ಎಕ್ಸ್ಪ್ರೆಷನ್ ಕಾಮ ಎಲ್ಲಿಗೆ ಬರತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ. ಯು ವಾಂಟ್ ಟು ಕಿಲ್ ಕಾಮ?
Please,
Then come, I will
Borrow-
kill you.
Borrow money, my lord, he has to, my lord, it is a
Borrow
formal
money
thing.
as what? Please understand the law.
Please.
No government servant shall, except with the previous sanction of the government, and is subsequently added with blackening, save in the ordinary course of business with a bank or a firm of standing duly authorized to conduct banking business either himself or through any member of his family. This is like a lending business, money lenders act nalli. One sporadic act of lending will not be business. ಆ ರೀತಿ ಇದ್ದಂಗಿದೆ ಇದು. Business ಗೆ ಮಾಡಕ್ ಬರಲ್ಲ ಅವರು. Lending, borrowing, this business he cannot conduct. See that he shall not borrow from Allah. With, see the word. ಯಾವ ಕೋರ್ಟು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿಲ್ವಾ ಇದನ್ನ?
ಇದನ್ನ ಮಾಡಿ.
That's is ND judgment. Look, 1984 Karnataka, 83 or 84 Karnataka. Justice ND Venkatesh judgment ಇದೆ ಅವರ ಮೇಲೆ.
ಇದು ನೋಡ್ಕೊಂಬರ್ಬೇಕು.
ಮತ್ತೆ what he says appears to be true also. Just look into.
ಇದನ್ನ ಅವತ್ತೇ ಹಾಕಿ.
ಇದನ್ನು ಸಹಿತ ಅವತ್ತೇ ಹಾಕೊಂಡ್ಬಿಡಿ. Business ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Lending and borrowing either as principal or agent. Keywords ಎಲ್ಲ ಇದಾವೆ. Yes. Yes, Ramesh.
Lord, a case from law where a candidate to the post of ACF, Assistant Conservator of
Forests.
he is a highly qualified candidate, Lords. Only very brief dates may I mention.
What is the grievance? Why are you
The
here?
grievance is, I am a meritorious student from
You have to
University.
make Brandy's brief.
Please.
Perhaps you are aware of that.
Please. Yeah.
American judge.
Please,
He was
please,
a
just
lawyer.
a moment.
He used to make one statement to the court before starting the argument that came to be known as Brandy's brief.
There's a university in his name. Brandeis University.
Yes.
My lords, the issue is, the petitioner has completed his BSc in agricultural biotechnology. He makes an application for the post of ACF for the non-forestry candidates. There are two categories under which
Forestry
and non-forestry science candidates. Non-forestry science, it is not non-science, non-forestry science. So one is specialization expertise in forestry. And
both are in science only.
Both are in
The one
science.
is specialization is required.
Yes.
If non-forestry science,
Clear.
under that stream,
Please.
no specialization.
Specialization also required. The streams are mentioned, but they are wider than specific requirement for BSc forestry. So I didn't apply for the BSc forestry candidates ACF post. I applied for ACF non-forestry post. Now posts were available. I had a 2A category being rural. That was also available. That is not in dispute. What happens is I'm allowed to write the prelims. Thereafter written. I get the highest marks in the written. I go for interview.
Now they say you do not fit.
I have given endurance test verification of documents. After that, they say your degree is not the same BSc sciences which we are expecting and put up in the notification. It is contrary to that. Therefore, your qualification, you are disqualified on the score of qualification. So you will not be given the post of ACF. Now, this is the issue.
Where is the notification?
Well, it's the notification. Would your lordships kindly come to page 44?
45 is the educational qualification.
My lords, I'll complete my submission. My lords. BSc Aranya Shastradalli 8. Your lordship gets me? Annexure A3. A3 ಅಲ್ಲಿ
BSc ಪದವೀಧರರಿಗೆ
8.
BSc ಅರಣ್ಯಶಾಸ್ತ್ರ
ಪದವಿ ಹೊರತುಪಡಿಸಿ ಇತರೆ ವಿಜ್ಞಾನ ಇಂಜಿನಿಯರಿಂಗ್ ಪದವೀಧರರಿಗೆ 8. Your lordship may kindly come to the qualification required at page 47. This is the relevant portion where they say English ಅಲ್ಲಿ this one, second part ಅಲ್ಲಿ. For science and engineering graduate.
In A3, number 2. is relevant for you.
Is relevant. for
ಅರಣ್ಯ
that.
ಶಾಸ್ತ್ರ ಇದೆ.
ಅರಣ್ಯಶಾಸ್ತ್ರ ಇಲ್ಲ. ಅರಣ್ಯಶಾಸ್ತ್ರ ಪದವಿ ಹೊರತುಪಡಿಸಿ ವಿಜ್ಞಾನ
ಶಾಸ್ತ್ರ ಪದವಿ ಹೊರತುಪಡಿಸಿ
ಹೊರತುಪಡಿಸಿ ಇತರೆ
ಇತರೆ ವಿಜ್ಞಾನ.
ವಿಜ್ಞಾನ. ನಾನು ಅದರಲ್ಲಿ ಬರ್ತೀನಿ.
ಇತರೆ
ಇತರೆ
ವಿಜ್ಞಾನದಲ್ಲಿ
ವಿಜ್ಞಾನದಲ್ಲಿ ಬರ್ತೀನಿ. In that, there is a further catch, my lords. The qualification, the criteria they expect is kindly come to page 47. Internal page 47.
ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಹತೆ ಮತ್ತು
ವಿದ್ಯಾರ್ಹತೆ ಮತ್ತು ದೇಹದಾರ್ಢ್ಯತೆ. ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 2
ಫಾರೆಸ್ಟ್ರಿ ವಿಷಯವಲ್ಲದ.
ಹೌದು. ಇದರಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ಪೋರ್ಷನ್ ಇಸ್ ವಾಟ್ ಐ ಇಫ್ ಐ ಮೇ ರೀಡ್, my lords.
ಅದರ್ ದೆನ್ ಫಾರೆಸ್ಟ್ರಿ ಅನ್ನೋ ಅರ್ಥದಲ್ಲೇ.
ಹೌದು. ಫಾರ್ ಸೈನ್ಸ್ ಅಂಡ್ ಎಂಜಿನಿಯರಿಂಗ್ ಗ್ರಾಜುಯೇಟ್ಸ್ ಅಂದ್ರೆ ಅದರ್ ದೆನ್ ಫಾರೆಸ್ಟ್ರಿ. ಅವ್ರಿಗೆ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನು?
ಪ್ಯಾರಾ 2.
Para 2, English portion, my lords. Must be holder of Bachelor of Science degree in agriculture or horticulture or veterinary science or Bachelor of Science degree with 2 or more of the following subjects, namely mathematics, physics, chemistry, zoology, botany, biochemistry, microbiology, biotechnology, or a holder of Bachelor.
ನಿಮ್ದು ಯಾವುದು ಬಯೋಟೆಕ್ನಾಲಜಿನ?
My degree is from a agricultural science university. It is a BSc agriculture degree as well. It is a specialization within BSc agriculture.
ಈ ಸಬ್ಜೆಕ್ಟ್ಸ್ ಬೇಕಲ್ಲ?
ಅದಲ್ಲದೆ in this Bachelor of Science, I have done a variety of subjects, in particular biochemistry and biotechnology also. 2 subjects ಇರಬೇಕು. Minimum 2 ನನ್ನ biochemistry, biotechnology ಇದೆ ನಂದು.
ಯಾವುದೇ ಒಂದಿದ್ರು ಸಾಕಾಗಿತ್ತಾ?
ಇಲ್ಲ, 2 ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. This is in fact in opposition to the All India Forest Service. ಆಲ್ ಇಂಡಿಯಾ ಫಾರೆಸ್ಟ್ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಒಂದೇ IFS ಆಗೋದಕ್ಕೆ ಒಂದು, ನಂತರ ಇವರು ACF ಆಗಿರೋರು ಕೂಡ ಒಂದಿನ IFS ಆಗ್ತಾರೆ. ಅವಾಗ ಒಂದೇ ಸಬ್ಜೆಕ್ಟ್ ಸಾಕು ಅವ್ರಿಗೆ. ಇಲ್ಲಿ 2 ಕೇಳ್ತಾರೆ. ಎನಿವೆ ಅದನ್ನ ನಾನು ತಕರಾರು ಮಾಡಿಲ್ಲ. ಐ ಕಾಂಟ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಟೂ ಲೇಟ್ ಇನ್ ದ ಡೇ. ಐ ಆಮ್ ನಾಟ್ ಚಾಲೆಂಜಿಂಗ್ ದ ನೋಟಿಫಿಕೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್. May I clarify that point, right?
You show us that you have studied these
Please,
subjects.
Your Lordship may now kindly come to my marks aggregate and my individual marks.
ಇದೇನು ಅಡ್ಮಿಟ್ ಆಗಿ ಹಿಯರಿಂಗ್ ಬಂದಿದೆ ಏನು?
P group ಅಲ್ಲಿ ಇದೆ ಸರ್.
Okay.
ಇದರಲ್ಲಿ
ready.
Lordship.
My lords, I seek for a short accommodation. Statement of objections has to be filed.
When were you served with the notice? You had filed objections before the tribunal?
No, my lords.
No, my lords.
They have not filed.
ಮಾಡಿಲ್ಲ.
My lords, a short accommodation of 3 days, my lords. A short.
3 days ಅಲ್ಲ, ನೋಡೋಣ ಜಾಸ್ತಿನೇ ಕೊಡೋಣ. ಬಟ್ ಯಾವಾಗ ಸರ್ವಿಸ್ ಆಗಿತ್ತು? ನೋಟಿಸ್ ಯಾವಾಗ ಸರ್ವಿಸ್ ಆಗಿತ್ತು? ಈ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನಾವು ಡಿಲೇ ಮಾಡ್ಕೋತ ಹೋದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಕ್ಯಾಂಡಿಡೇಟ್ ಏಸ್ ಬಾರ್ ಆಗಿ ಹೋಗ್ತಾನೆ.
I seek apologies, my lords.
Call this matter on 13th, 18th. Not good. First week of January ಹಾಕೋಣ.
This real, your Lordship, at your Lordship's hand. This is a very clear cut case. Sometime.
Correct. But ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ಬೇಕು.
ಅಲ್ಲ, ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ಲಿ ಸ್ವಾಮಿ. ಒಂದು ವಾರ ಅಥವಾ 10 ದಿನದಲ್ಲಿ let them, because clear he's a highly qualified. He is holding PhD and they don't want such a person in ACF. 21st of
call this matter.
November.
1st November.
November 20.
At the request of learned counsel appearing for
Are 2 minutes.
R2. First. No further date will be granted.
So grateful.
They have already studied biotechnology in this one. Ramesh, there is one judgment of Apex Court which treated almost similar way under the UGC guidelines.
Please.
How specialization should be read in your curriculum? Another melne, Justice, I don't remember, some judge has said that under UGC guidelines, there are such judgments. Just look into
Please.
Arul Selvam, the law relating to education.
Please.
There is one big volume. He has referred to that. I remember. Just look it.
In terms of equating, Lords.
Correct.
How to relevant.
Not equating also.
Please.
How to construe these provisions. That way. Equating we cannot do.
True.
Some authority has to do.
Yes.
Now it is not a case of equation. It is a case of construction. Construing of that particular item.
Yes.
Just look into.
Great.
Okay. Yes.
Appearing for the petitioner.
Lord, the contesting respond number 3. The panel advocate, Ms. Sinchana, informed me today morning there is a bereavement in the family.
Okay.
She said a short
Ah,
accommodation.
thank God.
But however, the matter is covered by the judgments of the Honorable Supreme Court. It's a pure question of law.
But
Whether
you said that there is bereavement in the family of.
she
Vatsal,
said,
na?
yes, my lord.
In the second week of.
But she said
February
she'll be
20.
back tomorrow. May I request for a short date, my lords? What has happened is my appointment as an STA has been cancelled by KPSC.
Second week of January.
Lords, may I request for in the
request.
month, this month, my lords, may I request
This
for
month very difficult, brother. Yes, next. Yes, Kashinath.
This, my lord, the petitioners are the, my lord, blind teachers, my lord, that are working as a music teachers in the primary schools.
Blind teachers.
Yes.
Quote one good author who was blind, but who wrote great epic.
Rules are challenged.
Huh?
Rules are challenged.
Rules are challenged. He was blind. Don't know. Paradise Lost, Paradise Regained. Paradise Lost, he wrote when he was blind. Paradise Regained, he wrote after getting the eyesight back. Great epics. John Milton.
John, lordship was only, my lordship was only insisted while my lordship was practicing to read that book, my lord, when once in the car.
No, I read those books when I was in
To
college.
me, my lord, to me, my lord.
To you, okay.
Yes. Kindly note that the short grievance is this, my lord, in this case. The petitioners are the music teachers. They are working in the primary schools, my lord, as a music teachers.
Music
The
teachers.
grievance is, my lord, in respect of the transfer policy. The government, my lord, formulated 2020 Transfer of Teachers Act, my lord. That Teachers Transfer Act, my lord, is amended in 2022. In that, my lord, Section 10, my lord, in the initial act, where, my lord, exceptions is, my lord, is provided for various categories of persons seeking request transfers.
Means they can request transfer or they're excluded from request?
No, my lord, they can
request.
They can make request, my lord, on oftentimes on various grounds, my lord, health issues, family, couple case, this, my lord. In 2020, my lord, 22, my lord, this Section 10 was amended, my lord, by imposing a restriction for one-time request.
One time in the whole service?
Yes, my lord. It is, my lord, equally, my lord, it is applicable for the disabled candidates, disabled teachers, including the teachers, those who are blind teachers. If, my lord, in the
It does not, it's a very general clause.
Yes.
Which comprises all employees,
Yes.
all teachers.
Yes.
And they have nothing to do with the disability.
Yes.
Where is that section?
Kindly, my lord, the original section, my lord, is at Annexure A2, page 75, my lord.
Stop objection.
You have filed?
File.
You want to file?
Page.
You have filed.
Rules are challenged. I will file yours.
For generally, for challenging rules, ordinarily no question of filing statement of.
Discrimination ante ಏನಿಲ್ಲ.
ಅಷ್ಟೇ case.
ಅಷ್ಟೇ ಒಂದೇ option is given to them. Only once they can exercise it.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು.
Because now lordship disability under that we are not supposed to discriminate. In so far as this is concerned, it's only an option given to them once they can exercise it. It's a case of transfer. It is in a case of transfer, lordship may kindly appreciate.
ಕಪಲ್ ಕೇಸ್ ಜೊತೆ ನನ್ನನ್ನು ಈಕ್ವೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ನಾನು ಬ್ಲೈಂಡ್ ಟೀಚರು. ಇವತ್ತು ಪ್ಯೂಪಿಲ್ಸ್ ಟೀಚರ್ ರೇಷಿಯೋ ಇಸ್ ಕರೆಕ್ಟ್ ಇದೆ, ನಾನು ಇಲ್ಲಿ ಇದ್ದೀನಿ. ನಾಳೆ ಒಂದಿನ ಅಡಿಷನಲ್ ಟೀಚರ್ ಆದ್ರೆ ನನ್ನನ್ನು ಎಲ್ಲಿ ಹಾಕ್ತಾರೋ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ದೆನ್ ಐ ಕಾಂಟ್ ಮೇಕ್ ಎ ರಿಕ್ವೆಸ್ಟ್. That option is not open, my lord, under section 10.
There should be an option
If
there.
the transfer of teachers, my lord, is completely based on the data, my lord. The teacher and pupil ratio has to be considered as per the section, the provisions of the act itself. When, my lord, my school found that my post is found additional post because of pupil and teacher ratio, then, my lord, where should I go? I can't, my lord, make a second option because that option is restricted under section 10. By virtue of this.
Which is that?
Section 10, my lord.
We will take this matter next. We will also read and come back. Any judgment on this aspect of the act?
No, my lord. This issue is, my lord, Section 20 of, my lord, the Persons with Disabilities Act. Yes, my lord, where the provisions provide in respect of posting and transfer, there must be a policy. That, my lord, the word is may. Here already policy is formulated, but my lord, not with the conscious care and towards the disabled persons. Where their rights are protected by virtue of this policy, my lord, is not considered by the government by imposing
Your
that.
grievance is against the rule making itself.
Yes.
It requires consideration. Notice ಆಗಿದೆನಾ?
Notice
ಆಗಿದೆ.
ಆಗಿದೆ.
In the
Here, my lord,
second week of January.
The date, my lord, the next year ಬರೋದಕ್ಕಿಂತ ಮುಂಚೆ dispose.
ಇಲ್ಲ ಮುಂದಿನ ಟ್ರಾನ್ಸ್ಫರ್ ಯಾವಾಗ?
ಅದು next February
third week of January. Yes. 2025. Yes, Prakash. Chatre.
This is with regard to payment of the difference between the MACP and fitment charge benefit. In fact, in 2013, my lord, we have given fitment benefit, my lord, 3%. Later, my lord, in the year 21, we have withdrawn it. And thereafter, my lord, he has been granted MACP 3, my lord. Now, my lord, he has, earlier, my lord, he has approached the CAT, my lord, asking for MACP.
MACT.
MACP 3, my lord. That is,
MACP 3.
please, modified, acquired
Okay.
career progression. 3, my lord, 2 we have given, 3 we have not given because fitment charges benefit were given. So the CAT, my lord, dismissed the OA, my lord, on the ground that you have been given 3% fitment benefits. So MACP 3,
They cannot avail.
please, my lord.
3% ಕೊಟ್ಟವರಿಗೆ, those who have taken that benefit.
They have not challenged that. They have not asked for. And on that ground, my lord, it was dismissed, his OA. Then later, my lord, we have withdrawn the fitment benefit, my lord.
Then he becomes entitled to.
Then we have granted MACP 3.
You have granted MACP.
Please, my lord, that is not in dispute. Now, my lord, he has approached the CAT again, my lord, for a grant of fitment charges because withdrawal benefit has been challenged by him. Then
CAT has granted it now.
Granted, my lord, that is the difference now. Because MACP amount less the fitment benefit less MACP.
Differentially order ಮಾಡ್ಯಾರ.
Please, my lord. Now the question is, my lord, the fitment benefit we have withdrawn, my lord, all over India, and even we have recovered it also from all others. And from him also we have recovered it. Now, my lord, for refund, my lord, there is an order. The question here is, my lord, whether Rafiq Messiah's case applies to him and later, my lord, Thomas Daniel.
KR Singh Cyber judgment.
Please, my lord. Later, my lord, 2022, my lord, Thomas Daniel case. There, my lord, one observation has been made. If the employee has been put on notice with regard to this mistake in calculation, the government can recover it. That is a one observation. Another, my lord, even Rafiq Messiah's case also, the recovery is barred, my lord, so far as C and D group employee is concerned.
Not this
he belongs to B grade, my lord.
ಅಲ್ಲ ಅಲ್ಲಿ ಆ ಕೆಟಗರಿ ಕೇಸಸ್ ಇದ್ದು ಅನ್ನೋದಕ್ಕೆ ಹಂಗೆ ಹೇಳಿದ್ರು ಅವರು. ನೀವು ಅನ್ನೋದು ಆ ಡಿಸಿಗ್ನೇಷನ್ ಅವ್ರು ಇಲ್ಲೇ ಬರ್ತಿತ್ತು ಅಂತ.
ಅಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲೋವರ್ ಗ್ರೇಡ್ ಎಂಪ್ಲಾಯಿಗಳಿಗೆ ಉಪದ್ರ ಮಾಡಬೇಡಿ ಅಥವಾ ದೇ ವಿಲ್ ಬಿ ಪುಟ್ಟು, ದಟ್ ಮೇ ಬಿ ದ ಒನ್ criteria. Because and this man, my lord, he has been put on notice. In fact, my lord, he has become an account officer who is in charge of the very accounts department. And he has kept that recovery notice, my lord, as it is, and later he has sent it. That is also one of the allegation we have made.
This is, my lord, out of record. This allegation, my lord, I'm sorry to state that he should have pleaded it before.
No, we have pleaded and.
No, it is not so.
And he has sought for
Not winning the case is something different from, my lord, making a statement, my lord.
No, we have made a statement.
ಸುಳ್ಳು ಹೇಳಲ್ಲ.
No, ಅಲ್ಲ ಯಾಕ ಅದೇ ನನಗೂ ಆಶ್ಚರ್ಯ ಆಗ್ತದೆ. He must be, my lord, I am not saying anything about.
My lord will not lie.
No, I am not saying, my lord.
ನಮ್ಗೆ ಆ ನೆಸೆಸಿಟಿ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ
We
you
understand.
will have to
You
show
have great
more
respect for-
fairness when we appear for a department.
Elthon,
Please,
where you taken up that contention?
please. Para 15, my lord, ink page 32.
Two.
It is submitted that the respondent was relieved from Office of GM Building, so and so Bangalore, on 4/8/2021, on his transfer to Office of CCA, Karnataka Circle, Bangalore, so and so. The respondent assumed the charge of accounts officer, that is on Karnataka Circle, so and so, on 5/8/21. Further, on assumption of charge as accounts officer in so and so, he was assigned charge of establishment, telecom accounts and audit division, wide office order CNC, order number so and so, dated 23/8/21 as per annexure R7. Since the account officer establishment division, Karnataka Circle, Bangalore, so is responsible for drawal of pay and other personal claims like tour, TA, LTC, medical, etc. Every employee deduction of income tax at source, recovery of excess paid pay and allowances to any employee after following due procedure.
ಎಲ್ಲಿದೆ? ನೀವ್ ಹೇಳಿದ್ದೆಲ್ಲಿದೆ?
Then it is there.
Huh?
It is submitted Bangalore. Next para, my lord.
16.
Please. Date, that is, it is submitted that on office order so and so and so, a letter dated 15/11/2021 forward to the service book of Sri G. Suresh, that is the respondent, along with the due drawn calculation sheet detailing recovery of an amount of ₹1,96,501 in accordance with the DOP so and so, dated 26/4/2020. It is pertinent to note that here that a Group B gazetted officer was in charge of establishment division, CCA, Karnataka Circle, on the date of receipt of letter dated 15/11/21 from Office of GM, Karnataka Circle so and so. It is further submitted that as per the prescribed procedure, the action for issuance of the notice of recovery should have been initiated by the respondent himself in the capacity of a responsible account officer holding the charge of establishment division, and got it served from the competent authority for the order of recovery received from office order GM. Instead, it is important. Officer represented directly to the higher authority.
He has apologized for that.
For that.
ಇವ್ರು ತಗೊಂಡ ಅಬ್ಜೆಕ್ಷನ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ? ಗವರ್ಮೆಂಟ್ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಅಂದ್ರೆ ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಇತ್ತು. He has sent it for higher officer, my lord, because he had the notice of that recovery.
Yes.
Proceedings.
All right.
So he can't tell, my lord, before.
Two judgment kudi now, I have not seen that judgment.
That is
only just Justice Kihar's judgment, 2013 Supreme Court.
That is in page 192 is there, my lord.
ಅಲ್ಲ, ಅದು ಡೆಸಿಗ್ನೇಷನ್ ಸ್ಪೆಸಿಫಿಕ್ ಅಂತ ನಿಮ್ಮ ಒಂದು ವಾದ.
ಹಾ, ಅದರಲ್ಲಿ ಕೂಡ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ. ರಫೀಕ್ ಮಸೈಲ್ ನೆಕ್ಸ್ಟ್ ಇವನ್ ಥಾಮಸ್ ಡೇನಿಯಲ್ ದಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟೆಡ್. ದಟ್ ಇಸ್ 205 my lord, in the same
ಇದರಲ್ಲಿ
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ, ಆ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ
ಪ್ಲೀಸ್
ಡೆಸಿಗ್ನೇಷನ್ ಸ್ಪೆಸಿಫಿಕ್ ಅನ್ನೋ ಇಂಪ್ರೆಷನ್ ಬರ್ಲಿಲ್ಲ ನಂಗೆ. ನಾವು ಆಫ್ ಕೋರ್ಸ್ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಐ ರೆಡ್, ಬಟ್ ಇಫ್ ಯು ಜಸ್ಟ್ ಹೈಲೈಟ್ ದಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಸ್ಪೆಸಿಫಿಕ್ ಅಂತಿಲ್ಲ, ಬಟ್ ಯಾರಿಂದ ರಿಕವರಿ ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ರೋಮನ್ 1 ನಲ್ಲಿ, and within 1 year, then other 3
notice.
But because specifically C and D has been mentioned, that means all others are excluded. Otherwise, my lord,
he does not belong to that category.
That is not in dispute.
Higher position.
Please.
ಅವ್ರಿಗೆ ಪ್ರೆಜುಡೈಸ್ ಆಗಲ್ಲ. ಕೆಳಗಿನ ಡೆಸಿಗ್ನೇಷನ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆಲ್ಲ ಡ್ರಾವಲ್ಸ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಮೀಗರ್ ಇರ್ತದೆ. ಆ ಕಾರಣಕ್ಕೆ ಅದು
ಸ್ವಲ್ಪ ಪೂರ್ ಇರ್ತಾರೆ.
ಬೀಯಿಂಗ್ ಕೈಂಡ್ ಟು ದಿ ಪೂರ್ ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅವರು. ಏನ್ ರಿಕ್ವೈರ್ಸ್ ಇಷ್ಟಪ್ಪ ಇಷ್ಟಲ್ಲ,
ಅದು ಅವರು ಹಾಕಿದ್ದಾರೆ, ನಾವು ಸ್ವಲ್ಪ ಆಡ್ ಮಾಡಿದ್ದು ಅಷ್ಟೇ.
House of bad ಮಾಡ್ಬಿಟ್ಟಾರೆ. We have to add something. ಇಷ್ಟೇ issue.
Issue ಅಷ್ಟೇ, ಈಗ ಡಿಫರೆನ್ಸ್
How
ಮೇಲೋಡ್ ಓನ್ಲಿ
that issue, your contention is treated by the CAT.
ಪ್ಲೀಸ್. ಪೇಜ್ 52 ಮೇಲೋಡ್. Annexure A.
52.
ಸ್ಟಾರ್ಟ್ಸ್ ಮೇಲೆ.
ಇವ್ರ ರಿಪರ್ಕಷನ್ಸ್ ಏನ್ರ ಇದೆಯಾ ಜಡ್ಜ್ಮೆಂಟ್ಗೆ? ಬೇರೆಯವರಿಗೆಲ್ಲ ಅಪ್ಲೈ ಮಾಡೋದು
ಆಲ್ ಓವರ್ ಇಂಡಿಯಾ ಇದೆ ಸರ್. See, even we have already recovered from almost 85 people. That is also, I got the, and only thing is, my lord, only difference. Maybe, my lord, at that time the.
ಡಿಫರೆನ್ಷಿಯಲ್ ಅಷ್ಟೇ ಆರ್ಡರ್ ಮಾಡ್ಯಾರ ಅವರು.
ಅಲ್ಲ, whether he is entitled for fitment benefit is a question.
Because he has.
Because that order has become
One excludes.
Holding the field now.
ಅಲ್ಲ ಶೆಟ್ರೆ.
Please.
One benefit excludes the grant of another benefit ಅನ್ನೋ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಹಾ.
Since he has
But
already.
now, my lord, that withdrawal of fitment benefit order is now holding the field, my lord, for all. And now, my lord, in view of that, we have immediately we have granted him MACB because they realized.
That requires consideration, if that is so.
May I submit? My learned friend is not correct to say that, my lord, I have granted two benefits by the department. My lord, I joined the department as a, my lord, postal assistant, my lord, a third division post, my lord, in the 85. My lord, this MACP, my lord, this provides that an employee who continues to, my lord, work for 10 years, my lord, he is entitled for, my lord, a promotion. That is by way of, my lord, financial benefits. That is MACP. My lord, MACP was given to me, my lord, after 23 years of service. Otherwise, I am entitled. I have produced, my lord,
10 years you are
10 years I am entitled, but it was given after 20 years. I am entitled for second MACP. My lord, second MACP was given. My lord, thereafter what happens is, I wrote a departmental examination. It is not as if, my lord, I was promoted in usual way. My lord, I wrote the departmental examination, that is part 1, part 2, and got through in the examination. Therefore, I was promoted along with other successful candidates. I was in the 33rd place in the list of promotees. But I was promoted as assistant accounts officer. My lord, in the my lord, India government, my lord, services. That is, I was liable to all India. I'm sorry, all India service. My lord, what happened is, my lord, I am entitled, my lord, in the promoted place, my lord, 3% fitment. My lord, that was given to everybody who was promoted, my lord. And what happened is, I wanted, my lord, third MACP. Because by then I completed 30 years, and therefore I contended that I am entitled for, my lord, third MACP. But and that was denied to me, and I approached my administrative tribunal contending that I should have been given. Administrative tribunal said, had you not been promoted, whether by way of examination or in usual course, since you got the promotion, you are not entitled for third MACP. MACP is meant only to see that, yes,
did not get the promotion.
Yes. Therefore, administrative tribunal said you are not entitled, and my application was, my lord, rejected. My lord, I my lord, demitted office on attaining superannuation on 30th April 2022. My lord, I was not served with any notice of this recovery, and, my lord, the withdrawal of, my lord, the second MACP. Nothing was there. My lord, after retirement, my lord, a notice was sent to me saying that you are not entitled for this third, the 3% fitment benefit when I, my lord, promoted to the post of assistant accounts officer. And therefore, my lord, they have unilaterally, my lord, recovered 1 lakh from my salary of March 2022 and April 2022. Then, my lord, I approached the administrative tribunal saying that, my lord, the 3% fitment benefit is rightly given. I am entitled. But that was accepted by the administrative tribunal. But, my lord, what happened is, after that, my lord, they gave me third MACP. Your lordship kindly appreciate, my application seeking third MACP was rejected by tribunal. In spite of that, my lord, the department granted me, my lord, third MACP.
Only to exclude your
No,
entitlement.
No.
Ah.
My lord, in spite of my rejection of my application, saying that I am not entitled for third MSCP, they grant it to me. It was brought to the notice of the tribunal that the third MSCP was granted.
ಎರಡರ ಡಿಫರೆನ್ಸ್ ಎಷ್ಟಾಗ್ತದೆ?
My lord, that was detected, my lord.
Huh?
The tribunal detected in absence of a challenge, my lord. Tribunal said, they have wrongly given you third MSCP. I also did not, my lord, question it. And therefore tribunal detected that, my lord, 1,95,000 according to them is paid in excess to me. My lord, out of that, my lord, third MSCP granted was deducted.
ಎಷ್ಟದು?
After that is, my lord, it is worked out in the order itself.
82,000.
82,000, my lord, is the amount, my lord,
Now,
they have to return it to me.
now
85,000, my lord, the question is, my lord, another question is, that is, my lord, on facts. The next question is, assuming for a moment that it was given, my lord, wrongly. My lord, the question is whether the department is entitled to recover that. My lord, all the three judgments I have brought to the Honorable Supreme Court is, unless it is shown that that excess amount is paid due to my lord, overact, because of my lord, overact, if that amount is paid, then, my lord, they are recover, my lord, rule 67(2), etc. My lord, Supreme Court said they are entitled to recover.
That
But
weave is loosened. Your weave is loosened.
Yes, my lord.
That weave has been diluted by the subsequent judgment. They
No,
followed
no,
section
22.
72 ನ ಯಾವ್ದು ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ ಇದೆಲ್ಲ ಆ ಪ್ರಿನ್ಸಿಪಲ್ ರೀಡ್ ಮಾಡಿದ್ರು. If somebody
My lord,
is given money, it's a public money, the employee cannot contend that no, you have no right to recover that once you have given. That is diluted by the apex court to my knowledge.
No, my lord, 2022, Lordship, kindly see, I have given
22.
22. my lord.
2013 was KR Singh's soft judgment. 22
But
was,
other
22
two-
considered KR Singh also.
please, my lord.
That
That is-
judgment is also considered.
My lord, my first submission, it is not paid in excess, that we are entitlement, it is given. That is my first submission. The second submission is only.
Even
this
otherwise
alternate-
you cannot recover it.
Yes,
you are
yes, that is what I. My lord, paragraph, my lord, page.
ಮಾಸಿನೂ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
Yes,
ಅದರಲ್ಲಿ accept
Must
ಮಾಡಿ.
is considered.
yes, my lord.
Even para 11, my lord, 11 last portion, my lord.
Para?
11 ನಲ್ಲಿ
ಹಾ.
last portion, last para, my lord. Para.
My lord,
That is
page- my lord,
Thomas
page-
Daniel, my lord.
Pagination, my lord.
Pagination ಸರಿ ಇರೋದು ಎಲ್ಲ ರಿಪೋರ್ಟ್.
ಅಲ್ಲ ಅಲ್ಲಿ ತಾವು ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲಿ ಈ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ 2008 208 my lord, page number 208.
Page 3, page 3 ಅಲ್ಲಿ.
ಅದು ಪ್ಯಾರ 11 ನಲ್ಲಿ ಲಾಸ್ಟ್
Page 3
ಐ ವಿಲ್ ಜಸ್ಟ್ ರೀಡ್ my lord. We are therefore of the view that
ಯಾವ ಜಜ್ಮೆಂಟ್ ನೀವು ಓದ್ತಾ
ಅದು ಥಾಮಸ್ ಡೇನಿಯಲ್.
ನಾವು ಅದನ್ನೇ ಓದ್ತಾ ಇದ್ದೀವಿ. ಥಾಮಸ್ ಡೇನಿಯಲ್
ಪ್ಲೀಸ್
2022.
ಪ್ಲೀಸ್
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೀವು ಓದ್ತಾ
ಜಸ್ಟಿಸ್ ನಜೀರ್ ಅವರದ್ದು.
ಹಾ.
ಅದು ಪ್ಯಾರ 11 ಲಾಸ್ಟ್ my lord.
11 ಎಲ್ಲ ಪ್ಯಾರಾಫ್ರೇಸಿಂಗ್ ರಿಪೋರ್ಟರ್ಸ್ ಎಲ್ಲ ಪ್ಯಾರಾಫ್ರೇಸಿಂಗ್ ಮಾಡಿಬಿಡ್ತಾರ.
ಅಲ್ಲ ಅದು
11 is
Karnal
available
BJ
at page 3, my lord. Page 3, 11 is available on right
11.
hand side. On right hand side.
ಕರ್ನಲ್ ಬಿಜೆ ಅಕ್ಕರ ಅಲ್ಲ ಅದು
ಇಲ್ಲ
Page 4.
ಪೇಜ್
ಇಲ್ಲಿ ನೋಡಿ.
ನಮ್ ಜಜ್ಮೆಂಟ್ಸ್ ಪ್ಯಾರಾಫ್ರೇಸಿಂಗ್ ಮಾಡ್ತಾರೆ ರಿಪೋರ್ಟರ್ಸ್. ನಾವು ಯಾವ ಪ್ಯಾರಾ ಹಾಕಿರ್ತೀವಿ ಏನೋ ಒಂದು ಕಾರಣಕ್ಕೆ ಹಾಕಿರ್ತೀವಿ.
ಪೇಪರ್ ಬುಕ್
ಅದರಲ್ಲಿಯೂ ತಮಗೆ ಬೇಕಾದ ಪ್ಯಾರಾ ಮಾಡ್ಕೋತಾರ ಅವರು.
ಪೇಪರ್ ಬುಕ್ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ 208 ಅಲ್ಲಿದೆ, ಟಾಪ್ ಅಲ್ಲೇ ಇದೆ.
Paraphrasing our this way in UK, even if you put one extra comma, they will be prosecuted under the legislation. ನಮ್ಮಲ್ಲಿಲ್ಲ.
208 ಮೇಡಮ್.
208.
ಅನಕ್ಷರ A25 ಅಲ್ಲಿ 208 ರಿಲೆವೆಂಟ್.
ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಎಲ್ಲ they can come in the afternoon. Why are you keeping them as captive audience? What are your arguments? Yes, others may come afternoon. This matter will take some time because it is likely to have some repercussions. Yes. 209.
208 ಮೇಲೆ
8.
ಟಾಪ್ ಅಲ್ಲಿ we are therefore
of the
view that the respondent shall not recover any excess payment
excess payments made towards pension in
pursuance of the circular 76/99 till the issue of the clarificatory circular 11/9/2001. Insofar as any excess payment made after the circular dated 11/9/2001, obviously the Union of India will be entitled to recover the excess as the validity of.
So only discussion of law, how law has developed ಅಂತ ತೋರ್ಸ್ಯಾರ ಅವ್ರು ಅಷ್ಟೇ. Paragraph ಬೇರೆ ಇದೆ.
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಹೇಳಿದ್ದಾರೆ. If the, as the pensioners have been put on notice in regard to wrong calculation. So that is the last line. So here, my lord, as per annexure R12, my lord, we have sent him.
But para 59, my lord, in same page 59. My learned friend has not read it. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because.
ಅಲ್ಲ ಅಲ್ಲಿವರೆಗೆ ಬಂದಿಲ್ಲ ಅವರು. he is reading 12. ನೀವು ಹೇಳೋದು para 59 is below 12. ಪ್ರಕಾಶ್ ಅಲ್ಲಿಗೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅವರು. ಹೇಳ್ರಿ ಶೆಟ್ರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್.
The appellants in content that even if it were to be held that the appellants were not entitled to the benefit of additional increment, the excess amount should not be recovered from them, it having been paid without any misrepresentation or fraud on their part. The court held that appellants cannot be held responsible in such a situation and recover of the excess not be ordered, especially when the employee has subsequently retired. The court observed that the general parlance recovery is prohibited by court where there is no misrepresentation or fraud the part of the employee and when the excess payment has been made by applying a wrong interpretation and understanding of a rule. Thus, ultimately the excess amount that has been paid
even
because of any representation. So it's
Rafiq Messiah also, my lord, discussed in para 13. My lord.
State of Punjab versus Rafiq
Please,
Messiah.
there, my lord, the para 18, the recovery from the employee belonging to class 3, class 4, service or group C and D.
Hardship was to an employee, reimburse the employee and disavow these. So as between two parties, if a determination is rendered in favor of the party, the weaker of the two, without any serious detriment to the other, which is truly a welfare state, your resolve would be in consonance with the concept of justice. ಯಾವ postulate ನಾಗ ಬರ್ತದೆ ಪ್ರಕಾಶ್? para 209 ಬನ್ನಿ. In case ಯಾವ postulates ನಾಗ ಬರ್ತದೆ?
59.
Which of the postulates?
59.
ಅಲ್ಲ 59 ಮುಂದೆ ಹೋಗಿದೆ. ಅದಲ್ಲ, it's only the structuring of the judgment. Then the postulates are at page 18. How law developed ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. It is not possible to postulate all situations. Number 1. ಅಲ್ಲಿ number 1 ಬನ್ನಿ. Recovery from the employees belonging to class 3, 4. You are not. 2. Recovery from the retired employees or employees who are due to retire.
Within 1 year.
Number 2 ದಲ್ಲಿ ಬಂದ್ಬಿಡ್ತದೆ. 2 ದಲ್ಲಿ ಬಂದ್ಬಿಡ್ತದೆ. Even 2022 judge. ಅಂದ್ರೆ ರಿಟೈರ್ಡ್ ಎಂಪ್ಲಾಯೀಸ್ ತೊಂದರೆ ಕೊಡಬಾರ್ದು ಅಂತ ಎತ್ಲಾಗೂ ಆರಾಮ್ ಇರಬೇಕು.
ಹೌದು. 251 page 250
to be
ಅಲ್ಲ, he has been put on notice, my lord, 50.
ನೋಟಿಸ್ ಬರಲ್ಲ. postulate ನೋಡ್ರಿ ಹೆಂಗಿದೆ. Please come to 2. If he is retired employee, he should be allowed to enjoy retired life.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು.
ಏನಾಗ್ತದೆ, ಆ ಅಮೌಂಟ್ ಅನ್ನು ಇಟ್ಕೊಂಡು ಮದುವೆ ಮಾಡಿರ್ತಾನೆ, ಮಕ್ಕಳದ್ ಮದುವೆ ಮಾಡಿರ್ತಾನೆ, ನಂತರ ಮೊಮ್ಮಕ್ಕಳು ಬರೋ ಪಾಸಿಬಿಲಿಟಿ ಇರ್ತದೆ, ಏನೋ ಮನೆ ಕಟ್ಟಿಕೊಂಡಿರ್ತಾನೆ. ಅಲ್ಲಿ ನೀವು ಅಲ್ಟರ್ ಮಾಡಿಬಿಟ್ರೆ ಬೇರೆ ಸಮಸ್ಯೆ ಆಗತ್ತೆ. ಇಟ್ ಮೇ ಬಿ ರಾಂಗ್. ದಟ್ ಕನ್ಸಿಡರೇಷನ್ ಹ್ಯಾಸ್ ಎಂಟರ್ಡ್ ಕನ್ಸಿಡರೇಷನ್. ಅಲ್ಲಿ ರಿಟೈರ್ಡ್ ಎಂಪ್ಲಾಯಿ ಇದ್ದು ಅಂತಂದ್ರೆ ನೀವೇನ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತಾನೆ ಹೋಲ್ಡ್ ಮಾಡಿಬಿಟ್ಟಾರೆ.
ಇಲ್ಲ, ಆಕ್ಚುಲಿ ವಿ ಹ್ಯಾವ್ ರಿಕವರ್ಡ್ ಇಟ್.
ಯಾವಾಗ ರಿಟೈರ್ ಆದ್ಮೇಲೆ
ಸ್ವಲ್ಪ ಮಾಡಿದ್ವಿ.
ಅದು ವಾಪಸ್
that is March and April. I retired on 30th April.
1,95,000.
1 lakh there.
Only 1 lakh. ಇದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಈಗ ಅವ್ರದ್ದು ಕೇಸ್. ನೀವೇ ಸೈಟ್ ಮಾಡಿದ್ದು. ಐ ಡಿಡ್ ನಾಟ್ ನೋ.
ಅಲ್ಲ, ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ನಾನೇ ಅಲ್ಲ ಹೇಳಲೇಬೇಕು, ಯಾಕಂದ್ರೆ ಇಟ್ಸ್ ಅ ಲೀಗಲ್ ಪ್ರಿನ್ಸಿಪಲ್. ಐ ಕಾಂಟ್.
ಐ ಆಮ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಫಾಲ್ಟ್ ವಿತ್ ಯು. ಯು ಆರ್ ಫೇರ್ ಇನಫ್. ವಿ ನೋ ದಟ್. ಬಟ್ ಹಿ ಫಾಲ್ಸ್ ಇನ್ ಟು 2. I mean mutually exclusive. Group C and D ಇದ್ರೆ ರಿಕವರಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಂಬರ್ 1 ಕರೆಕ್ಟಾ? ಅವ್ರು C ಇಲ್ಲ, ಹಂಗಾಗಿ ಅಪ್ಲೈ ಆಗಲ್ಲ. recovery from the retired employees or employees who are due to retire within 1 year. ಅವರಿಗೂ ಬರಲ್ಲ. Recovery from the employees when the excess payment has been made for a period in excess of 5 years. Before the order of recovery is issued. ಅವ್ರು ನಿಮ್ಗೆ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿ ಆರ್ಡರ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು? ಥರ್ಡ್ ಹೋಗ್ರಿ ಪ್ರಕಾಶ್.
Yes.
Page 209.
Yes.
Third postulate.
Recovery from the employees when the excess amount has been made for a period in excess of 5 years before the order of the recovery is issued.
Order of the recovery order ಯಾವಾಗ ಮಾಡಿದ್ರು?
No, that is a 22, my lord.
22.
22.
Payment ಯಾವಾಗ ಮಾಡಿದ್ರು?
Payment, no, payment started from, my lord, when I, my lord, 2016, my lord, when I promoted.
ಹಂಗಾಗಿ ಇರುವಾಗೂ ಬಂದ್ಬಿಡ್ತದೆ.
ಹೌದು, ಅದರಲ್ಲೂ ಬರುತ್ತೆ. Long ago, it is not just.
Two and ಅದ್ರಲ್ಲಿ ಪಾರ್ಟ್ಲಿ ಬರ್ಬೋದು, ಪೂರ ಬರಲ್ಲ. ಪಾರ್ಟ್ ಪೇಮೆಂಟ್ ಹಾಕೋತಿರ್ತದೆ.
ಅಲ್ಲ, ಅದು ಥರ್ಡಲ್ಲೂ ಬರುತ್ತಲ್ಲ.
ಹೇಳಿ ನಿಮ್ಮ ಎಂಪ್ಲಾಯಿ
ಅಲ್ಲ, ನನಗೆ
ಹೇಳಿ.
ನನಗೆ that third person fitment benefit was given when I was promoted as, my lord, assistant accounts officer.
That was in the year 2016.
Yes, my lord.
Huh?
Yes.
When the payment was made.
Well, for starting, my lord, I opted for this 3% fitment and immediately.
payment
Yes, yes, granted.
In any event, it will be beyond 5 years ಅಂತ ನೀವು ಅನ್ನೋದು.
Yes.
ಏನ್ ಹೇಳ್ತಾರೆ ನಿಮ್ಮ ಆಫೀಸರ್? ಇಲ್ಲಿ 2 and 3, 4.
All amount has been recorded
2 and 3.
in the year
13, madam.
2013.
13.
ಫಿಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ಯಾವಾಗ ಅವರಿಗೆ?
ಅವಾಗ ಕೊಟ್ಟಿದ್ದು.
2013.
2013.
ಹೌದು.
Days.
ಮತ್ತೆ ಹೆಂಗಿದೆ? ಎರಡು ಟೈಮ್ ಬಾರ್ಡ್ ಆಗಿಬಿಡ್ತದೆ.
ಅಲ್ಲಲ್ಲ, ಎರಡು
209 ಬನ್ನಿ. 209 ಬನ್ನಿ. 2 and 3 ಎರಡು ಬರ್ತದೆ. Both are applicable. He is a retired employee. ನಿಮ್ಮ ರಿಕವರಿ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ಆಫ್ಟರ್ ರಿಟೈರ್ಮೆಂಟ್. ಕರೆಕ್ಟಾ?
ಅಲ್ಲಲ್ಲ, ಅದು ಫಿಟ್ಮೆಂಟ್ we have granted.
Fitment you gave in 2013.
13, my lord. Only the now recoveries, my lord, maybe. That is.
Come to 209.
209 ಅಲ್ಲಿ third.
Second and third ಎರಡು ನೋಡಿ. Second we have already discussed now. Retired employee, therefore he has some protection. Retired employee will be in the evening of his life. ಅವ್ರನ್ನೆಲ್ಲ ಟ್ರಬಲ್ ಮಾಡಬಾರ್ದು. ನಂಬರ್ 1 ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಇದೆ. ನಂಬರ್ 3 ನೋಡಿ.
ಅಲ್ಲ, ತಾವು
3 is a period of limitation.
ತಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಸಾಕು. ಯಾಕಂದ್ರೆ he has not.
Many others will be there.
Please, my lord.
We'll say that it is confined to
That is 2, my lord.
employee ಅಂತ ಹೇಳ್ಬೋದು.
2. ಅಲ್ಲ, 2 ಅಪ್ಲೈ ಮಾಡಿ ಕನ್ಫೈನ್ ಟು ಅಂತ.
3 ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ನಮ್ ಕಣ್ ಮುಂದೆ ಇದೆ ಈಗ. ಅಂದ್ರೆ ನೀವು ಬೇರೆ ಎಂಪ್ಲಾಯೀಸ್ ತೊಂದರೆ ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡಿರೋ ಏನು?
ಇಲ್ಲ ಇಲ್ಲ, ಹಾಗೇನು
ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಎಂಪ್ಲಾಯೀಸ್
ಎಲ್ಲ ನಮ್ಮ ಎಂಪ್ಲಾಯಿಗಳೆಲ್ಲ.
ಏನಾದ್ರೂ ಎಂತಾದ್ರೂ ಡಿಸಿಪ್ಲಿನ್ ಎನ್ಕ್ವೈರಿ ಕೇಳಿ, ನಿಮ್ಗೆ ಏನಾದ್ರೂ ಡಿಸಿಪ್ಲಿನ್ ಎನ್ಕ್ವೈರಿ ಅವಾಗ ಆಗಿತ್ತಾನೆ ಕೇಳಿ.
No.
At no point of time.
No,
How
but
many years of service he has put in?
My lord, I have stated so in my statement of
We
objection.
are asking, how many years of service you have put in?
My lord, from 85, my lord, I retired in 2020.
36.
36 years.
36 years he has worked. Such person should not be troubled. Broadly agree with the reasoning of the tribunal. First off, further we add paragraph, subparagraph, paragraph 18.2 and 18.3 at page 209. First off,
Of judgment
the
of
respondent
Thomas.
employee admittedly has put in more than 35 years of service, and the same is stated to be spotless. Spotless. First off, a retired employee in a welfare state who has put in a long and spotless service is entitled to be at peace. Peace. First off, in the above circumstances, petition is dismissed.
ಅದು ಪ್ರೆಸಿಡೆಂಟ್ ಆಗ್ಬಾರ್ದಂತ ಸರ್.
ಅಲ್ಲ, ಗೊತ್ತಾಗಂಗಿಲ್ಲ ನಮ್ಗೆ. ಈಗ ಇಂಥರೇ ಇದ್ರು ಅಂದ್ರೆ ನಾವು ಅವ್ರಿಗೆ ಹೆಂಗ್ ಡಿನೈ ಮಾಡೋದು? 35 ವರ್ಷಗಟ್ಲೆ ಒಂದೇ ಒಂದು ಎನ್ಕ್ವೈರಿ ಇಲ್ದಂಗೆ ಸರ್ವಿಸ್ ಮಾಡಿರ್ತಾನೆ ಎಂಪ್ಲಾಯಿ. ಅವನೇ ವಾಟ್ ಹಿ ವಿಲ್ ಫೀಲ್ ವೆರಿ ಬ್ಯಾಡ್. ಏನಪ್ಪ, ಇಷ್ಟು ವರ್ಷ ನಾ ಸರ್ವಿಸ್ ಮಾಡೀನಿ, ಈ ಒಂದು ಸ್ಮಾಲ್ ಅಮೌಂಟ್ ಅನ್ನು ರಿಕವರ್ ಮಾಡೋದು ಅದು ದಟ್ಸ್ ವಾಟ್.
ಅಲ್ಲ ಸ್ಮಾಲ್ ಅಂದ್ರೆ ನಮ್ಗೆ ಆಲ್ ಓವರ್ ಇಂಡಿ ಜಾಸ್ತಿ ಆಗಿದೆ.
ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. ನೀವು ಎಲ್ಲೆಲ್ಲೋ ಯಾರ್ಯಾರಿಗೂ ಕೊಡ್ತೀರಿ ದುಡ್ಡು, ಇವ್ರಿಗೆ ದುಡ್ದಂತವ್ರಿಗೆ ಕೊಡಿ. ಪಾಪ್ ದೇ ಹ್ಯಾವ್ ವರ್ಕ್ಡ್ ಫಾರ್ 35 years, 35 ವರ್ಷ ತಮ್ಮ ಬೆವ್ರು ಸುರಿಸಿರ್ತಾರೆ ಅವರು. ಆಮೇಲೆ ಒಂದು ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಅವನ ಮೇಲೆ, ಸ್ಪಾಟ್ಲೆಸ್ ಸರ್ವಿಸ್. ಅವರು ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಟು ರೆಸ್ಪೆಕ್ಟ್ ಎಟ್ ದ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್. ವಿ ಹ್ಯಾವ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಫಾರ್ ದೆಮ್.
ಆದ್ರೆ ಮಿಸ್ಟೇಕ್ ಕೂಡ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ. ದಟ್ಸ್
ಹಾ, ಮಿಸ್ಟೇಕು ಇದೆ ಅದು ಅಲ್ಲ. ಡಿಸ್ಮಿಸ್ಡ್. ಏನಿದೆ on that day?
In this case, your lordship,
Of the records available for.
lordship, in this case,
Be adverse influence will be drawn.
in this case, your lordship, respondent number 2 may be directed to take note. NK Ramesh may be directed to, they have to produce the document, your lordship.
ಅವ್ರ ಕೈಲಿದೆನಾ?
ಅವ್ರ ಹತ್ರ ಇದೆ records.
ಅವ್ರಿಗೆ
I have
notice
informed this-
ಹಾಕಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
My lord, I just want to tell you something. You know, I'm a hearing impaired person.
We know that you have argued other day.
Yes, sir.
You have argued very
Yes,
well.
my lord.
ಹಾ.
I have.
ರಮೇಶ್ ಅವ್ರಿಗೆ
ತಗೊಂಡ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೇನೆ ಸಮಯ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
I have.
ಮಾಡ್ಲಿಲ್ಲ ನಾವು.
ಮಾಡಿಲ್ಲ R2ಗೆ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ಕೊಳ್ಳಿ. ಯಾಕೆ ಹಂಗಾಯ್ತು? ಪಾಪ again and again he has to come to court.
My lord, I have to travel from way long from Mangalore. And it is very difficult for me to come for 10 hours journey every time to just hear one word from the court, my lord. Every time I'm getting denied here.
ಅಲ್ಲಿ coordinate bench, of course it's our bench only, still our court only. They should have issued a notice to the executive because the documents are at the hands of this person. ಅವ್ರನ್ನ ಕರ್ಕೊಂಬನ್ನಿ ಮಧ್ಯಾಹ್ನ.
ಹೇಳಿದ್ದೇನೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
Ramesh, that panel council is requested to accept notice for the second respondent. First, petitioner to serve copy of the petition on the said panel council immediately. First, ಅವ್ರನ್ನ ಕರ್ಕೊಂಬನ್ನಿ ಮಧ್ಯಾಹ್ನ.
Please, Lord.
Thank you, my lord. Thank you.
Not.
My lord, kindly, serial number 38. In fact, I had moved the matter.
Are you here? You should have gone abroad. Go for traveling. Oh, go for traveling.
But serial number, I had moved the matter.
His passport is full of seals. How many extra passports have been issued to you?
I have so far covered 100 countries, my lord.
Yes, brother.
Please.
What do you want?
My lord, I had moved the matter. Srivatsa had been engaged.
Correct.
ಮಧ್ಯಾಹ್ನ ಅವ್ರಿಗೆ ಏನೋ ತೊಂದರೆ ಇದೆ ಅಂತ. Could it be taken up next week?
Next week ಹಾಕ್ಬೇಕಾ? ಮಧ್ಯಾಹ್ನ ನೀವು ಬನ್ನಿ ನೋಡೋಣ. If there is difficulty, I will give you time. We have one part. Yes, that's ಕೊಡಿ. ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. Srivatsa was here. I saw.
Oh, yes, my lord. He was here.
He has written a very good book on law of evidence.
Yes, my lord.
Just one of the very different.
Anytime subject to your lordship's convenience, next week.
Next week ಹಾಕ್ಬೇಕು. ಯಾವ್ದಾರ ಡೇಟ್ ಹಾಕೋ. ಮಧ್ಯಾಹ್ನ NK ರಮೇಶ್ ಅವ್ರನ್ನ ಕರೆಸಿ. ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಅವ್ರು ಕರೆಸಿ. We'll tell him something. Okay.
ನಂಬರ್ ಬೇಕಾ? ಯಾವ ಡೇಟ್ ಕೊಟ್ರು? ಇದೆಯಾ?
ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ನಾನು ಮಾಡಿದ್ದೀನಿ, ಫೋನ್ ಮಾಡಿದ್ದೀನಿ, ಎತ್ತುತ್ತಾ ಇಲ್ಲ ಅವ್ರು.
ಏನ್ ಮಾಡ್ತೀರಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವಾಗ ಕೊಡಿ ಸರ್? 12th ಕೊಡ್ತೀರಾ?
So next week, after next week, ಅಲ್ಲ 19.
ಬೇರೆ ವೀಕ್
19 ಸ್ವಲ್ಪ ತುಂಬಾ ಮುಂದಕ್ಕೆ ಹೋಯ್ತು. ಆ ವೀಕಲ್ಲಿ 12th 11th ಇಂದ ಯಾವ್ದಾನ 11th ಬಿಟ್ಟು 14th
19th ಸರ್, 19th ಮೇಲೆ ಸೀನಿಯರ್ ಫ್ರೀ 19th ಮೇಲೆ ದಯವಿಟ್ಟು. ಹಾ ಸರ್, ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಎಸ್ ಸರ್.
ಬಿ ಗ್ರೂಪ್ ನಡೆಯೋದಿಲ್ಲಲ್ಲ ಈಗ ಸರ್? ಬಿ ಗ್ರೂಪ್ ಅಷ್ಟೇನಾ? ಈಗ ಬಿ ಗ್ರೂಪ್ ಲಾಸ್ಟ್ ಒಂದೇ ಇರೋದು ನಂದು. ಅಲ್ಲ ಬರ್ಲೇಬೇಕಲ್ಲ, ಎನ್ ಕೆ ರಮೇಶ್ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ.
ಸರ್ ಮಧ್ಯಾಹ್ನ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ತಗೋತಾರ ಡೈರೆಕ್ಟ್ 2:30 ಇಲ್ಲಾಂದ್ರೆ ಅದೇ ಫುಲ್.
ನಮ್ದು ಸೈನ್ ಆಗಿದ್ರೆ 2 ಸೈನ್ ಆಗಿದ್ರೆ
ಜನರಲ್ ಇದನ್ನ ಇಟ್ಕೊಂಡು ಮಾಡಿರೋದು ಅಂತ. ಸೊ ಅದು ಜನರಲ್ ಕ್ಯಾಟಗರಿ ಬರುತ್ತೆ, ಅದಕ್ಕೆ ಎಂಟೈರ್ ಕ್ಯಾರಿ ಫಾರ್ವರ್ಡ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಕನ್ಫ್ಯೂಷನ್ ಇದೆ, ನನಗೂ ಅಷ್ಟೊಂದು ಕ್ಲಾರಿಟಿ ರೆಕಾರ್ಡ್ ತಗೊಂಡು ಬಂದಿರಲ್ಲ. ಹಲೋ,
ನಾ ಇಲ್ಲೇ ಇದ್ದೀನಿ, ಟೋಟಲ್ 6 ಆಯ್ತು ಹೇಳಿ ರೆಕಾರ್ಡ್. ನಂಗೆ ಇಂದ ಫೋನ್ ಬಂತು ಇವಾಗ, ನಂಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ಓ ಆಯ್ತು ತಗೊಳ್ಳಿ.
ಹೀಗೆ ಕ್ವಶನ್ ರಿಸರ್ವ್ ಮಾಡಿದಾಗ GM ಗೆ ಹಿಂಗೆ ತಗೊಂಡ್ರಿ ಕಟ್ ಆಫ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ. ಇವ್ರು ಹೇಳೋದು
ಈಗ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಏನ್ ರೆಕಾರ್ಡ್ ಹಿಡ್ಕೊಂಬ ಇಟ್ಕೊಂಡು ಟೋಟಲ್ 6 ಹತ್ರ ಬರ್ಬೇಕು. ನೀವು ಸ್ವಲ್ಪ ಬೇಗ ಬಾ, 2 ಗಂಟೆಗೆ ಬಂದ್ಬಿಡು. ಅದು ಆರ್ಡರ್ ಇದೆ, ಆರ್ಡರ್ ಹಾಕಿದ್ದಾರೆ. ಬಟ್ ಇದನ್ನ ಪ್ರೋಸೆಸ್ ಹೆಂಗ್ ತಗೊಂಡ್ರಿ, ಇದನ್ನ ಒಂದು GM ಕಟ್ ಆಫ್ ಅನ್ನು ಹೆಂಗ್ ತಗೊಂಡ್ರಿ ಅವನು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿ.
ಎಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ನ GM ಕೋಟಾದಲ್ಲೇ ತಗೋಬೇಕು.
ಡಿಸೇಬಲ್ ನಲ್ಲಿ ಇದಾದ್ರೆ ಹೈಯೆಸ್ಟ್ ಬಂದವರು GM ಅಲ್ಲಿ ತಗೊಳ್ಬೇಕು, ಉಳಿದಿದ್ದನ್ನು ಕ್ಯಾರಿ ಫಾರ್ವರ್ಡ್ ಮಾಡಬೇಕು. ಅಂತ ಇದೆ, ಅದಕ್ಕೆ ಇದೆಯಾ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಅದೇನಿದೆ ಅದು ಹೇಳ್ಕೊಂಬರ್ತೀವಿ. ಹೌದಾ? ತೆಗೆದೆ ಬರ್ತೀನಿ ಮತ್ತೆ. ನಮ್ಗೆ ಅದ್ರಲ್ಲಿ ಇದು ನೋಟಿಸೇ ಆಗಿಲ್ಲ. ನೋಟಿಸ್ ಆಗಿದ್ರೆ ಬಂದ್ಬಿಡಿ. ಓಕೆ.
Sir, intentionally, 3 candidates secured 4 marks in general, GM, CH-06. Then 4th GM candidate. ಈಗ 4th GM candidate ಇದಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ, PH ರಿಸರ್ವೇಶನ್. ಬರ್ತಾನೆ. ಅವನದು ಮಾರ್ಕ್ಸ್ ನ ತಗೊಂಡು ಕಟ್ ಆಫ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಹಿ ಇಸ್ ಎಕ್ಸ್ಕ್ಲೂಡೆಡ್ ಅಂತ.
ರಮೇಶ್ ನೋಡ್ರಿ ಏನೋ ಒಂದು ಗ್ರೀವೆನ್ಸ್ ಇದೆ. ಯಾವತ್ತಿಗೆ ಹೋಗ್ಬೇಕು? ಐ ಹ್ಯಾಸ್ ಟು ಕಮ್ ಫ್ರಮ್ ಮ್ಯಾಂಗ್ಳೂರ್. ಮ್ಯಾಂಗ್ಳೂರಿಂದ ಬರಬೇಕು. ಮತ್ತೆ ಕರ್ಸೋದು ಬೇಡ, ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
My lord, just 5 minutes. If you
5 minutes ಅದು ಆಗಲ್ಲ, ಅವ್ರು ಉತ್ತರ ಕೊಡ್ಬೇಕು. 5 minutes ನಿಮಗೆ ಕಡಿಮೆ ಇದು, ನಮಗೆ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್, ಅಷ್ಟೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ. ನಾವು ಅದಕ್ಕೆ ಬಂದಿರ್ತೀವಿ.
ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಅದು ಇರುಡ ಒಂದು ಪಾಯಿಂಟ್ ನಾನು ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ, ಜಾಸ್ತಿ ಮಾತಾಡೋದು ಒಂದೇ ಪಾಯಿಂಟ್. ಐ ಜಸ್ಟ್ ವಾಂಟ್ ದಟ್ ಮಚ್ ಕ್ಲಾರಿಟಿ.
ಹೇಳಿ ಬೇಗ ಹೇಳಿ.
ಮೈ ಲಾರ್ಡ್, I would like to draw your attention to page number 29, para 9 there.
ಅಲ್ಲ, ಅವ್ರು ಉತ್ತರ ಕೊಡ್ಲಿ ಅದಕ್ಕೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಅವರು ಒಂದು ಫಾಲ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ.
ಈ ನೀವು ಹಂಗೆ ಹೇಳ್ತಾ ಇರೋದಕ್ಕೆ ಅವ್ರು ಉತ್ತರ ಕೊಡಬೇಕು. ಈಗ ಪಿಟಿಷನ್ ನೀವು ಕೊಟ್ಟಿರಲ್ಲ, ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡ್ಲಿ ಅವರು. ಸೊ ದಟ್ ವಿಲ್ ಕನ್ಸಿಡರ್. ತೊಳಿ ಯಾವತ್ತ
ಸಬ್ಮಿಟೆಡ್
ಕಾಪಿ ಕೊಟ್ಟು ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಟು ಕೊಡಿ ಇನ್ನೊಂದು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಬೋದು. ತೊಳಿ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ತೊಳಿ, ಚೂಸ್ ಒನ್ ಡೇಟ್. ದಟ್ ಡೇ ಅವ್ರದ್ದು ಫೋನ್ ನಂಬರ್ ತೊಳಿ. ನಿಮ್ಗೆ ಏನಾರ ಡಿಫಿಕಲ್ಟಿ ಇತ್ತು ಅಂದ್ರೆ ಮತ್ತೆ ಅಲ್ಲಿಂದ ಬರಬಾರ್ದು. ಅವ್ರು ಬಂದ್ರೆ ಎಲ್ಲ ಖರ್ಚೆಲ್ಲ ನೀವೇ ಕೊಡ್ಬೇಕು. ಅವ್ರ ನಂಬರ್ ತಿಳ್ಕೊಂಡು ಓಕೆ.
11th November.
ಕೊಟ್ಟ ಸರ್ ನೋಡ್ರಿ, 11th November ಮ್ಯಾಟರ್ಸ್ ಭಾಳ ಇದಾವಲ್ಲ. 13th November. 13th 1-3.
Not 11th.
11th already it is many matters are posted.
So 8th November.
Not Friday is very another bench. So 13th. Okay. Our number ಇಸ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆ ಏನಾದ್ರು ಡಿಫಿಕಲ್ಟಿ ಇದ್ರೆ ಮತ್ತೆ ಅಲ್ಲಿಂದ ಕರೆಸ್ಬೇಡಿ. 14%.
8310. 70. 70.
Okay.
Thank you, my lord.
All. Good. Gautam Raghunath. ಏನಿದೆ?
Lordship, what we are challenging here is Rule 9 of the teaching staff of degree colleges. Your Lordship, what has happened here is, today they're supposed to have counseling. Counseling is for transfer of those teachers who are in Zone E and bringing in new recruits. Your Lordship, in this particular degree colleges, they do not even have cadre rules, as unlike that there are for PU colleges and they have for secondary board of education, that is for schools. All of them have cadre rules. Here they do not even have cadre rules. Here what they've done is any memorandum they come up with, and then that becomes an official transfer list. Here under rule page 95, Your Lordship, which is Rule 9. Under Rule 9, we have challenged, Your Lordship.
They're all government teacher. Government.
Please. And here what happens is, this is all post of assistant professor. There is no cadre wherein from assistant professor they become, assistant professors. Before that, all of them would be,
Did you approach the KT?
we approach the KT, the lordships are saying, ಇದು ಆಗ್ಲಿ ಇವತ್ತು, ಅದಾದ್ಮೇಲೆ when you get some other transfer, at that time you be aggrieved, then you come. Your lordship, that is like a post-mortem and then saying, let the murder happen and then we will wait for the post-mortem and decide. Your lordship, of course, notice was then issued after a long pressing. Earlier, the KATs has already ordered that they had quashed before.
ಇದ್ರ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ವಿ, ಕೌನ್ಸಿಲಿಂಗ್ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಏನ್ ಮಾಡಿದೇವಲ್ಲ ಅದೇ ರೀತಿ ಮಾಡೋಣ. ಹಾ ಅಷ್ಟೇ, ಕೌನ್ಸಿಲಿಂಗ್ ಆಗ್ಲಿ, ಬಟ್ ಡೋಂಟ್ ಆಕ್ಟ್ ಅಪಾನ್ ದ ರಿಸಲ್ಟ್ ಆಫ್ ಕೌನ್ಸಿಲಿಂಗ್, ಔಟ್ಕಮ್ ಆಫ್ ದ ಕೌನ್ಸಿಲಿಂಗ್. ಎಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್? ಅದು ರಿಲೀಸ್ ಆಗಿದೆ ಇಲ್ಲ? ಅಲ್ಲಿ ತನಕ ಒಂದು ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ, ಬಟ್ ಲೆಟ್ ದೆಮ್ ಅಂಡರ್ಗೋ ಕೌನ್ಸಿಲಿಂಗ್. ದಟ್ ವಿಲ್ ನಾಟ್ ಹಾಲ್ಟ್. ವಿ ಸೈಡ್ ಇನ್ ಅದರ್ ಮ್ಯಾಟರ್ನ ಆಲ್ಮೋಸ್ಟ್ ಐಡೆಂಟಿಕಲ್. ಕರೆಕ್ಟ್. ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ಸ್ ಮ್ಯಾಟರ್ ಬರ್ಕೊಳ್ಳಿ. The subject matter of this petition is substantially similar to the one treated by us in WP number so and so between so and so, disposed of wide order dated Wednesday order ಹಾಕೋಬೇಕು 30th of November 20 October 2024, wherein the operative portion of the order reads as under. Full stop. Next paragraph. Learned AGA on request having accepted notice for the respondents. But ಇವತ್ತೇ ಕೌನ್ಸಿಲಿಂಗ್ ಎಲ್ಲ ಇವತ್ತೇ. ಕೌನ್ಸಿಲಿಂಗ್ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ ಇವತ್ತೇ?
Immediate, one day itself, they have to take charge and where they give them, your lordship. That is the difficulty.
Brother, we'll say you requested time, but we felt that this is matter is fairly covered and held, so that you are protected in that. We'll say you insisted that time should be given, but we said no. ಏನಾರ ತೊಂದರೆ ಆಗತ್ತನೋ? ಓಕೆ, ಬರ್ಕೊಳ್ಳಿ. ಹಾ, ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ಲ. All right. Issue, recall that. Issue emergent notice. First, learned AGA on request accepts notice for the respondents. Full stop. Next paragraph. Learned senior advocate Srimati so and so appearing for the petitioner draws our attention to the judgment, to our judgment in WP number so and so between so and so disposed of on 30/11/2024. Our content that reprieve as sought for in this petition has been granted to the litigants in those petitions, and therefore on parity basis the same has to be extended in view of a coordinate bench decision of this court in 1977. Other one there. So and so. First stop. Next paragraph. In view of the above, we pass the following in order. First, the scheduled counseling shall go on, semicolon. However, the result thereof shall not be acted upon till next date of hearing, called day after. Okay.
Obliged.
Very good. PD Sudan. ಸಂಪತ್ತಿ ಅದಕ್ಕೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನೀವು ಅದಕ್ಕೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? 35 ಅಡ್ಮಿಷನ್ ಇದೆ ಏನು? 39 ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದಾಗಬೇಕಲ್ಲ. 2015 ಮ್ಯಾಟರ್. ನೋಡೋಣ ಇರಿ, ವಿಲ್ ಟ್ರೈ. ಯಾಕಂದ್ರೆ ಇನ್ನು ಶಂಕರ್ ಅವ್ರದ್ದಾಗಬೇಕು, ಇವ್ರದ್ದಾಗಬೇಕು. All right. Ready. ಸತೀಶ್ ಇದ್ರದ್ದು ಸಬ್ ರಿಜಿಸ್ಟರ್ ಜಜ್ಮೆಂಟ್ ರಿಲೀಸ್ ಆಗಿದೆನೋ ಅದೊಂದು ಕಾಪಿ ಕೊಡು. 28750 ಇದೆಯಾ? ಓಕೆ. ಎಸ್. What is the next point?
Lord wanted to know under what provisions that rights of records are formed. Under what provision the rights of records are entered by the revenue officer. RR ಬಗ್ಗೆ. You were wanted the position of law. There was an act called Karnataka Land Record Rights of Act 1958.
Which is repealed under 64 Act.
64 Act. And earlier to that, there was an act of 1927.
27.
1927.
27.
1827.
Learned counsel appearing for the appellant submits that the additional documents.
RR entries, exhibit.
Listen first. We come here after reading. The documents which are sought to be produced with leave of the court in terms of application in IA number 1 of 2024 alwa 24 supported by an affidavit filed under order 41 rule 27 of CPC
1 of 23
1 of 23 CPC inter-alia comprise of certain land records and that they carry presumptive value since those entries have been made in due discharge of official duties in terms of section?
Section 4 of Karnataka.
Section 4 of Karnataka.
Records shall be maintained. Section 4, records of rights. A record shall be maintained for every village, and such record shall include the following particulars: name of the person who are holders.
With the presumptive value.
Presumptive value. Earlier to that, there was an act which is repealed. Earlier to this act,
yes,
there was a earlier act called as.
This entries ಯಾವ year ನೀವು ಕೊಟ್ಟಿದ್ದು?
ಇದು 1960 ಗಿಂತ ಮುಂಚೆ 16 ಕಾಲ.
Third act, why are you making us travel to 2 statutes? During what period these entries have been effected?
This relates to the entries. Relates to the records, the 17,545. The records the sale deed of 27.
Then both the acts are not applicable.
Pardon? Earlier to that, there was an enactment.
You show that.
That I could not trace it.
Then we cannot argue.
Library ಸಿಗಲಿಲ್ಲ ಅದು.
ನೋಡಿ ಏನಾರ ಒಂದು ಆರ್ಗ್ಯೂ ಮಾಡಿ ನಾವು
ಮಾಡ್ತೀನಿ. ಏನಾದ್ರು ಒಂದು ದಾರಿ ಮಾಡ್ತೀನಿ.
ಸುಮ್ಮನೆ ಏನಾರ ಮಾಡಿ ನಾವು
12 presumption ಬರ್ತದೆ. Earlier to that, Karnataka Land Records of Rights 1927.
27 Act.
27 Act.
ನಿಮ್ಮ ಎಂಟ್ರೀಸ್ ಎಲ್ಲ ಮಾಡಿದ್ದೆ ಯಾವ ಇಯರ್ ನಲ್ಲಿ? ಯಾವಾಗ ಆಕ್ಟ್ came into force? When your entries were made?
These entries are related to recording the sale deeds of 1927.
No. Not correct.
Bande.
Not correct. There is another act. Anterior to that act, 1927 Act.
27 Act.
ಬೇರೆ act ಇದೆ. ಅದು ಯಾವತ್ತು it came into force? When your entries were made pursuant to sale deeds. ಆ ರೀತಿ ರಿಸರ್ಚ್ ಬೇಕು.
ಅಲ್ಲ ಅದೇ the sale deed is of dated 20th. See, mortgage deed is entered of 20th/6/27. Muniyamma. Mortgage deed 27th.
Mr. Surana, if I say entries are made because it is a registered instrument. It is not the date of instrument document when it is registered, but when entries are made pursuant to that. This is how ILR 86 Karnataka 1059 Murugarajendra says. ಹಂಗಾಗಿ ಯಾವ ಆಕ್ಟ್ ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು.
I will also lay my hands to that act also. There is earlier act also. IL and RR.
ಅರ್ಲಿಯರ್ ಆಕ್ಟೇ ಸಂಬಂಧಪಡ್ತದೆ ನಮಗೆ.
ಕೊಡ್ತೀನಿ.
ಅದನ್ನ ಕೊಡ್ಬೇಕು.
Then
ಅಲ್ಲೇ ಅದು ಆಕ್ಟ್ ಸೆಕ್ಷನ್ ಅದರಲ್ಲಿ ಯಾವುದು 27 ಆಕ್ಟ್ ನಲ್ಲಿ ಯಾವ ಸೆಕ್ಷನ್ ರಿಜಿಸ್ ದ ಪ್ರಿಸಂಪ್ಷನ್?
58 ಅಲ್ಲಿ ಪ್ರಿಸಂಪ್ಷನ್ ಬರೋದು 12 ಅಲ್ಲಿ.
ಪ್ರಿಸಂಪ್ಷನ್ ಯಾವ ಆಕ್ಟ್ ಕೆಳಗೆ ಮಾಡಿರ್ತಾರಲ್ಲ
ಸೆಕ್ಷನ್ 4.
ಸೆಕ್ಷನ್ 4 ಅದು ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ಅಂತ ಆಯ್ತು. ಏನೇನ್ ಕಂಟೆಂಟ್ಸ್ ಇರಬೇಕು ಅಂತ ಆಯ್ತು. ಯಾವ ರೆಡ್ ಇಟ್.
ಆಯ್ತು.
ವಿ ಆರ್ ಆಸ್ಕಿಂಗ್ ವೆರಿ ಪಾರಿ ಮಟೀರಿಯಾ ಪ್ರಾವಿಷನ್ ಲೈಕ್ 133 ನ ಯಾವ್ದದು
27 ಆಕ್ಟ್ ಅಲ್ಲಿ
64 ಆಕ್ಟ್ ನಲ್ಲಿ ಅಂತ ಪಾರಿ ಮಟೀರಿಯಾ ಪ್ರಾವಿಷನ್ ಎಲ್ಲಿದೆ?
1963 ಆಕ್ಟ್ ನೋಡಿ ಹೇಳ್ತೀನಿ.
Under section 32 no 33 of the Indian Evidence Act 1872. First off,
Then 111(14)(e).
The Surana further submits that
presumption and 111(14)(e).
These entries were made pursuant to registered sale deed of 1927.
Registered mortgage deed.
Registered mortgage deed in 1927. And that was in the year 1927 itself. And therefore, presumptive value arises under the 1927 Act. ಆ ಆಕ್ಟ್ ನಲ್ಲಿ ಯಾವ್ದಿದೆ? ಪ್ರಿಸಂಪ್ಷನ್ ಆಫ್ ಕರೆಕ್ಟ್ನೆಸ್ ಆಫ್ ದಿ ಎಂಟ್ರೀಸ್.
Yes, I will.
ಅದು ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
I will name it.
But first,
I made a search, but I could not.
Assures the court that he would point out the specific provision under which such presumptive value would arise as to the validity of such entries. Okay.
Then kindly note that in the earlier suit, there were about 26 properties, 22 properties, X to Z and all that. Now this suit is filed only in respect of 5 properties. 5 properties.
5 properties, of which survey number 37 is also one.
37 was not mentioned in the earlier suit.
Correct. ಇದರಲ್ಲಿದೆ.
ಇದರಲ್ಲಿ 37 ಏನ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಆ ಬೌಂಡ್ರೀಸ್ ಕೊಟ್ಟಿದ್ರು ಐಟಮ್ ನಂಬರ್ 1 ಗೆ.
Correct.
But extent was only lesser than 10,010 acres. It was 7 acres, item number 1.
Correct.
Schedule A ನಲ್ಲಿ.
Correct.
Now the survey number mentioned in item number 1 of schedule in that suit was 29A.
29A.
Survey number 29A.
But boundaries except one boundaries, because one says, other day you read it, remember? Kere.
ಈಗ ಅದೇ ಸರ್ವೆ ನಂಬರ್ 29A ಗೆ ಡಿಫರೆಂಟ್ ಬೌಂಡ್ರೀಸ್ ಕೊಟ್ಬಿಟ್ಟು ಶೆಡ್ಯೂಲ್ ಇ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಶೆಡ್ಯೂಲ್ ಇ ಪ್ರೆಸೆಂಟ್ ಸೂಟ್ ಅಲ್ಲಿ
ಅದೇ ಬೌಂಡ್ರಿ ಇದೆಯಾ?
ಬೌಂಡ್ರೀಸ್ ಬೇರೆ ಇದೆ, ಬಟ್ ಸರ್ವೆ ನಂಬರ್ ಸೇಮ್ ಇದೆ. ಪ್ರೆಸೆಂಟ್ ಸೂಟ್ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಇ ಏನಿದೆ, ಸರ್ವೆ ನಂಬರ್ ಇಸ್ ಸೇಮ್, ಬಟ್ ವಿ ಹ್ಯಾವ್ ನೋ ಇಂಟ್ರೆಸ್ಟ್ ಇನ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ.
ಅದು ಬಿಡಿ, ನಿಮ್ ಸಂಬಂಧನೇ ಇಲ್ಲಲ್ಲ.
Then kindly bear in mind, he can't maintain a suit for partial partition. If he says that.
Next point. Mr. Surana submits that ordinarily a suit for partial partition qua the property is not maintainable. All right. ಈ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ರಲ್ಲಿ ನಿಮ್ WS ನಲ್ಲಿ ತೋರಿಸಿ.
WS ಅಲ್ಲಿ ತಗೊಂಡಿ ಒಂದು ನಿಮಿಷ. In this present, what we said is, these are not the properties in the property ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಆ ತರ ಹೇಳಿಲ್ಲ ಅಲ್ಲಿ.
Mr. Surana, being specifically asked, admits that such a contention, such a plea is not taken in his WS to the second suit. Next.
Then
whether even if such a plea is not taken, that can be argued in the appeal and judge. It's not question of law ಅಂದ್ರೆ invocation facts ಎಲ್ಲ ಬೇಕಾಗತ್ತೆ ಅದಕ್ಕೆ. ಅದ್ರ ಮೇಲೆ ಅಷ್ಟು ಸಿಂಪಲ್ ಇಲ್ಲ. ರಾಘವಾಚಾರಿ treats it in a very wider way. Yes. Next.
See, equities cannot be worked out if they omit the properties. In the event if they were.
Equity ಗೆ pleading ಬೇಕಾಗ್ತದೆ.
So therefore, now Kindly bear in mind.
That's that in the absence of all properties being put into the suit schedule, comma, the doctrine of equity, which ordinarily obtains in law of partition, would not be pressable. First off, we are not sure whether
Well,
equity argument can be treated in the absence of foundational pleading. Since many courts have taken that view, many high courts in the country have taken that view. Yes, next, go to next point.
Then in para 6, he says, I am not going to claim any relief in respect, seeking relief in respect of those properties. In another paragraph says, I am going to reserve to take appropriate steps in those properties.
So he has reserved right to litigate
Without-
in respect of leftover properties,
He has not sought any relief as required by Order 2, Rule 3.
First off, he further adds
Para 8 alli.
that
Para 8.
although
Plaintiff reserves.
some plea is taken by the plaintiff in paragraphs
Paragraph 6 that he is not going to claim.
6
any-
and
6 and 8.
6 and 8. Alla, 6 nalli we are not claiming at all anbutta.
Alala, we are not claiming any relief ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾ.
Property ಬಿಡೋದಿಲ್ಲ ಅವರು.
But relief on the partition suit ನಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ
ಇದರಲ್ಲಿ
ಹಾ.
we reserve our right
ಇರ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರ ಆಯ್ತಲ್ಲ.
8 ಅಲ್ಲಿ.
But they have given up their
Given up ಅಂತ ಹೇಳೋದು ಅವರು.
we are not claiming ಅಂದ್ರೆ given up ಅಂತ ಹಂಗ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ. ಅದಕ್ಕೆ ಹೇಳೋದು.
ಅಲ್ಲ.
ಮತ್ ನಾ ರೂಲಿಂಗ್ ಎಲ್ಲ ತರಬೇಕಾಗ್ತದೆ.
Seeking
ಇಡೀ
relief in
ಲೈಬ್ರರಿ ನಾನು ಬೆನ್ ಹಿಂದೆ ಇಟ್ಕೊಂಡು ಅಡ್ಡಾಡಕ್ ಆಗಲ್ಲ ನನಗೆ.
What he says is, see, it is their pleading. What they say is, the plaintiff is not seeking relief in respect of the aforesaid properties. ಅಷ್ಟೇ ಹೇಳೋದು ಅವರು. ಆಯ್ತಲ್ಲ. So see, then kindly say, a commissioner was appointed by this honorable court.
ಈ ಪಾಯಿಂಟ್ ಆಯ್ತಾ ಇಲ್ಲಿಗೆ?
ಈ points ಆಯ್ತು. Then
ನಿಲ್ಲಿಸಿ.
see,
Next.
my lord wanted to know judgments about the admissibility of these documents under section 74 of the act.
ಸಿನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ದೆ ನಾನು. ಸಿನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೆ ನಾನು. ಜಸ್ಟಿಸ್ ಮುನೀರ್.
Suit for partition is not maintainable. I rely upon one judgment of the single judge, Leonard single judge of the honorable court.
To the effect?
That
Partial partition.
partition.
All right. In support of non-maintainability of suit in for partial partition. He ಬೇಕಾದಷ್ಟು judgment ಇದೆ. Any standard book will treat that. Means Mullah.
Justice Natarajan in RFA
All right.
345 of 2019.
Okay, next.
ಆ judgments ಕೂಡ ಬನ್ನಿ. ಈಗ ಮಾಡ್ತಿದ್ದು ಬೆಳಗ್ಗೆ ಮಾಡ್ತಿದ್ದು.
Mullah treats it under a subheading itself. Partial partition qua the properties, partial partition qua the members of the family, joint family. Anyway, it's all right. Go to next point.
ಅಲ್ಲ ಇನ್ನೂ ಸ್ವಲ್ಪ
All property should be put into.
ಇನ್ನೂ ಸ್ವಲ್ಪ
Yes, pointed
ಕೇರಳ.
out 3 exceptions. 3 exception ಮಾತ್ರ ಮಾಡುವುದು, but there is not some rule and hold matter. Bombay High Court Justice Renganekar's judgment. All right, he banks upon a judgment. Nodama. Yes, okay. Next point.
These revenue document, these certified copies of the sale deeds which are produced before the court are all under Evidence Act only. Kindly have a look to section 75B.
75B.
B.
ಏನದು?
74B.
ಓದಿ.
74(2). Public records kept in the state of the private documents are also public documents under 74(2).
Public records of private documents are also
Public documents under section 74(2).
ಹಂಗೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ರು. ವೆದರ್ ಸೇಲ್ ಡೇಟ್ಸ್ ಇನ್ಕ್ಲೂಡ್ ಆಗಲ್ಲ ಅನ್ನೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ ಅಲ್ಲಿ.
I'll give that judgment. Then under section, no, under section 77, the production of the certified copies of sale deeds are included. The certified copies are public documents that are included. I'll give judgments. Under section 77 ಅಲ್ಲಿ
ಅಂದ್ರೆ ಅದಕ್ಕೆ ಪ್ರೂಫ್ ಬೇಡ ಬೇಡ ಅಂತೀರಾ? ಸಾಜೂಮ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಸೇಲ್ಡ್ ಇದೆಯಪ್ಪ, ಅದಕ್ಕೆ ಫಾರ್ಮಲ್ ಪ್ರೂಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬೇಕಾಗಿಲ್ಲ, ಒರಿಜಿನಲ್ಗೆ ಬೇಕಾಗತ್ತೆ. ಇನ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸಿಗೆ ಬರಲ್ಲ ಅಂದ್ರೆ ಎಂತದ್ರಿ?
See,
It has to be.
if the
If you
executed,
produce original, you have to lead the evidence to show that there is due execution of the concerned document. You mean to say certified copy of that document can be admitted to evidence without formal proof of execution? That will be illogical, to say the least.
no, your lordship wanted to know what are the on the point.
Adhe,
therefore
padi.
I'm putting it. Under section 77, ultimately it is my lord to take a decision. Under section 77, such certified copies may be produced
Correct.
in proof of the contents of the public document or the parts of public document which are permitted the copies.
ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್ಗಳು.
ಆಯ್ತಲ್ಲ,
ಆ
77.
interpretation ನೀವು
Now-
ಹೇಳಿದ್ದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿದೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
I rely upon 1996.
ಪಡಿ. For the proposition,
That certified copies can be read upon
certified copies of
the registered documents
without formal proof.
without formal proof.
ಹಂಗಿದೆಯಾ?
ಒಂದು ನಿಮಿಷ ಬಂದೆ ಹೆಡ್ ನೋಟ್ ಬಿ ದಲ್ಲಿ even presumption can be drawn on 90 ಅಂತ ಹೇಳ್ತಾರೆ, provided if you lay down the footing for leading secondary evidence. Para 17.
ಅಲ್ಲಿ ಬೇರೆ ಮುಂದೆ ಏನಿದೆ ನೋಡಿ, ಕಂಡೀಷನ್ ಹೆಂಗಿದೆ.
These are the,
ಹಾ,
in this case, the sale certified copies are produced. Registered sale idea. Para filed then, thereafter sold and transferred the lands and things. These are all relating to the sale of the properties only. Para 10 ಹೇಳ್ತಾರೆ. Goswami, Mr. Goswami has submitted that when the suit was filed in the 81, the document of sale deed executed by plaintiff number 1 in favor of Holy Ram in 1950 was more than 30 years old. ಅದಕ್ಕೆ even certified copies presumption ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ 17 ಅಲ್ಲಿ.
ನೋಡಿ, come to the last part of para 16, last page ಗೆ ಬನ್ನಿ. ಅದೇ 30 years old ಇರಬೇಕು. ಎರಡು ಆಪ್ಷನ್ ಇದೆ. ಒಂದು, if the original is produced which is more than 30-year-old coming from proper custody, court may presume, not shall presume, number one. Number two, where you are producing certified copy of the original, that again is coming from the proper custody. That itself is 30-year-old.
The certified copy should be also.
Otherwise meaning ಆಗಲ್ಲ.
No, reason is a registered down. The registered documents can be produced before the court and proved before certified copies because the originals are not available. Now secondary evidence can be led and rectified. When secondary evidence is led and proper foundation is laid that we don't have the originals. In that circumstances, see under section 77.
Where have you pleaded all that in your application?
I have said we don't have the documents.
ಅಷ್ಟು ನಡೆಯಲ್ಲ. I don't have the document ಅಂದ್ರೆ, these original documents are not available with me. They are with XYZ. They cannot be called to come and deliver the documents. ಇದೆಲ್ಲ ಫೌಂಡೇಶನಲ್ ಆಗಿ ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಹೇಳಿ.
Then I will file the additional proof tomorrow.
ಏನಾದ್ರು ಒಂದು ಮಾಡ್ಬೇಕು.
I will file the additional report tomorrow.
ಅಲ್ಲಿ ವುಡ್ರಾಫ್ ಅಂಡ್ ಅಮೀರಲಿ ಆ ರೀತಿ ಬರ್ದಾರೆ ಅದರಲ್ಲಿ ಕಮೆಂಟ್ರಿಯಲ್ಲಿ.
Now, these documents which are certified copies are themselves or admissible. There is one more judgment of Supreme Court. 19.
Certified copies
of the public documents. Private documents which are in the domain of the public, in the domain of the custody of the public officer. Say, for example, the certified copies of the statement of account filed by the companies, which are in the public domain. 2012, Supreme Court, page 31.
ಎಕ್ಸ್ಟ್ರೀಮ್ ಆಗ್ತದೆ ಮಿಸ್ಟರ್ ಸುರಾನಾ. ಸಪೋಸ್ ಸರ್ಟಿಫೈಡ್ ಬೇಡ, ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ, ಸೇಲ್ ಡೀಡ್ ಅನ್ನ, ಫಾರ್ಮಲ್ ಪ್ರೂಫ್ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಬೇಡವಾ?
In the case of registered document,
It's a registered document only,
So,
sale deed.
in the case of registered document, unless the challenge is made by the executant, formal proof would not be necessary. Under 60, if it is a case of registered document, unless there is a formal denial of the execution of document itself.
Proof ಬೇಕಾಗುತ್ತೆ. It may be admissible, it may be relevant. It becomes admissible under section 5258 of the Evidence Act. Document. Relevancies under 5258 ಇದೆ.
69 ಅಲ್ಲಿ proviso.
Question of evidence act. Evidence ಇದು proof of execution ಬೇಡ ಅಂತನಾ? Our impression is exactly contrary. Convince us.
Yes.
Enlighten us.
Kindly have a look to section 68 proviso.
ನೋಡಿದೀವಿ ನಾವು ಅದನ್ನ. ಆ ಸೆಕ್ಷನ್ ಬೇರೆ ಮುಖವಾಗಿ ನೋಡಿದ್ರೆ ಅದೇ ಅರ್ಥ ಕೊಡ್ತದೆ ನೀವು ಹೇಳ್ದಂಗೆ.
ಅದು.
ಬಟ್ ರೂಲಿಂಗ್ಸ್ ಹಂಗಿಲ್ಲ.
Provided it shall not be necessary to call attesting witnesses in proof of the execution of any document.
ಅದು ಅವರನ್ನ ಕರೆಯೋ ಅಗತ್ಯ ಇಲ್ಲ ಅಂತ.
ಹೌದು.
Dispensation of
Formally, formal evidence.
Section gives limited exemption. That is, you need not call the attesting witness.
The formal proof, the question is, the formal proof, if it is to be insisted, only question is the matter has to go back for recording evidence, either for a limited purpose of recording evidence in trial court or by recording evidence by the registrar of the honorable court. 2012, page 31, I will just pass on a minute. Page 14 only, para 14.
The company documents ಅನ್ನೋದು.
The statement of accounts filed before the registrar of companies.
There aspects of it. Proof is not necessary. ಅವರು ಹೇಳೋದೇನು? These are the politics, the character of public office. Copies of private documents which are in public office partake the character of public documents. ಅದು for limited purpose ಅಂತ ಹೊರಡುತ್ತೆ. ಈ proof and execution.
ಕೊಡ್ತೀನಿ ಅಲ್ಲ.
ಮಿಸ್ಟರ್ ಸುರಾನಾ.
ಆಯ್ತು, ಸಾರಿ. ಮೊನ್ನೆ ಬಂದಿಲ್ಲ ಮಾಲೆ ಅವರು. I will give you a copy, no problem. So the statement of accounts filed before the registrar of companies, certified copies are admitted because it is maintained by public document.
Mr. Surana repeats that the private documents, when their copies are, the copies of private documents kept maintained in public office partake the character of public documents themselves, and therefore proof of execution thereof is not a sine qua non for their admission to record as a piece of evidence.
Para
Support
14.
of that, he banks upon
2012 AR, page 31.
AR 1996, SC 1253, paragraph 16. And AR 2012, SC page 31, paragraph 14,
Paragraph 14, yes.
Paragraph 14. Please read 14. They
That what-
refer to the provisions of the Companies Act.
Yes, plus 74(2).
That is addition, no, see, how are you going to take out the ratio decidendi of addition?
74(2) also is referred.
74?
2 of the Evidence Act. Plus
Correct.
75.
Correct. We are not denying that.
Yes.
How are you going to take the ratio decidendi of a decision? Rupert Cross in Precedent in English Law, he says, what all the factors that counted with the court in articulating the premises which emerges as a ratio should be looked into. Here, not only Evidence Act, they specifically refer to the Companies Act.
Yes, kindly have my landlord. In the Registration Act, the documents are compulsory registered under Section 17 of the Act. When the registration take place, the same copies are copied down in the registers maintained by them. Those the authenticity of the registers are all official acts, which can't be doubted at this stage of the point.
Cannot be doubted so far as they are faithfully and truly copied into its
Yes,
registers.
therefore,
That's all.
that's all.
But it doesn't vouch for that the same person who executed the document was
Executed it.
there and he voluntarily did it.
Yes.
It
Now,
doesn't vouch for his acts.
now the question is, therefore,
It acts only in respect of the duty performed by the public servant
Sir,
in that
now
office. That's all.
the document purpose to say that this particular person is executed the sale deed. Now, the revenue entries are made in support of that. Revenue, the RRT extracts are produced, revenue is made. The persons are in possession of property. A commissioner is appointed this honorable court to find out what is the position of the exact nature of the property as on today. The commissioner has given the report.
The question answer, you are traveling astray. We are asking you, in almost, it's a common knowledge actually. In any suit founded on a title deed, title deed being compulsorily registrable and is so registered, do you mean to say you need not vouchsafe the execution of the said deed at all?
No, see,
It is
if
required.
a formal evidence is necessary, therefore made a submission, that a formal evidence can be recorded either by way of
Or
that
report can be called for.
that is one aspect of the matter. That is another aspect that, see.
In the alternative, Mr. Surana submits, if the court comes to the conclusion that the documents, additional evidence in respect of which leave is sought for under IA 1 of 2023, filed under Order 41, Rule 27, either court itself may record evidence for proving the execution of the private documents which otherwise carry public character, or court may call for evidentiary record at the hands of trial court.
Now, so far as the documents already marked, that is sale deeds executed by Krishnappa, that is exhibit P13 and P27, P33 and P18, it is not challenged that so and so person has not executed. There is no dispute that so and so person has not executed.
Not disputed.
Cross examination yellow dispute ಮಾಡ್ತಾರೆ.
Exhibit P.
Exhibit D13,
D13 and D30.
D33 and D18.
Right hand side, ನೀವು ಕೊಟ್ಟ ಇದರಲ್ಲಿ right hand side.
ಅದು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ನೀವು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು, we are recollecting from our memory.
Yes.
The chart which you had given
Yes,
other
yes,
day,
yes.
on the right hand side ಇರೋದಾ?
Right hand side ಇರೋದು D13, D27, that is executed by Krishnappa.
D13, D27, yes.
Executed by Krishnappa. We purchased the properties under D33 and D18.
The left hand side.
Left hand side.
No, for our reference it is.
If it comes into province of judiciary, we have got transfer. At the threshold, I am objecting it for this reason.
I am not,
Part of the part. And my letter, he is admitting, Mr. Surana is admitting, Surana is giving evidence and not the party. There is no evidence in the trial court. So we should have to control from there. Whether this,
this is only a compilation, no, this is only a compilation of the facts, sir, which is evidence on record. No, I am not, see, please don't go to it, please. Sir, no, I think it.
Your lordship.
I am only referring to the documents already on record. I am only referring to the documents already on record.
And I have taken the floor earlier, therefore permit me to continue. Well, the evidence that is available can be discussed. The evidence which is it has to be, your lordship have to critically view it to see whether there is error of procedure. Can you look at section 99 CPC? Unless it affects the jurisdiction, unless it affects the result materially. Well, these are the reasons where constraints on the first of report and section 93 is set out in section 99 of the report. We are ignorant of that section, and at least I reminded myself that I am not blown away from this stormy arguments. Well, it could be brainstorming, it could be brain teasing or brain chasing. Which one is, I am not sure.
This chart is not a evidence of new evidence. Only a chart
ಅಷ್ಟೇ
with-
ಕೊಟ್ಟಿದ್ದೇವೆ
only-
ದಿಸ್ ಇಸ್ ಅವರ್ ಸಬ್ಮಿಷನ್ ಅಂತ ನೀವು ಹೇಳಿ.
This is our only a chart prepared on based on the documents placed on record by way of 41, 27 and documents which are already marked at D series. That's all. Now there is no challenge to these sale deeds.
Go to the next point.
A commissioner is appointed with Honorable Court. And a report is given by the commissioner on 8/9/2017.
ಏನಂತ?
Reporting the nature of the construction existing on the property.
Nature of construction
Existing on the property.
I think how that comes to the aid of the court.
Now, the purchasers from Krishnappa, they have also put up construction over the property.
ಅದು ಕಮಿಷನರ್ ಹೆಂಗ್ ಹೇಳ್ತಾರೆ ಅದ್ರ ಬಗ್ಗೆ?
That is
ಅಲ್ಲಿ structure
37(2).
ಇದೆಯಾ ಇಲ್ಲ? ಅಲ್ಲಿ ತಾಜ್ ಮಹಲ್ ಇದೆಯಾ ಇಲ್ಲೋ ಅಂತ ಹೇಳಕ್ ಬರ್ತದ ಅವನಿಗೆ. ಇದನ್ನ ಯಾರು ಕಟ್ಟಿ ಶಾಜನ್ ಕಟ್ಟಿದ್ನೋ ಇನ್ನೊಬ್ರು ಕಟ್ಟಿದ್ರು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ಅದು.
These are the facts which are there.
ಅದು ನಿಮ್ಮ ಕೇಸ್ ಅಡ್ವಾನ್ಸ್ ಕೊಡೋದು.
The Krishnappa sold the property, Venkatappa, he died. His LR's names are recorded in the mutation registers.
Next point.
Therefore, looking from any angle, the suit for partition ought to have.
Respect of this property could not have been decreed. Correct. He concludes his argument by submitting that in respect of suit scheduled property, especially that is land in survey number 37.
Extent of 6 acres, 16 guntas.
Acres to the extent of 6 acres.
16 guntas.
16 guntas could not have been decreed at all. All right.
Then, see, I have produced the documents, the sale deeds which are there. The sale deeds now I have produced with Narayan Shetty and others. It is referred to in the exhibit D33.
ಇದಕ್ಕಿಂತ ಮೇಲ್ಗಡೆ ಬರ್ಕೊಳ್ಳಿ. The copies, certified copies of sale deeds
of Muniamma,
which are sought to be placed on record with leave in terms
more
of
particularly sale deeds in favor of Muniamma.
application in IA number 1 of 2023.
Alala, D33 already marked. D33 already marked.
This document
Yes,
is referred in D33 is your case.
Yes.
ಮತ್ತೆ ಬರ್ಕೊಳ್ಳಿ. Is more particularly the sale deed dated
20th 9/65 of Muniamma is referred.
Sale deed dated
Executed by Muniamma in favor of Gopal Reddy's vendor. Gopal.
ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದ
One of the sale deed. One of the sale deed.
Date ಹೇಳಿ.
Sale deed dated 20th 6 1965.
20 June 1965, executed by
Muniamma
Srimati Muniamma
in favor of this Krishna Reddy versus Dodgud Reddy.
In favor of Krishna Reddy, son of Dodda Gureddy.
Who has sold the property in favor of the Gopal Reddy in exhibit D33.
He is referred to in exhibit
D33,
in exhibit D33, which is sale deed dated
24/6/1971.
24/6/1971. And therefore, the formal proof may be dispensed. The subsequent deed having been proved.
Now, the plaintiffs have not produced.
I'm asking one question now. Where a particular document is proved and it is admitted to evidence, that document refers to other compulsorily registrable documents. If this document is proved, does it go to ipso facto proof of referred documents? What's the law on the point?
The existence of the document can be presumed. Existence
Only
of
to
document-
that extent.
Existing document can be presumed.
The other proof of the document, the existence of such a document can be assumed.
And when the document become ancient, many times it not be available for the person. It dies into the memory of the time. When I made my submission before in the forest case, I gave 2 judgments Supreme Court, where the documents goes into the memory. These registered instruments carries the presumption. Kindly bear in mind, one more aspect is, in the evidence of the plaintiff, he does not know as to when Chinnappa acquired the property.
When
When Chinnappa acquired the property.
Chinnappa alias Chinnaya,
Chinnanna. And he does not know as to how the properties have been transferred from time to time. No evidence is there.
ಅದ್ ಯಾರು ಹೇಳ್ತಾರೆ?
Simply, he says, I don't know how Chinnappa acquired it.
ಇದು ನಿಮ್ದು ಇದು second part.
Only the trial court only goes by the RTC extract and says Chinnappa's name is there, therefore I decree this suit. The trial court, though rely upon RTC extract to say Chinnappa was the owner of 10 acres 10 guntas, but he ignores the fact that entries are subsequently made in the RTC extract.
Yes. ಅಲ್ಲ ನಿಮ್ದು second part of the argument.
And the trial court does not disbelieve my sale deeds. What the trial court says is, these sale deeds under which I have purchased the property, it may become a nucleus for the family. That is the way it will become a nucleus for the family. That is the way in which the trial court looks into my sale deeds.
ಬಟ್ ನಿಮ್ ಏಜ್ ನಾ ಕೇಳಿದೆ ಅವತ್ತ ನೀವು ಹೇಳಿದ್ರಿ 28 ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ 29 ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ನಿಮ್ ಇನ್ಕಮ್ ಏನಿತ್ತು ಅಂತ ನಾವು ಕೇಳಿದ್ವಿ.
Therefore, I have relied upon one Supreme Court judgment. Unless the plaintiff places an evidence on record that there was a nucleus available to purchase the property, no evidence need be necessary. That is one of the judgment I will. My lord has recorded that also.
ಹಾಗಾಗಿ that will pale into that question will not be relevant at all.
Because when they come to the court, my lordship on the other day, that there is no presumption that the family, though joint, has a joint family property. The person who says it is joint family property has to show that it is joint family property. When the sale deeds are produced before the court, sale deeds are not disputed. And trial courts does not say that these sale deeds are not valid. Trial court only says under these sale deeds, the property will become joint nucleus. Such a finding cannot be recorded.
In the absence of proof of nucleus.
Please, there is no pleading at all. See, may I recollect my judgment?
ಅದು ಬಿಡಿ, well established. Means on Hindu law treats that.
And there is no pleading at all. It is only says, I took the revenue records, my name, Chinnappa's name is found, therefore I say it is joint family property. That is the way in which the plaintiff comes to the court. And the trial court also relies upon this revenue document, say it is joint family property. But trial court ought to have looked into the revenue, very same documents on which it relies upon, that entries are made.
In favor of Chinnaya.
No, in favor of the purchasers.
Purchaser. From the days of Chinnanna.
Muniamma's name is found. There are Muniamma transferred the property, their names are found. Krishnappa transferred the property, their names are found.
Gureddy's name is found. Krishna Reddy, son of Gureddy, is none other than Krishnappa, son of
Krishnappa, son of Chinnappa.
Krishnappa.
Krishna Reddy and Krishnappa, son of Chinnappa, are one and the same. What they say is, they say Chinnappa is son of Gureddy. Sorry, Nanjudappa. But revenue record says the Krishnappa is, this Chinnappa is son of Gureddy, Gurappa, alias Gureddy.
All right. Yes, no, ಅವ್ರೇನ್ ಹೇಳ್ತಾರಂತ.
Few more judgments are there on this point about the admission register said it. I'll give it. Reply statement. Have pen in there. Pen in there.
ಅಲ್ಲಿ ಒಂದು ಆ ಸೆಕ್ಷನ್ ಪ್ರಾವಿಸೋ ಓದಿದ್ರಲ್ಲ ನೀವು, the
68
attestor need not be called ಅಂತ.
Attestors need not be called
ಅಷ್ಟೇ. That does not dispense with proof of execution.
That is
Otherwise,
now,
where was the need for such a proviso?
very well. Now the executants are no more. We will leave for
sorry. One way of
that is true.
saying,
And therefore, I make it say, I am not say that this must be the position of law. The position of law is to be declared by the court.
all right.
In the event the court feels that formal proof is necessary, we will permit us to lead the evidence. That is my prayer before the court.
The old Act 1927 Act.
I will trace it. Today I will trace it.
Yes, sir. It is over now. It is full stop. He can give that act, he can give. Act does not need proof. Section 5 of the Evidence Act says, evidence can be led to prove the facts in issue and the facts relevant to the facts in issue and nothing else.
8 and 9.
5.
8
Section 5
9
of the Evidence Act. 8 is different, 9 is different. They are different. 5 says like this. Only exception is Magna Carta, where House of Lords permitted Attorney General entering the witness box and telling that the Magna Carta is a piece of legislation, statute. That's the only, there is one more, one the Tanzania court, the other one. Anyway, all right. Please, on ಮಾಡ್ಕೊಳ್ಳಿ. Okay, on ಮಾಡ್ಕೊಳ್ಳಿ. You want to say something? You want to add anything? In you are adopting his argument. ಹೇಳಿದ್ರಿ. all. ಇವ್ರಿಗೆ ಈಗ ಹೇಳಿದ್ದಲ್ದೆ ಬೇರೆ ಏನಾರ ಆಡ್ ಮಾಡಂಗಿದ್ರೆ ನೀವು ಮಾಡ್ಬೋದು. ಓಕೆ. ಅಲ್ಲ ಅವ್ರು ಮತ್ತೆ okay. Learned counsel appearing for respondent number, appellant number 1B2, 1E broadly adopts submission of learned counsel Sri Surana. However, reserves right to reply to the submission to be made by the appellants in the cross objections. Okay. Yes, sir. ನಾವು ಸ್ವಲ್ಪ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ಯಾಕೆ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ, ಒಂದು ನಾವೇ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ಏನ್ ನಡೆದಿದೆ, ವಾಟ್ ಈಸ್ ದಟ್ ಲೀಗಲಿ, ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್ ಇನ್ ಲಾ ಅನ್ಕೊಂಡು ಒಂದು. ಅನದರ್ ಈಸ್ ದೇರ್ ಆರ್ ಮೆನಿ ಯಂಗ್ಸ್ಟರ್ಸ್ ಅಂಡ್ ಇಂಟರ್ನ್ಸ್ ಅಂಡ್ ದೇರ್ ಪ್ರೊಫೆಸರ್ಸ್ ಕಾಲ್ us and tell, please have some discussion so that our children will learn. And they treat us also as children is another thing. Only for that reason, a little time is perhaps not
I saw the
wasted but invested. Yes.
I saw the honorable bench making copious notes of his submissions and also making record of the fact so that we do not retract from it.
Correct.
To save that situation,
Correct.
to avoid your lordship's exerting in this behalf, we have filed written submissions. One.
Yes.
So that your lordship will have to.
ಕೊಡಿ written submissions ಕೊಡಿ.
The written submissions.
We'll go by that now, one by one.
Really.
ಇದು ಫಸ್ಟ್ ನೀವು ರಿಪ್ಲೈ ಕೊಟ್ಕೊಂಡು ನಿಮ್ಮ ಅಪೀಲ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಿರೋ ಅಥವಾ ನಿಮ್ಮ ಅಪೀಲ್ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಇದಕ್ಕೆ ರಿಪ್ಲೈ ವಿಚ್ ಎವರ್ ವೇ ಯು ವಾಂಟ್ ಟು.
Then I think it's comfortable for me to argue the cross objection.
Well,
And
then
it comes in a very narrow compass and then
Very
say, meet the stormy arguments. Cross objection. The opening submission, which is recorded by the Honorable Court, is that apart from suit item 1, he would not dispute the claim or entitlement of plaintiff. If I have heard your lordship's dictation.
Entitlement of plaintiff to
Entitlement of plaintiff
other
to
than
other
37.
properties.
6 acres, 18 guntas.
What I said is, I am not at all concerned with those properties.
That's what.
So,
That's what. You have nothing to do. Even if that property is taken and put into Kaveri water, you have no grievance.
no grievance.
Very well.
It is at, if there are available for him, he can do it.
SP Shankar, learned senior advocate appearing for the appellant in the cross objection. So and so begins his submission stating that the whole grievance of the appellant represented by Surana and Shri so and so appellants is confined to the land in survey number 37 at measuring 6 acres, 18 guntas. Correct? 18
Yes.
guntas, full stop.
And he would not.
Surana straightway agrees to that. Yes. ಇಲ್ಲೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡೋದಕ್ಕೆ ಹೇಳ್ಬಿಟ್ಟೆ ನಾನು.
To this limited extent, to this limited extent, qua the suit schedule properties, the cross objections may be allowed. To this limited extent, qua the suit schedule properties, the cross objection requires to be allowed.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರ ಅವ್ರು ಕೆಳಗಿನವ್ರು? ಚೆಕ್ ಮಾಡಿದಾರ?
Reject ಮಾಡಿದ್ದಾರೆ.
In respect of those
Yes,
properties. On what ground? On what ground?
I took pains to go through it quite a few times. I could not find out the reason for rejection. My lord, the way in which they kindly look at the pan of litigation. It has spread from so many years. 40 years we are in court.
It will be over within 2 weeks perhaps.
That's the
Once
hope.
for all, we'll put an end to that.
Therefore, the plaintiff has real difficulty in this situation. Kindly look at the present situation, my lord. Earlier, the suit was filed by the
Submits
brother.
that. He submits that. Since the appellants in companion appeal in RFA 1433 of 2014 has no claim or objection whatsoever in respect of item numbers 2 to 5,
2 to 4 or 5.
Granted A and D.
Trial court has granted A and D.
No, ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು cross objection ಇದಕ್ಕಿದೆ ಅದು.
BC and B and C.
BC and E.
BC.
In respect of
Item ಹೇಳ್ಬೇಕು.
all properties
Other than
comprised in
37 over.
all properties other than survey number 34,
37.
comma, suit has to be decreed.
That's the first submission I make to the Honorable Court. Second is,
Yes.
in respect of survey number 37, as late as the year 2005, when they sought conversion and plan and other things, they have called it as 37 only and not 37 over 1.
ಗೊತ್ತಾಗಲಿಲ್ಲ. Identity of property ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
The developer who has purchased it has approached the authorities with that application for with this assistance. I can't argue.
ಸಂಪತ್ ಒಂದು ಬೇರೆ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ತೊಗೊಳ್ರಿ, ಕಾಯ್ಬೇಡ್ರಿ ನೀವು ಪಾಪ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಗೊತ್ತಾಳಿ, ಯಾರು ಮತ್ತೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರ್ದು. ನಾವು ಅವ್ರೊಬ್ರಿಗೆ ಕರೆದೇವಿ, ಬಿಕಾಸ್ ಹಿ ಇಸ್ ಎ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್. ರೈಟ್, ನೋಡಿ ಒಂದ್ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಹಾಕ್ಬಿಡ್ರಿ.
If there is
Yes.
no assistance, I'll sit down.
21st
Show me,
of,
I've got to argue.
Ah. Other matters we may not take, we do not know, because other matters may not reach also.
Volume 3 na idu?
Yeah.
Please
If
turn to
you are not here, we will not damage any of your matters.
2-3 documents are there, show me. Please turn to page 7, 8, 9.
7, 8, 9 of volume 1, na?
Volume 3.
Volume 3.
This is the order of the government
789.
under section 95, 95(4) and 95(7).
789.
9, 7, 8, 9.
Exhibit D46,
D46.
ಏನಿದು?
Conversion order.
In respect of 37.
37. They all along, there is, the story is, I'm using the word story. The story is, there's an earlier partition, it is 37 is folded and 37 more is there. And it is 37(1) which is a part he is claiming. My lord has recorded it, and in my earlier submission also, he doesn't have a claim in respect of the property, suit schedule property, other than 37(1). Is the recording done? No. On the submission of the advocate.
37/1 is 6 acres, 18 guntas.
37/1 and 37/3.
Yes, yes.
There was a 40 were done. Thereafter, there was some dispute.
When the part, in the present case, the witnesses are mute, dumb, and I'll spare the third adjective. The way in which the submissions are made at the bar, I do not know who is the party. So therefore, I am requesting my lord's kind attention to this fact, namely, what is claimed by the appellant is 37/1, 6 acres and the thing. Kindly look at D46, which refers to 37 and not 37/1.
This is 1 acre, 30 guntas and 2 acres.
Yeah, 2 acres.
So 1 second. Total is 10 acres ಏನೋ ಇತ್ತಲ್ಲ ಅದೆಷ್ಟು?
10 acre, 9 acre, 21 guntas is
9 acres, 21 guntas
plus Karnataka ಸೇರಿ 10 acre, 10 guntas ಆಗುತ್ತೆ.
1 second. 6 acre, 18 guntas plus 1 acre, 30 guntas will be 7 acres.
So far as that is concerned, let me complete. I will point out from the RTC itself.
ಅಲ್ಲ ಅದಲ್ಲ ನಮ್ಗೀಗ ಇದು ಈ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದು ಅಂತ ಕೂರಿಸ್ತಾ ಇದ್ವಿ ಬೇಸ್ಡ್ ಅಪಾನ್ ಏರಿಯಲ್ ಎಕ್ಸ್ಟೆಂಟ್. ಆಫ್ಟರ್ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಮುಗಿದ್ರೆ ಆಯ್ತಪ್ಪ. ಇದರಲ್ಲಿ
6 acres,
18 guntas.
6 acres, 16 guntas.
7 acres, 30 guntas. Means
6 acres, 16 guntas.
8 acres.
ಅಲ್ಲ.
ಒಂದು ನಿಮಿಷ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದ್ಸಲ ಮಾಡ್ಬೇಕು. 8 acres, 6 acres, 18 guntas plus 1 acre, 30 guntas. That is 7 acres, 18 guntas plus 30 guntas.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಸ್ವಲ್ಪ ಇರಿ. We are better in mathematics, please. It's 8 acres, 10 guntas.
8 acres, 8 guntas.
8 guntas ಆಗ್ತದೆ. Plus ಟೋಟಲ್ 2 acres ಕೊಟ್ಟ.
ಅಲ್ಲ ಇದರಲ್ಲಿ 46 ಏನಿದೆ ಇದ್ರಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಆಗಿರೋದು portion of 6 acres, 16 guntas belong, which was purchased Gopal Reddy. There are two portions. 6 acre, 13 guntas purchased by 16 guntas purchased by the Gopal Reddy under 2 sale deeds. 3 acre, 5 guntas sold by the Krishnappa. It comes to 9 acres, 21 guntas.
ನೀವು ಅನ್ನೋದು ಎಕ್ಸಿಬಿಟ್ D46
Is a
comprises
part of the land
part
purchased
of your property.
our property. ಅದರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ.
All right, let's come to that. Okay.
The right of an
ಅಲ್ಲಿ ಒಂದು
advocate to
ಸೆಂಟೆನ್ಸ್
refuse
ಆಡ್
reply
ಮಾಡಬೇಕು. ಮೊದಲನೇ ಸೆಂಟೆನ್ಸ್ therefore decree
is
should
not
be
to be
granted
diluted.
ಇದೆಯಲ್ಲ ಅದ್ರ ಒಂದು ಸೆಂಟೆನ್ಸ್ Mr. Surana adds that the that cannot be done in as much as
ಇನ್ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ನೋಟ್ಬುಕ್ ಹೇಳುದಾ
his land, part of his land is comprised in the lands in respect of which now decree is sought for at the hands of this court. Okay. Yes, sir. D46 ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ 2 ಎಕರೆ ಬಗ್ಗೆ
D46 is dated 4/10/2005.
Correct.
This is the order under which conversion is
Conversion took
granted.
place.
Conversion is granted.
Correct.
Well, it is difficult to correlate this survey number 37, this extent of 1 acre 30 gutas plus 2 acres, 3 acres, 3.5 acres, 3 3/4 acres with the suit schedule item 1 which he claims here.
ಅಲ್ಲ ಇದು D46 comprises of 2 acres of land.
No, I'm reading like this. ಹರಕುಂಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 37 1 ಎಕರೆ 30 ಗುಂಟೆ ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಹಾಗೂ 10 ಗಂಟೆ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ 2 ಎಕರೆ
ಆಗೋಲ್ಲ ಒಟ್ಟು
but 2 acres. This 2 acres, it's how the one for how construction of the house ಅಂತ ಹೇಳ್ತಾರೆ.
Anyway, we are saying
Conversion, non-agricultural
only
purposes.
2 acres.
The extent is 2 acres. Extent is 2 acres. This extent we have to read in conjunction with Exhibit D45 at page 783.
Now we want to just have clarification. Whether the part of 37, that is 6 acres, 16 guntas or 18 guntas, is part of this land also 2 acres? Athwa bere no idu.
In survey number 37, there is no other extent. It can't.
Survey number 37 in all
9
plus acres. at
including Karab,
least. It will be more than 10.
10 acres.
Correct.
10 acres.
But now they are confining their claim to 6 acres, 16 guntas.
Whether
That 6 acres, 16 guntas
should have been
part of that is comprised in these 2 acres is our question.
No evidence. Part of that.
Stand in.
Sando, all that I'm saying is this, the concoction that is made by saying that Krishnappa, there are 3 sale deeds.
ನಮ್ಮ ಪ್ರಶ್ನೆಗೆ ನೇರವಾಗಿ ಒಂದು ಉತ್ತರ ಕೊಡಿ. ಮುಂದೆ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. Our question admits binary answers. Then you can build up your argument whichever way you want. We want to know, in the sense, whether Surana's land or part of Surana's land is comprised in 2 acres or it is independent land. What is your stand based upon the pleadings? Pleadings, ನಿಮ್ಮ argument in the pleadings ನಲ್ಲಿ ಏನು ಕೊಟ್ಟಿರಿ?
Suit schedule item is 37/1.
37/1. Let us see that for a moment.
Part 1. The evidence on record is that survey number 37 did not have any sub numbers as on 2/10/1925.
Sorry, 37. Suit only 37/1 ಅಲ್ಲ, it's only 37.
37.
ಏನಂತಾರೆ ಮಹಾಲಿ ಅವರು?
Well, the 37/1 is claiming the suit item is 37. Suit schedule property is described as 37. The extent is larger. Well, I am trying to point out only one point, one aspect there. The claim which he makes, the plaintiff makes a claim in respect of this survey number 37, the extent is also given, but what is converted and used for purpose of this development activities is mere 2 acres, and that comes from Exhibit D45 and D46. D45 is the tracing of
prayer ತೋರಿಸಿ. ನಿಮ್ಮ ಪ್ಲೇಂಟ್ ಪ್ರೇಯರ್ ತೋರಿಸಿ.
plaint.
Come to page 29.
And 29.
Entire land ಇಟ್ಕೊಂಡ್ರಿ.
Entire land. 37 acres. Suit item 37, measuring 10 acres, 10 guntas.
ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲೇ ಬರ್ಕೊಳ್ಳಿ. Mr. Shankar draws our attention to schedule A property at page 29 of the paper book 1, PB1, wherein the entire land at measuring 10 acres, 10 gunta and 10 guntas including 30 guntas kharab in survey number 37 is the subject matter of dispute. Entire land ಬಂದ್ಬಿಡ್ತದೆ.
Will kindly now permit me to take to page 22 and 23, paragraph 15 and 16.
Yes.
Defendants 4 and 5 who have purchased the two properties are trying to alter the nature of the properties when there is no division of properties amongst the family members. Defendants 1 and 2 are not entitled to alienate the properties in favor of the defendants 4 and 5. So also, defendants 4 and 5 or any other purchaser who purchased the property from defendants 1 and 2 will not get any right over the properties. Consequently, defendants 4 and 5 are not entitled to claim right over the properties purchased by them from defendants 1 and 2. Moreover, the properties situated alienated in favor of the defendants 4 and 5 are the joint family properties and the plaintiff is entitled for share in the same. I'll now read 16. First person ಬಂದ್ಬಿಡ್ತು. I submit now the defendants 4 and 5 are claiming rights in respect of the scheduled properties under the deeds executed by defendants 1 and 2. Defendants are not entitled to claim any right when once the scheduled properties are the joint family properties. Taking undue advantage of same, the defendants 4 and 5 are interfering with the possession of the scheduled properties. Further, defendants 4 and 5 are also tried to put up construction in the scheduled properties on 8/10/2004.
No. Next page also. Next para also.
No, I don't submission.
1 second. 1 ನಿಮಿಷ. ನಾನು ನೋಟ್ ಮಾಡ್ಕೋತೆ.
87 Supreme Court 1775.
The prayer for partition in respect of entire land in survey number 37 is structured on the basis of plaint averments at paragraphs 17, paragraphs 15, 16 and 17. First, in these paragraphs, joint family is pleaded and title of respondent, defendant numbers 1 and 2. Defendant numbers 1 and 2.
87 Supreme Court 1775.
Their transferee, namely defendant numbers 4 and 5, is also denied. Yes, sir.
ಎರಡು ವಾಲ್ಯೂಮ್ ಸಾಹೇಬ್ರಿಗೆ 1775. ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಿ.
ಏನು proposition ಹೇಳಿ. If we agree with your proposition, no proof is necessary.
Undivided interest in co-partnership can never be alienated. If it is alienated, it is void and there's no need to invoke section 31 of the specific relief act and claim relief of cancellation. 87 Supreme Court 1775.
No, that's correct. But provided,
not unknown to my lord.
What we are saying is provided you show that this is part of the family property.
That's exact. The attempt is that only. Suit schedule is 37.
Correct.
The conversion is 37. The conversion order with the D46 at page 789.
Exhibit D.
Yeah, D46.
D46.
45 is partition, same of 37. So in such situation, now I am trying to point out to the Honorable Court that undivided interest of the co-partnership
is not alienable.
Is not alienable, is alienated and they.
That's right. But show us that it is undivided. They are in agreement with the proposition. Establish that it's an undivided property.
But they say this is paragraph 15. They claim to have purchased the property
from D1 and D2.
Yes.
Correct. D1 and D2 have bought the property and they have produced the sale deeds now.
Admission, I think admission could have found the family partial admission. There are 3 places where admission is made.
To the
Nilibaria. I didn't expect this assistance or want of it. Kindly turn to page 119 of the first volume. Kindly put up.
Yes.
Cross-examination. I have studied up to 8th standard. I know reading and writing Kannada. It is further correct Krishna Reddy and Munswam Reddy are the sons of Chikka Chinna Reddy. It is not true to suggest that Chikka Chinna Reddy was also being called as Chinnappa Reddy. It is not true to suggest that Chikka Chinna Reddy was being called with 3 names, namely Chikka, Chinnanna, Chinnappa and Chinnappa Reddy. Then
Yardu evidence idu? DW cross. Who is he? D2.
No, it doesn't stop there. I think I'll.
ಅಲ್ಲ ಕೇಳ್ಬೇಕು ಹೂ ಅಂತ ನೋಡ್ಕೋಬೇಕು ಯಾರು ಹೇಳಿದ್ರಿ ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. D2.
Defendant number 2, his name ಅನ್ಕೊಂಡು
Krishna Reddy. Krishna Reddy.
If evidence commences at
08.
101 ಅಲ್ಲ ಎಂಡ್ ಆಗೋದು.
Krishna Reddy.
22/9/2025 Srinivas Reddy ಅಲ್ಲ?
Krishna Reddy.
M. Krishna Reddy. 108.
1.
His evidence commences at page 108. And I took your lordship to the admission made at page 119. It is correct, Krishna Reddy and Munswam Reddy are the sons of Chikka Chinna Reddy.
Yes.
It is not true to suggest that Chikka Chinna Reddy was also being called. So there is an admission from PW1 that how the evidence of DW1 is that it is not true to suggest that Chinna Reddy was also called by Chinna Reddy. It is not true to suggest that Chinna Reddy.
ಒಂದು ಸ್ವಲ್ಪ ಹಿಂದ್ಗಡೆ ಹೋಗಿ. It is correct.
Krishna Reddy, Munswam Reddy
My
are the
paternal
sons of
grandfather Chikka Chinna Reddy was already is my father and Krishna Reddy is my uncle. Correct. Page 119.
Yes.
There is admission.
So it is not true to say that Chikka Reddy was being called by 3 names. Chikka Chinna Reddy.
But he admits that these persons, his grandfather is Chikka Chinna Reddy. My uncle is Krishna Reddy.
Yes. The documents D7, 27 and 28 refer to different pseudonyms or anonyms. I do not know, it's not a name, it's a Uruf ಅಂತ ಹೇಳ್ತಾರೆ ಕನ್ನಡದಲ್ಲಿ. Alias name. Now, if there is that oath against oath in respect of the confusion regarding names, in such situation, what is the duty of the cross-examining counsel? What is the duty of the advocate who leads evidence? This has been explained by the Calcutta High Court, presided over P.B. Mukherjee. The name is he who later on became the Chief Justice. Yes, Chief Justice of India. The 61 Supreme, 61 Calcutta, page 359.
Citation copy ಕೊಡ್ತೀರಾ? ಇದೆಯಾ? Copies ಇದೆಯಾ?
We'll give one copy. 9.
P.B. Mukherjee was also Chief Justice.
Yeah, 61 Calcutta,
P.K. Mukherjee was
359.
Chief Justice.
Well, this P.B. Mukherjee and H.K. Bose.
For the proposition?
Proposition is the minimum minimum the cross-examining counsel has by way of a duty to the court and to the client is to put a suggestion of what his case is. I'm similar. I'm trying to, after citing this decision, we come back to that proposition. Or I will state it and that's so that your lordship could appreciate. Well, now there are two versions. One version is that he had three names. Excellent. We had three names, 108 names, Ashtotra. But what I'm pointing out to the Honorable Court by way of a defect in the evidence is this. There is no suggestion that those three names are the persons who have executed the sale deed. This is the foundation I'm laying. There is no suggestion. There is no suggestion from the cross-examining counsel that these three alias names are the very same persons who executed the document. This is missing, and that missing link is dealt with in two decisions, one Supreme Court, one Calcutta High Court. Calcutta High Court is 61, Supreme Court, Calcutta page 359. Please turn to paragraph 9 in this decision. Well, at 148, since Honorable Court is dealing with evidence, 138 is the right to cross-examine. The right to cross-examine has a consequence effect on the person who is tendering evidence. He does not enter the box and does abstain from cross-examination either wholly or in part. What is the law on the point? I'm asking myself a question. What is the law on the point? His evidence is to be struck off and it should be treated that he has no evidence. There are 7 decisions on the point. The inference is he who does not subject himself to the cross-examination is his evidence is to be treated as no evidence and is to be excluded from consideration. This is not doesn't come under section 138 of the Evidence Act. It is judge-made law.
No, that's all right.
Judge-made law.
D1 and D2, the evidence which you have read is of D2.
I'll help it. My lord's questions are sharper than what I have felt. So therefore, I'll keep myself in a position to receive that question after I make this statement. Well, failure to put the important and crucial part of the case to the witnesses coming to prove testimony capacity must be held to be against the respondent. It is all the more so because the case of the witness Venkatramaiah is that as early as in October 1956, he has told this story at Pune to Aratun and the learned counsel, Mr. Ganguly. If that was so, then there can be no doubt that this case would have been put to the doctors and nurses who are being examined and commissioned in Pune itself. It's also strange. Why then the respondent did not have the evidence of this witness, Venkatramaiah, immediately on commission at Pune, and why he has kept his sleeves to be played by as a last trump, as a last witness in the case, when the entire evidence in the case of the propounder had been made and concluded. Lastly, this course is Yale, all the more reprehensible here because witness Venkatramaiah admits that on all his visits to the testator's room in the nursing home, he found the wife present, question number 81. If that is so, then the wife who has put that case, she might have denied, but by keeping back this case from her, she has denied the necessary opportunity to do so. Then please turn to next second case, 2003, 1 SEC page 240. Page net madilla. Kindly turn to
Mr. Shankar.
Paragraph 10.
Yes, sir. What is that in the, up to this one you have?
I am drawing the inference that if the revenue entries show there are 2 versions there also. One is Gurappa Reddy, the other is Nanjun Reddy. Their father's name also differs. And the sale deeds are not produced. Secondly, I need my lord's kind attention. I need my lord's kind appraise.
No, I was processing what you were saying.
No,
I'm attentive only. I was processing in the light of what has been stated in the cross.
This crucial point alone would have the cutting edge effect.
Nimma proposition ಹೇಳ್ಬಿಡಿ ಬರ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ ಅವರು.
ಇದು ಓದ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ. Paragraph 10 ಓದಿ.
All right.
Paragraph 9 of the Supreme Court judgment. Undisputedly, Piara Singh and Mukhtiar Singh were taken towards the fields of Sahib Singh. Piara Singh was murdered in the fields and arm injuries were caused to Mukhtiar.
ಯಾವ judgment ಓದ್ತಾ ಇದೆ?
Then Millard, the line 4. Human behavior also run counter to such plea since it is observed.
ಯಾವ judgment? ಯಾವ judgment ನೀವು ಓದ್ತಾ ಇರೋದು?
2001 Supreme Court second, ಅದೊಂದು ನಮ್ಮ pagination ಮಾಡದೇ ಇದ್ರೆ how to tell?
55 Supreme Court,
2001 Supreme Court,
2001 Supreme Court.
which where the Calcutta decision is approved with India, paragraph 10, incidentally. ನಾವು ಅದನ್ನು ವಾಪಸ್ ಇಸ್ಕೊಂಡು paginate ಮಾಡ್ಕೊಡ್ತೀವಿ ನಂತರ.
2004, 12 ACC.
2003, volume 1, SCC page.
Sarwan Singh
Second ಅಂತ ಅವ್ರು ಹುಡುಕ್ಬೇಕಲ್ಲ.
ಸ್ವರಣ್ ಸಿಂಗ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಪಂಜಾಬ್.
Sarwan Singh
Para 9.
versus state of Punjab, para 10. Incidentally, in early 90s, terrorist activities were on peak in the border districts of Punjab, and it has practically been axiomatic truth in the area in question that no one could be in fact come out of the residential houses after dusk unless perforce at 3 o'clock in the morning. There exists no other evidence, nor even there being any suggestion of existence of any other factor for such perforce outing at 3 a.m. It's no, the law commences. It's a rule of essential justice that whenever the opponent has declined to avail himself of the opportunity to put his case in cross-examination, it must follow that the evidence tendered on that issue ought to be accepted. A decision of the Calcutta High Court lends support to the observation as above. See in this context so and so. That is the first decision I read. So what is the law declared? It's a rule of essential justice that whenever the opponent has declined to avail himself of the opportunity to put his case in cross-examination, it must follow that the evidence tendered on that issue ought to be accepted. So we have led evidence saying that they are not this assumption is made by the other side, saying that in the record of rights index of land, the 3 names appear. And that should have been a suggestion saying that those 3 names are the name of your father. That is missing. So therefore, that evidence which he is trying to bank upon is not available for consideration.
ನಿಮ್ಮ ಪ್ರಪೋಸಿಷನ್ ನಿಮ್ಮ ಫ್ಯಾಕ್ಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇಲ್ಲಿ ಹೇಳ್ಬಿಡಿ, ಬರ್ಕೊಂಡ್ಬಿಡ್ತಾರ ಅವ್ರು. ಬರ್ಕೊಳ್ಳೋಣ ಡಿಕ್ಟೇಷನ್ ತಗೋ.
Omission to avail the opportunity of cross-examination on the part of defendant, contesting defendant, that the 3 names shown are indicated in Exhibit D7 and D28, read with D79 and 80, is that of the father of the plaintiff, is fatal, and as a consequence, the court had to accept the evidence of plaintiff that they are not the sons of persons named above, and he has failed to prove that there was earlier partition or earlier alienation. As per law laid down by the High Court of Calcutta in AR 1961, Calcutta 359, which is endorsed with approval by Honorable Supreme Court in para 10 of the decision reported in 2003, 1 SCC 240.
Yes.
Now, to continue, the fact that there is no earlier partition, I am requesting my Lord's attention to 119, 120, which was being shown to your Lordships. My Lord was requested to notice the cross-examination by Mr. UBG of DW1 at page 119, and this reinforces my present submission made. I will read with the leave of the Honorable Court. It is correct.
My paternal.
It is correct, Krishna Reddy and Munswami. My Lord, I have my Lord's leave because the Honorable Court may kindly notice it. It is correct, Krishna Reddy and Munswami Reddy are the sons of Chikkachinna Reddy. It is not true to suggest that Chikkachinna Reddy has also been called as Chinnappa Reddy. It is not true to suggest that Chikka Chinna Reddy was being called with three names, namely Chikka Chinnanna, Chinnappa, Chinnappa Reddy. Then kindly come to the bottom 5 lines. It is correct. My paternal grandfather Chikka Chinna Reddy was already
My father.
my father and Krishna Reddy is my uncle. It is correct that plaintiff and defendant 3 are the sons of my uncle Krishna Reddy. Kindly come to paragraph 2, line 7. Line 6. I do not know whether my father, paternal grandfather, whether there was any partition between father and uncle. I have not produced any document to show that there was partition between my father and uncle. The whole case is built on the fact that there was a partition, and at that partition, my father, plaintiff's father, got his due share and he has sold. And those sale deeds are Exhibit D7 and D28.
Kindly come to para 2, page 120.
120. I cannot say the various landed properties my grandfather Chikka Chinna Reddy was possessing at the time of his death. It is correct that my father and uncle were having landed properties in their individual names. I do not know whether my father, paternal grandfather, whether there was any partition between the father and uncle. An admission.
No, he admits.
I have not produced any document to show that there was partition. Well, they admit that there was no partition in effect, and there is no document. Partition, if it is by deed, it has to be evidenced by a document. It's not a family arrangement. It's not a oral partition. It is a partition, and that is not admission. It is not there. Then will kindly permit me to read the last 5 lines. But I have not produced any document with us V and E scheduled property showed that they are all the self-acquired properties. This is admission. The defendant admits that he has not produced any document, any evidence to show that they are his self-acquisitions. Because the case of the defendant is that they are his self-acquisitions.
V and D.
Then my lord, to a suggestion put to this witness that the name of the father Chikka Chinna Reddy was Nanjun Reddy, this witness said that the father of Chinna Reddy was being called as Gureddy. The document D27 and 28 refer to this Nanjun Reddy. I think it's time, I may request my lord to kindly look at the document D27 and 28. They refer to the name as Nanjun Reddy.
Page number?
D27 and D28. Padipa. ಎಲ್ಲಿ ತಗೋದಿರಿ ತಕ್ಷಣ ತಗೋಬೇಕು. ಲೈನ್ 6 ಬೆಂಗಳೂರು ಹೋಬಳಿ ಹರಳಕುಂಟೆ ದಾಖಲೆ ಸಾಮಸಂದ್ರ ಪಾಳ್ಯ.
This is sale deed.
Beglur sir.
This is a sale deed.
D27. This is a typed copy D27A. My lord could refer it at D27 only.
Is it a sale deed?
Yes, sale deed. This is sale deed under which they claim title.
This is executed by whom? In whose favor?
Vendor. Yes.
Huh?
The case of what is the intrinsic value of this document is that my father had sold. My father is the vendor. That's the case made out.
Who is the vendor in this case?
Vendor in this case is
ಕೃಷ್ಣಪ್ಪನಾದನಾನು
ದಾಖಲೆ ಸಾಮಸಂದ್ರ ಪಾಳ್ಯದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಜಿರಾಯಿತು ಕೆಲಸ ಮಾಡುವ ಚಿನ್ನಣ್ಣನ ಮಗ ಸುಮಾರು 45 ವರ್ಷ ವಸುಳ್ಳ ಕೃಷ್ಣಪ್ಪನಾದನಾನು ಕೊಟ್ಟೆ.
Who is ಕೃಷ್ಣಪ್ಪ?
This Samsandra is a different village. I am not a resident of Samsandra. Correct? My instruction.
No problem.
Krishnappa,
No, this
ಕೆಲಸ ಮಾಡುವ ಚಿನ್ನಣ್ಣನ ಮಗ. This Chinnanna is not father.
No, what for you want to rely upon this document?
Well, there is confusion. There is uncleared evidence on the part of the defendant to say that this document would show that they have purchased property in this document. from our family. I mean, that is the case is, there was an earlier partition, this property had come to your share, you have sold your share. That is the case. And that is not believed by the court below. Now kindly look at this, my lord. The name of the father of Krishnappa, he is not Krishnappa in the first instance, he is Krishna Reddy. In a document, irrespective of the alias name I have, my name must come, alias it comes next. Here the name is Krishnappa, the father's name is Chinnappa Reddy, Chinnanna, it comes. Then, my lord, the next document. And my lord has noticed that it's only survey number 37. Please come to page 497. It is shown as 3702. Please turn to page 497.
This is 37/2.
37/2. The suit schedule property is 37. The document under which we have obtained is 37. And what is sold is 37/2.
DW1 in his chief, he says there are 4.
1 acre, 26 guntas.
Sold by Krishna Reddy. Krishnappa.
Now, my lord, I take the admission of the defendant.
DW1.
Admission of DW1.
Examination in chief.
ನೋಡೋಣ ನಾಳೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ.
ಇಲ್ಲ ಇದೊಂದು ಮುಗಿಸ್ಬಿಡ್ತೀರಿ, ಫ್ರೆಶ್ ಪೇಜ್, ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 113. Paragraph 9.
113.
Page 113. I think volume 1. Paragraph 9. Deposition. This is not the property mentioned in schedule. Same belongs. My lord would notice 9th line. It would commence with the word there were 4 persons by name Chinnanna in our village. Or as the same name of Chinnanna was shown in the RTC.
Page 113.
Page 113.
Paragraph 9. 113, para 9.
Para 9.
Middle of the paragraph.
Middle paragraph. There were 4 persons by name Chinnanna.
4 persons by name Chinnanna in our
ಇದು
village.
ಯಾರು ಏನ್ ಹೇಳಿದ್ದು, ಯಾರು ಮಾತಾಡ್ತಾರೆ?
DW1 in his chief.
Evidence of DW1. There were 4 persons by name Chinnanna in our village. As the name of Chinnanna was shown in the RTC in respect to scheduled property, plaintiff took undue advantage of the same and filed this suit filing claims of the property as if the same belonged to said Chinnanna without impeding the persons who are interested. Not my case, their case. From Mulubagal to Tirupati, everybody is Govinda.
Yes.
Then kindly come to, my lord would permit me to continue. ಇದೊಂದು this on the page 114. Line 4. If this honorable court comes to the conclusion that there is joint family and the properties included in the scheduled properties are the joint families, by excluding the lands in survey number 3703, 3701, our respective shares may be allotted and the said properties may be allotted to us. 3703, 3701 ಯಾವುದು ಇಲ್ಲ, suit schedule ಅಲ್ಲ. Then next paragraph. I submit that the plaintiff and the third defendant without any manner of right, title and interest over the settled land 3703, 3701 illegally made attempts to interfere with our possession and enjoyment of the same. So
During the lifetime of my brother.
Now the defendant is making out a case that there are other properties which bear the number 3701, 3703, 3702 ಹೇಳಿಲ್ಲ, 3702 ಹೇಳಿದ್ದಾರೆ, ಒಂದು ನೋಡಲ್ಲ ಅದು. So the 3 sub numbers they give. This is only because there are 4 Chinnannas and our ಮಕ್ಕಳು ಬೇರೆ. And I am
Kindly come to page para 11. Page 114.
I submit that the plaintiff and the third defendant without any manner of right, title and interest over the lands in survey number 3703 and 3701 illegally made attempts to.
They have obtained a decree. against you.
Not in respect of 37/1, it
No,
is.
37.
My lord, let me just clarify that. That decree is a ex
Ex
parte
parte.
injunction decree.
Correct.
And in this itself, my lord, I will be able to show, my lord, that they've given our address, some other address.
ನಮ್ಮ address ಕೊಟ್ಟಿಲ್ಲ, ಬೇರೆ ಎಲ್ಲೋ.
But you have not vacated the decree.
No, that, my lord, I don't think has happened.
A decree once passed.
That's an injunction decree.
Correct.
ಇಲ್ಲ ಜಸ್ಟಿಸ್ ಸಭಾಯತರ ಡಿಸಿಷನ್ ಇದೆ ತಮಗೆ. If a decree is obtained by giving a wrong address at a silk merchant case and the order 5 rule 20 they resort. Mr. Shekhar Shetty was the advocate for the plaintiff and it was inferred by the court to say that that decree is not binding on him because it is obtained at a wrong address. It's a wrong address, wrong property, both. I think this is the humble beginning we have made and will continue to.
Yes.
Well, it would be on this essential point that D27 and 28, 79 and 81 have nothing to do with the suit properties. The vendors there are totally different and the plaintiffs are different. That's our primary case.
37/3 and 37/1.
37 is divided into 1, 2, 3, 4 and 5, 7. Those numbers are allotted. Thereafter, at some point of time, this, I will place
And
the
in
record.
2005, they obtained it for 37, not 37. Well, this is a case where they are Nindu Nande, Nandu Nande. That's the principle.
Tomorrow. Day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Namdu.
Further hearing. ಏನಿದೆ?
ನಾಳೆ ಇಲ್ಲ ಅಂತ. Can it be one day after that, please?
So, ಅಲ್ಲಿ 6th, 7th.
Lord, may I request for one day after that, Lord? Day after, Lord, I am in Delhi tomorrow.
8th.
Yes. One leg in Dharwad, the other leg is in Karnataka, Bangalore.
8th. 8th ಮಧ್ಯಾಹ್ನ.
Yes.
ಯಾವತ್ತಾಗ್ತದೆ?
Friday. 8th ಮಧ್ಯಾಹ್ನ.
ಫ್ರೈಡೆ ನಮ್ ಸಿಂಗಲ್ ಬೇರೆ ಬೆಂಚ್ ಎಲ್ಲ ಇರ್ತದೆ. 7th ಹಾಕೋಣ.
7th is
ಮಧ್ಯಾಹ್ನ.
ನಾಡಿದ್ದು Thursday, Lord, that is
ನಿಮ್ಮ ಕಲೀಗ್ಸ್ ಅನ್ನ ಇಡಿ. ಸುರನ, ನಿಮ್ ಕಲೀಗ್ಸ್ ಇಡಿ, ಬಂದ್ ಜಾಯ್ನ್ ಆಗಿ.
Lord, then I
Anyway, ಅವ್ರು ಮುಗಿಸ್ಬೇಕಲ್ಲ.
Then I will have to be appearing online, Lord. I am in Delhi on 7th.
On that day.
Yes.
But yet we are not sitting in this combination. All right, you come online only. No issue. No issue.
8th morning.
ಮಾರ್ನಿಂಗ್ ಆಗಲ್ಲ. ನಾನು ಬಹಳ ಮ್ಯಾಟರ್ಸ್
ಆನ್ಲೈನ್ ಮಾಡಿ ನಿಮ್ದು.
ಸರ್ ಅದು
Your Lordship could please record. It's a request, humble request. The instructing advocate has filed an objections to it without even requesting the honorable court to grant leave. Kindly condone his mistake and accept, take it on record.
That now, that is on 4/11/2024, the objections are filed to
The application, IA3.
appellant in IA number 1 of 2023, filed under order 41, rule 27. First, the said application was filed now.
Today.
23.
23.
Date have it.
17.
1 of 23 and
11th.
The said application was filed in the court on 11th January 2023.
It's on 7th. No, no.
Therefore, whether the objections filed belatedly can be taken note of.
I will make.
Let him file the application for condonation of delay.
Application ಹಾಕಿನಿ. Permission.
Condonation of delay. ಅದು ಹಾಕಿದೆ. Application for condonation delay also it's filed.
ಅಲ್ಲ, objection ಗೆ you have to file objection within such and such period ಅಂತಿದೆ. ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟರಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಂಡೋನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅಂತ ಒಂದು ರೂಲಿಂಗ್ ತೋರಿಸಿ, ಯಾವ್ದಾರ ರೂಲ್ ತೋರಿಸಿ ನೋಡೋಣ, ಎಂಟರ್ಟೈನ್ ಮಾಡೋಣ. Mr. Shankar submits that another application seeking condonation of delay in filing the objection is also filed.
Cross objection.
ಯಾವ್ದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ ಇದಾಕಿ ಯಾವ್ದಕ್ಕೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್
ಅಲ್ಲಲ್ಲ, ಈ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವರ
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ ಅದಕ್ಕೆ ಕಂಡಮೇಷನ್ ಡಿಲೇ
ಡಿಲೇ ಆಗಿರೋದಕ್ಕೆ
ಅದಕ್ಕೇನ್ ಟೈಮ್ ಇಲ್ಲ ಇವ್ರೆ
ಟೈಮ್ ಬೇಕಾಗಿಲ್ಲ, ಅಪೀಲ್ ಅಲ್ಲ, ಬೇಕಿಲ್ಲ.
ಅಲ್ಲ ಅವರು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ಕೊಂಡ್ರು
ಕಾಸ್ ಎಕ್ಸಾಮ್ಸ್ ಎಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ಗೆ ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ಗೆ ಅವ್ರು ಅನ್ಕೊಂಡಿದ್ದು ಅಪ್ಲಿಕೇಶನ್ಗೆ
ಇಲ್ಲ
permission, permit him to file, recall the order and permit him to file the objections ಅಂತ ಹೇಳಿ. Not filed ಅಂತ ಮಾಡೋದು. ಹೌದಾ? ಹಾಗಾದ್ರೆ ಬೇಕಿಲ್ಲ application. ಅದೇ ವಾಪಸ್
ಸರ್ ಅದರಲ್ಲಿ ಅವತ್ತು ನಾಟ್ ಫೈಲ್ಡ್ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಪರ್ಮಿಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು. ಹಾಗಾದ್ರೆ ಬೇಕೇ ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್.
ಏಯ್ಟು ಅದು ಶುಕ್ರವಾರ ನಿಮ್ದೇ ಅಲ್ವಾ?